2023. I want to welcome all the members here at M46 and on the virtual platform. Honorable Hendricks, can you hear us? Honorable Hendricks, can you hear us? Honorable Nyatso, can you hear us?
Yes, I can. Sorry, Chair, I can hear you.
Yes,
Thank you, Honorable.
yes, Chair, we can hear you loud and clear.
Thank you. That's helpful. Honorable Jafta, can you hear us?
Yes, Chair, I can hear you.
Okay, thank you. I want to welcome all of you, honorable members on the virtual platform, now that we're connected with you, to welcome the public protector, as well as the legal team of the public protector led by Advocate Mpofu, to welcome the evidence leaders, Advocates Awa and Mayosi, welcome members of the media with us, the entire support staff, as well as the members of the public who are rejoining us again to be part of the proceedings. Thank you. Welcome again, Ms. Sokoni. We continue with you. And now on, without wasting any time, I'm going to take this time and ask Advocate Mpofu to continue with you as indicated until tea time. Advocate Mpofu, over to you.
Thank you, Chair. So there's a note that I'm missing. So if I don't, I'll try and find it while we're going.
No problem. Just sort yourself out.
Yes, I'll try to do it. If I can't, I'll ask for 5 minutes. It's the appropriate time. Thank you, Chair. Good morning, everyone. Good morning, Honorable Sokoni.
Morning.
Yes. Yes, yesterday, I think we stopped around the time when we were talking about the 2020 UN General Assembly resolution, which, as I said, was the culmination of a series of such resolutions dating back to 1993, which dealt with the institution of Ombudsman. I'm not going to take you through those various UN resolutions. There are quite many. You've mentioned them on page 1 and 2 of your statement. But just collectively, you would agree that they all map out a journey towards the internationalization or globalization of the work of the office. And the last one that I mentioned, which is 2020 December, specifically incorporates the Venice principles that you and I went through in some detail yesterday, correct?
Correct.
Right. Now, I just want to isolate a few of the, I won't go into as much detail as I did with the Venice principles, but using the OR Tambo Declaration, I'll just, again, it's a similar exercise as we did yesterday. So the back of your mind is, I'll just isolate some of the principles. I might not refer them directly to what's happening here in this committee, because you might have missed some of the evidence. But when I do the argument for the members, I'll be able to demonstrate what conclusions I seek them to make as to whether or not South Africa is compliant with such instruments. You understand?
Yes.
All right. Now, if we can then immediately go to what we might call the African version of the instruments, as endorsed by IOMA. By the way, who is the president of IOMA?
The president of IOMA is the Ombudsman of South Africa, Public Protector, South Africa.
Yes. And we established yesterday that the signatory to the Tambo Declaration is her predecessor, Advocate Matansela.
Yes, that is correct.
Right. So can we then go to that document? We were at page 268. We had dealt with the most important standards, obviously, independence and autonomy. And I think that's what led us to all the other instruments. So if we can just then go back. Yes, we dealt 1.1 is the one that really permeates all the documents, independence, autonomy, and I think we went to town as to what the requirements of those two principles entail. So I want us to quickly then go through the remainder, and I won't read all of them. I'll just jump some of them. I'll read those that are relevant to what I will argue at the end of the case. All right. It's 1.2 says the institution should not be subject to the direction or control of any person or authority in the discharge of its duties. And I think you and I agreed that that is a restatement of the principle of functional autonomy.
That is correct.
Right. As it is also captured in our constitution. All right. Then at 1.3, it says the discharge of the Ombudsman mediator's function is subject to nothing but the law and commands and of his and her conscience. Again, I would, subject to your agreement, say that that's an expression of the wide powers that should typically be granted to those offices, correct?
That is correct.
And then here's an important one, which relates to something we discussed yesterday as well, wrapping up. And this also shows as to whether our system complies with even the African instruments, let alone the other international instruments. It says the Ombudsman, I'll say the public protector, shall be immune from being sued or prosecuted in his or her personal capacity. And you described why that is important in respect of independence and protection from reprisals.
That is correct.
And so what happens to a country like ours, which clearly does not conform with even the Tambo Declaration? What methods do we use at local, or let's say at continental level, maybe to persuade or to popularize these principles? Because in the heading, they are described as minimum principles. To me, that means, you know, this is the barest minimum that you should comply with to be a compliant public protector, isn't it?
That is correct.
So, okay, I mean, apart from trying to have these principles adopted at the level of AU, because then obviously then compliance would be driven at that level. Is there anything at the organizational level that you do to, when you see that a country does not comply with some of this?
Yes, at the organizational level, our level, when we are made aware of the fact that an ombudsman office is under threat, we do engage the governments and try to find ways and means in which we can help that government to ensure that the office of the Ombudsman is allowed to function as it should. In the past, we had intervened in Malawi, and we had also intervened, I think, my memory bears me right, one of the West African countries, we had intervened to assist an ombudsman's office that was under threat.
Okay, good. And well, something as serious as a public protector or rather a country that clearly does not confirm with the functional immunity and of either suing, and in this generically I include the issue of personal costs because it's the same effect really, paying of civil-based financial or rather monetary punishment, or which is worse, immunity from prosecution. I told you yesterday that our public protector is actually facing prosecution right now for the CX case. Is that the kind of thing that you take up both at organizational level and at country to organization level?
Yes, exactly. That is the reason why we're even here in these proceedings. We had actually requested that we should be given a platform. And we thank you for that. Thank you to this committee as well.
I couldn't hear you. You just went low.
Oh, my apologies. I said this is the reason why the African Ombudsman and Mediators Association is here at this August hearing. And we would like to thank you for having given us this opportunity to be able to address this matter before this honorable committee.
Okay. Thank you. So by that, you mean that well, I suppose, I don't know how it's done in diplomatic circles here, but is there a formal way in which you can pass the message or through the chair to South Africa on those shows I found? Oh, chair, I found my notes. I'm sorry.
I did not understand the question.
No, I was saying, apart from doing it through the chair and the committee, as you are doing now, is there a formal way in which you can communicate those areas of non-compliance to South Africa?
We are able to engage with the government directly. But however, we believe that this opportunity that we have been given also allows us to address the government directly, and we trust that it will start a process of discussion and engagement as well, not only here in South Africa, but in other countries as well.
Yes. All right. Then, if we then go to the next page, 269, Tsepo. One of your minimum standards is that I'm reading 3.3. The process of removal shall be on the basis of a just cause and shall be fair, transparent, and regulated by the Constitution, and preferably involve an independent body. That's one of your minimum standards.
That is correct.
Yeah. All right. Well, as far as fairness is concerned, you and I covered some of the issues, for example, issues of conflict of interest and so on, which clearly undermine the fairness of the process. But I want to talk about another aspect of fairness. If a process in a country could be shown to refrain, or let's say where there's a refusal to call essential witnesses or relevant witnesses or witnesses that are specifically mentioned in the charges, thereby depriving the accused person, quote unquote, of an opportunity to absolve themselves. Would that be fair?
Repeat the question, please.
If a process in a particular country involved the refusal to call essential witnesses or relevant witnesses that are specifically mentioned in charges, thereby denying the accused person an opportunity to clear their names, would that be in conformity with 3.3, standard 3.3?
It would not be in conformity with the fundamental principles of natural justice, because that is our ultimate tool that we use as ombudsman officers. So a person's right to be properly, firstly, to be properly represented, secondly, to be able to properly defend themselves, should be respected and upheld in any constitutional democracy.
Okay.
Yes.
And well, if it goes even further, and in a process where an ombudsman is in jeopardy of losing her job and position, and in that country, then there's a refusal to even call the complainant, the person who actually started the whole thing, to clarify what they had in mind and all the issues that you and I have traversed for the past hours. Could that be fair?
The complainant in any case is the one who brings the case before any court or any tribunal, and that is where the whole gist of the matter is based. So the complainant has to come forward and say, "This is my case." Otherwise, there's no case at all.
Thank you. Thank you. And but more importantly for your purposes, if there was a direct refusal to call the complainant, would that be in compliance with minimum standard 3.3?
If there was a direct?
If there was a direct refusal to call such a complainant in a particular country, would that be in compliance with regulation 3.3, or rather minimum standard 3.3?
No, that would not be in compliance.
Okay, then let's go to 4.2. Minimum standard 4.2 says the term maladministration should be given a broad interpretation as possible, or rather, yeah, I suppose it should say as broad an interpretation as possible, covering all public offices, institutions executing public functions, and institutions or individuals administering public funds. Now, this one is a statement, again, it goes to how wide, and I think our own court in EFF versus Nkandla, or rather in the Nkandla case, also known as EFF versus the speaker, spoke of very wide powers. So am I correct that this is also an expression of the width of the mandate?
Yes, definitely, that is so. It's very, very difficult to restrict the term maladministration I've often said that the categories of maladministration are never closed.
Yes.
Because really sometimes it's really personal how a person has been treated, because maladministration includes issues like rudeness, discourteousness, and depending on the type of industry that you are dealing with, the specific institution that you are dealing with, the concept of maladministration may change. So that is why the Ombudsman is granted such wide discretion to investigate public service institutions to ensure proper, efficient, and effective service delivery to the people.
No, thank you. Yes, no, that's true. That's my favorite standard in Section 6 is that one of rudeness, because I think it shows how wide the mandate is. Now, so in other words, if a public official just doesn't greet you when you greet them, you could report them to the public protector, theoretically, correct?
Theoretically.
Yes. Yeah. However, one of the issues on a more serious note in South Africa is that even the courts have tended to trying to put this nicely, to restrict the deliberately wide mandate of the public protector. Yesterday we spoke about the 2-year limit issue and how it has been interpreted by our courts as if it was a prescription provision, and we clarified that that is not what it's supposed to be. But let me just give you another example. We have one of the cases that feature in this matter. We have a person who was the deputy president of the country and going towards a conference to make him the president, to cut a long story short. And it turns out that he received anything between 300 million and R1 billion from unknown sources. But the courts interpreted that to say no, even though the person holds those positions, that those billions or those hundreds of millions were given to him as a person.
Chair.
Just suppose Advocate Mbofu.
Chair,
Advocate Bauer.
Chair, I'm going to object to the characterization of what Advocate Mbofu was putting, because he must either stick to what the case was about and phrase it in a manner where the court says who the money went to and what the money went to, because he must tell us what he's talking about.
Advocate Mbofu.
Yeah, okay, just answer. That's what I'm doing. I'm telling you what the case was about. I'm saying the case was about a person who is a deputy president of the country. Which part of that don't you understand?
If you're referring to the Busasa CR17 case, Advocate Mbofu, then say so.
No, I don't want to say so. I'm just giving an example of a situation, because the idea is not to discuss a particular case. It's just to get a concept.
That's fine.
Yeah. Thank you, Chair.
But Chair, for purposes of cross-examination, Advocate Mbofu is saying we have a case and he puts certain facts to the witness, which in our view is not necessarily and hasn't always been in sync with the case.
Can you agree that at this point, he's putting forward general points?
Yes.
We're not getting into specifics.
Thank you, Chair.
And hence I would protect that I don't find an issue if a name is not mentioned.
Yes.
Can we leave at that at this point?
Thank you, Chair.
Okay.
Yes, and I'm deliberately leaving out the names. And if Ms. Bauer, when we argue the case, if I've put the question in such a way that it doesn't elicit what I need, she should be happy, because then she can say that it was just a non-question. Yeah, if a person who holds the position of deputy president and is involved in a process which is intended to elevate him to the presidency itself, and in that process receives hundreds of millions of of whatever currency. The public protector then does an investigation and finds that there was something wrong with that in terms of the conflict and non-disclosure laws and all that. And I'm dealing here with a specific issue about how wide the mandate is. So I'm not really so much dealing with the merits of that case. I'm saying that in those situations, would it be in your understanding of the prescripts, both the international and continental prescripts, would that be in conformity with the very wide mandate to then say, no, even though we all know that this was done in the context that I've described, but the money was received by the person as another entity, like as a private person, and therefore the public protector must be barred from investigating such a, would that be in the spirit of the wide mandate of the public protector?
I'm not very familiar with the facts of the case,
No,
but okay, what I would say is that if that person is a public officer and falls within the mandate of the enabling legislation for the ombudsman to operate, then there should be no reason. There's no public officer who is exempt unless it is, for example, without jurisdiction. You may not investigate the judiciary or the legislature. So if it goes that far, then then the ombudsman cannot. But if it is within the mandate of that ombudsman, I don't see the reason why they should be blocked from investigating the matter. But I will go further to say the situation that you have actually referred to, if it was under my jurisdiction, I would pass it on to the Anti-Corruption Commission.
Yes.
Yes, so this is what we have been saying, the problem of multiple mandates.
Yes.
Where the ombudsman has got these multiple mandates, and then the difference between maladministration and other areas becomes mired.
Yes, no, that's correct. Actually, incidentally, it's interesting that you should say that without being familiar with the facts. That's exactly what the public protector sought to do, to refer it to the anti-corruption bodies. But thanks, you've answered my question as far as the it relates to the OR Tambo principles. Yeah. And well, just out of interest, that happened in a particular court setting or division of the courts. But when the tables were turned and that same person was now charged as a person, the court then said, well, now he should be here as a president. So I don't have to bore you with that, but that's what we have to deal with here. If we then go to number 7, so that's the next page, yeah. Okay, conditions of service, we spoke about that yesterday exhaustively, so I'll jump that. Right, okay. So those were just the things that I needed to clean up on the OR Tambo principles. Thank you, Chair. All right, can we then move to reprisals we've dealt with, rudeness we've just dealt with now. All right, let's then go to the speech. Page 331.
Statement or speech?
331. The speech of Honorable Sokoni to on the 21st September 2021. It's the one that was filed twice by us and by Ms. Bauer.
But Dali, we're struggling to find it. Can you just be specific? Which item exactly? 3?
I don't know. It's 331 on the big page on the same series that were.
Bundle H.
Yeah.
But which item?
Your team uploaded it via item numbers. Could they maybe assist you to tell you which item number it is?
Yesterday, which is 51. I'll get to the item now. It's yeah, it's bundle H item 31. And yeah, and this page 331.
There's 15 sub numbers in bundle 31. Can you tell us what it's called?
Okay, why were we able to find these page numbers yesterday, the whole day? It's page 331 of the same series we were using yesterday. If I just said page 269, for example, for the OR Tambo principles. So it's 331, just 30 pages after that.
It's called OR Tambo, that's why you can find it. But if it's not, if you're not referring to it by a name, then she can't find it.
12 item.
Tsepo, I'm told it's item 12. Thank you. Right. Okay. Just move it up or down or whatever. Let's see more of it. Yeah. All right. That is a speech that you delivered. I'm just trying to move fast because of time so that we cover this. That's a speech you delivered on the 21st of September 2021. It's headed a paper presented during a facilitated discussion of AOC and AOMA by Her Excellency Mrs. Caroline Zulu-Sokoni, Public Protector of the Republic of Zambia. I'll take you through some of the key propositions that we make there, which are relevant to the discussions we had yesterday. So I won't dwell much, but I'll just highlight those sections. And if you care to comment, I'll ask you to. All right, can we go to paragraph 2, or rather the next page? Yeah, the second paragraph is not numbered. Yeah. Okay, further down. Okay, that paragraph makes the link that you were just making now between maladministration and corruption. Because as we said, maladministration is such an elastic concept in this field that, as I said, it starts from such things as not greeting to like corruption, probably involving hundreds and millions of rands or dollars or whatever.
That is correct.
Yeah. Okay. And you make the point in the middle of that paragraph that maladministration may be termed petty corruption simply because of some of the activities such as discourtesy, to give just one example, have negligible effects on the government's resources. However, in terms of the law, maladministration is as much an offense as corruption, and more so because it creates obstacles to equal access of services and benefits of these services to all. And I'm linking this to the quest really in all the instruments to say either, and by the way, I want you to comment on the, I think it's a statement from your affidavit or the annexure there too, about the need either to move away from the so-called classical model where the public protector has mandate is confined to maladministration on the one hand, or, which is what you and I are discussing now, to define maladministration as widely as possible. Is that generally the trend?
Generally, yes, well, it's not most, the countries which have multiple mandates really are in the minority, but the trend is that is that of embracing the broadening of the definition of maladministration.
Yes, and just referring that to where we started about the United Nations, and I want you to correct me if I'm wrong on this. That trend of widening the scope of operation of ombudsman has gone so far to the extent that the office of the ombudsman, I mean, in general terms, has now been welcomed, quote unquote, into the UN human rights institutions family.
Yes, in actual fact, in Europe, most of the ombudsman officers have got the single mandate of investigating human rights. Yes.
Okay, good. All right, then let's move on to some of the highlights of your speech here. Okay, on page 333, you make the point about conditions of services being similar to those of the judiciary. We discussed that yesterday, so let's jump that. But more importantly, again, to relate it to our situation, you say in the second paragraph, further down, the position of ombudsman has therefore been equated to that of a high-ranking judicial office or of a judge, with all the accompanying powers of the office except the power to make binding decisions. The position has also been vested with the conditions of service and remuneration of a judge. And I think you and I agreed that that would mean then generally that, for example, the suspension of a public protector should follow the same steps as the suspension of a judge.
Yes, exactly.
Thank you. Okay. And it also means that, as we demonstrated yesterday, at least from a constitutional drafter's point of view, the constitutional protections afforded of a judge to a judge are identical to those afforded to the ombudsman, correct?
Correct.
Right. Except, of course, for example, that a judge has security of tenure for life, whereas we've agreed that in the case of a public protector, it might be limited.
Yes, definitely. Well, the judges have security of tenure for life. However, for the public protector, it's supposed to be for a term certain. So the ombudsman could have the same terms and conditions of service as a judge, but upon retirement, they would then maybe have some gratuity or something, some package given to them.
Yes.
Yeah.
Yes. Well, exactly. Well, some elements in this country look at that as if it's just a gift, a birthday present. It's as much misunderstood as the payment of charges for life. There are people who think that that's just, extravagance or largesse, and are not able to link it to the issue of independence. And you can confirm, I'm sure, that as someone who has even been nominated to be a judge, that the reason why judges are paid for life is not for fun. It's
No.
is actually a very serious matter of ensuring their independence. It's
Yes.
actually to protect the public.
Yes, exactly.
All right. Then you discuss okay. You then deal with the comparison with the case of Indeni, which we discussed yesterday, where your court, in my respectful submission, wrongly relied on our case of Minister of Home Affairs versus the Public Protector, basically to say that the powers were not binding, even though your constitution, unlike ours, specifically says that the powers are binding.
Yes, that is the reason why that case was so unique, and I had to mention it that
Yeah.
in the Zambian constitution, the public protector is imbued with the powers to make binding decisions. But however, based on the judgment of the South African courts, where they stated that the binding powers of the remedial action reports of the public protector were not absolute, so they based their own judgment as well on that very judgment. But for me, it was something strange because here in South Africa, the public protector was imbued with binding powers by courts. It's not stated blandly in the Constitution. So this is the reason why I made that comparative analysis of the two cases.
Okay. And maybe in fairness to your court, then the issue, or rather, you know the case better than me because you were a party to it. I would say that if you compare it with our situation, if the court, rather, if the issue was the reviewability as such, as opposed to the binding or non-binding nature, then obviously your case, your court's constitutional court would be in conformity with ours, in that in our situation, irrespective of the binding or non-binding debate, it's always been understood that the decisions are reviewable.
Maybe what I could just add as well is that the fact that the institution of the Ombudsman is only encouraged to make recommendations, it also protects the courts from making conflicted decisions. So it protects the Ombudsman from being placed in a situation of a compromised position. And it also protects the courts. They don't have to go backwards to try to protect anybody just because there is some sort of influence, external influence to say, no, this such a decision would not be becoming for a member of the executive.
Yes.
So.
Thank you. And then in your speech, you make quite interesting and detailed analysis of some of the cases that you say are relevant to the some of the South African cases that you say are relevant to your topic, but also to the what I've called the central thesis really of your evidence, which you've just mentioned about the recommendation versus binding nature. And at 336, you deal with the case that, for all intents and purposes, was a turning point in South Africa, and as I understand it from what you're saying, also in Zambia, which is economic freedom fighters versus the Speaker of the National Assembly, to us known as the Nkandla case. starts with similarly. Yeah, that's. You see there, you refer to the Nkandla case.
Correct.
And yeah, and you observe there that that case was a turning point in the manner that I've described. But in the previous paragraph, just the last sentence, sorry, please just go back a bit. Yeah, you make the observation that the institution, because of this, now must budget for litigation costs as a matter of priority. Would you agree that that's one of well, let's assume unintended consequences of having the binding model? Is that then the cost of litigation automatically shoot up, because obviously people are more likely to challenge decisions that are binding than those that are recommendations.
That is correct. Although I must confess, within the office now, you know, we have actually raised our standards very high, because whatever evidence we get, we interrogate each and every piece of evidence thoroughly, because, you know, we know that when this report comes out, you know, there's a possibility that it might be taken to court. So it has made us a little bit more cautious. It takes us a little bit longer now to issue a report, because we have to really do our due diligence and really interrogate our cases so thoroughly.
Yes, and in a way, you get what in English is called the short end of the stick, because your decisions are as binding as those of judges, but judges don't get reviewed, and you do.
That is correct.
And as we established yesterday, a judge can have all sorts of scathing remarks made about them in a higher court, but nobody's going to say they must come here and be impeached.
That is correct.
All right. Then you refer to another case that's relevant to this inquiry directly, which is the Reserve Bank of South Africa, or Public Protector versus South African Reserve Bank, otherwise known as the CX case. That, yes, you summarize the facts of that case at page 337. And you point out that that report was issued after the Nkandla judgment, and that's quite important, because again, the reason why there was the hullabaloo was because of the binding nature of the decision. Yeah, and this is an example of what you and I spoke about regarding this so-called elevation of Audi, or the refusal of Audi into bias. You quote there from the minority judgment of Chief Justice Mogoeng, and this was the sharp distinction between the two judgments, is that Chief Justice Mogoeng was not necessarily uncritical of some of the things the public protector was accused of, but his point was that, well, to err is human. I think those are the words that he actually uses, and therefore that should not be a basis for mulcting the person with personal costs and all sorts of things. And you indicated yesterday that yourself, you associate yourself with the minority judgment, the approach taken in the minority judgment of the Chief Justice. Am I right?
As I stated before, of course, being an ombudsman, I would think that the ombudsperson must be given the necessary protection that companies doing the sort of sensitive work that they do, that is that of investigating the executive. So having personal costs being occasioned by the ombudsman, asking the ombudsperson to pay the costs of a respondent institution means that the respondent institution has gone round through the back door and managed to punish the ombudsperson for making a finding against them. So it should be directed at the institution, not at the person, because we are all human, you know. We do make mistakes in our jobs, but if at each and every turn that we make mistakes in our job, if a doctor is operating somebody and that person dies on the operating table, and then the relatives take the hospital to court, and then the court says, no, the doctor has to pay in his personal capacity, you know. I mean, how many professionals would be able to do their job?
Yeah.
So basically.
Thank you. And I think Justice Mogoeng makes that point, that it would have such a chilling effect that, quite frankly, and these are my words, nobody would ever want to be a public protector, because he says it should be just to bankrupt the person, basically. Because if you accept that the people that you investigate are normally the powerful in society, whether they are members of the executive, if they are members of the executive, it's even worse, because sometimes they even use state resources to fight you, or there might be big banks or whatever, people with deep pockets, and therefore it would be likely to bankrupt a normal human being if you have to pay costs for those types of institutions.
Yes.
And I think the gist of what you are saying is that paragraph 46 of that judgment, which you'll find at bundle C, item 3, and number 17. No, this is currently. Number 37, yeah, bundle C, item 3, number 37. Paragraph 46. I'll just read it to save time in the meantime, but it will be put up. He says, all this was for a good reason. He says that's why personal costs against public officials is what you call a rarity. Public office bearers must be allowed the space to be human. I think that's one of the most profound statements, which, if not neglected, would have probably made sure that we're not sitting here today. It says, public office bearers must be allowed the space to be human, and to err is human. It ought to take much more than ignorance, limited competence in one's area of responsibility, poor judgment, or incidental but harmless unfairness to others to order personal costs against an office bearer litigating in a representative capacity. And does that capture more or less what you are saying about the inequities of this practice?
Yes, that is correct.
All right. Now, we will have debates, no doubt, between us and the evidence leaders and others who are that way inclined towards the other issues raised about recommendations for constitutional amendments and so on. I'm just raising these issues now in the narrow space of independence, autonomy, unfairness, and cruel punishment. towards a public protector. Now, Chair, if I may, then move to the other case that we touched on, which you referred to in the context of the wide mandate as to whether the public protector should have access to tax records and so on. You remember that case we spoke about? That's Public Protector versus Commissioner for South African Revenue Services.
Versus Commissioner.
Of South African Revenue Services.
Yes, yes, I recall.
Now, I want to deal with that case, but not what we discussed yesterday. A separate issue now related to what we're discussing now. And okay, that one, Tsepo, is at panel C, item 3, number 17.
Just for the record, Mr. Advocate Mpofu yesterday talked about this case at the level of generalities in respect of the subpoena. To my recollection, he didn't refer specifically to the case, or the witness didn't refer specifically to the case. Advocate Mpofu put the issue of whether subpoena should be issued by the public protector against personal information and whether she should be entitled to it. I just want to say that the witness did not testify specifically to this case yesterday.
No, that's not true. The witness spoke specifically about this case. She even said that she was surprised that she even pointed something in the case that I had forgotten myself. She said that in the case, the court had said that the public protector had other alternative ways, including approaching Mr. Zuma for the documents, and she had something to say. Nobody could make that remark if they were not talking about this case. As I say, I argued the case in the Constitutional Court, but I had forgotten that aspect of it. So she obviously was talking about this case.
I'm happy to accept I'm wrong. Sorry, through you, and I'll deal with witness and listening.
Yeah, thank you.
All right. I thought that would be the point that you would you online to come to deal with that.
Yes. Yeah. I mean, okay, I don't want to waste time on this, but just to illustrate the point, the point that the witness spoke about, you'll find it paragraph 4, where the court says, therefore, the public protector was entitled to subpoena taxpayer information. On the basis of this opinion, the public protector issued a second subpoena still requiring production of former President Zuma's taxpayer information and so on. That's what we discussed yesterday. But that's not what I want to discuss today. I want to take you to the issue of that is related to what we have just discussed around the Reserve Bank case. And Chair, if I beg you to give me just an extra, whatever you are going to give me, an extra 10 minutes, because I need to read some of these. For me, this is something at the heart of what we're doing here. And something that actually, I think I've said this before, it was a pleasant surprise. Because when we argued this during the case, we were even cautioned by the court that we were moving on thin ice as to the level to which we were criticizing the judiciary. But fortunately, we did so, and then the judgment vindicated us. And this relates to one of the 14 issues in the IOI guidelines, which is where the judiciary, I said yesterday that the judiciary and the legislature and the executive are supposed to play a role that is checks and balances rather than ganging up against the public protector. And I think we all agreed on that. But we put forward to the Constitutional Court evidence to show that our courts had actually gone overboard in mulcting the public protector with costs. And although the court didn't use the word fashionable, which is what I had used in my argument there, it basically vindicated that stance. And I'll read from paragraph 42. So that, did you find it? Okay, can we go to paragraph 42? I think that everyone talks about EFF and Reserve Bank, but I think this is the judgment that really defines what a country should not do. Yeah, okay. This is what Matlanga J said. And incidentally, he's the one who had questioned me in court about this. So I was very happy to see that between that time and writing the judgment, he probably looked at the evidence more carefully. It says, there appears, he says, in the middle, there appears to be a developing trend of seeking personal costs in most, if not all, matters involving the public protector. In other words, litigants were now catching on to this fashion, and they basically wanted to cash in, as it were. And this says, of these, a total of 4, including this one, have reached us. And the 3 high courts, in the 3, the High Court granted personal costs against the public protector. What one of those cases stand out was, what made one of those cases stand out was that a personal cost order was granted based on, quote, the usual rule. And that's what I meant by it's fashionable. That costs follow the result with no consideration whatsoever to special circumstances that justify the order. Okay. Then this is a far cry from the stringent terms towards of personal costs. And sorry, the next passage is more important for a different reason. This whole issue of so-called scathing remarks. The court in that case had made probably the most scathing remarks and found adjectives that I didn't even know existed to describe, to justify the personal cost order. And then this is what the Constitutional Court said. And in the matter instant, in its conclusion, the court has carefully selected and used epithets and particular nouns that are suited to award of personal cost orders, but there's not a scintilla of evidence to support those epithets and particular nouns, and therefore the conclusions. Thus, the conclusions simply cannot stand up to scrutiny. Then he says, out of the 4 applications that have landed here, it is only in one that this court has sanctioned the personal cost order. Of course, that does not mean that litigants who on cogent grounds believe that they're entitled to award personal costs against the public protector must not push for such awards, and that where such costs are warranted, courts should not grant them. But, he says, it does mean that courts must be wary not to fall into the trap of thinking that the public protector is fair game for automatic personal cost awards. And I just want to pause there. So this was a serious statement made by the Constitutional Court of, when you say automatic, you literally mean like just knee-jerk. So it's a public protector, therefore it means personal cost. And it says very important, whether inadvertently or otherwise. In other words, this could be in an innocent thing, but it could also be deliberate. I don't think it can be more serious than that. Whether inadvertently or otherwise, the High Court judgments in the EFF versus Godan matter, and that in the instant matter are instances where the High Court fell into that trap of knee-jerk or automatic cost orders. And then he says, personal cost orders may have a chilling effect on the exercise of the public protector's powers, including litigating where necessary. And I think that's the point you're making about it would make a public protector not want to investigate because they think, well, if I'm going to be in for personal costs, then I might as well not even do the investigation. Correct?
Correct, and it also erodes the respect for the office because this public protector is going to leave that court having personal costs awarded, against them. And then they have to go back and sit and call other respondents institutions to appear before them. There's just no respect for the office anymore. It's
Yeah.
just
Right. Then the learned judge says, has an office specially created together with other Chapter 9, others under Chapter 9 of the Constitution is an important cog in our constitutionalism, as it and the others were created, quote, to strengthen constitutional democracy. Axiomatically, the public protector's office is more important than any incumbent. In other words, your personal hatred for a particular incumbent should not destroy the entire institution forever. Amen. Yeah. Okay. And then he says, the impact of certain types of conduct that shake its operations as foundations may outlive the term of office of a number of incumbents. Needless to say, as the judiciary, we must not be guilty of contributing to the weakening of that office. The point you made yesterday that sometimes the judiciary itself becomes, quote unquote, part of the problem or part of the forces that threaten the existence of the office.
yes, exactly. It's even mentioned in the Venice principles that the judiciary could be one of the institutions.
Yes.
Also.
And this is where I said you were using the words of Justice Matlanga when you said it would weaken. Yeah, because he says, quote, you weaken it, you weaken our constitutional democracy. Its potency, its attractiveness to those it must serve, its effectiveness to deliver on the constitutional mandate must be preserved for posterity. And I just want to refer this back to when he talks about effectiveness. Remember that the full name of the O.R. Tambo Declaration is the O.R. Tambo Declaration on the minimum standards for an effective ombudsman institution and cooperation with the African Union on strengthening good governance. So this issue of effectiveness that the learned judge was talking about here also captures what we call the minimum standards.
Yes, it does.
Yes. And here's the punchline. He says that I voice these words of caution, which I hope everyone would listen to. Says, because of the disturbing frequency and regularity of applications for and awards of personal cost orders against the public protector. Disturbing frequency, automatic. And then it says, what is particularly disturbing is that it is clear that the applications and awards are not always justified. That much is apparent from the facts that 2 out of the 3 personal cost awards that have come before us, including this one, have been set aside. Crucially, those 2 typify the worst examples of personal cost orders. And in the 4th matter, where no personal cost order, where there was no personal cost order by the High Court, but there was an insistence that this court should make such an award, we declined the invitation.
So there was an insistence by the respondent institution.
Yes. Well, it's saying there were 4 cases basically. Only in one was, which was the Reserve Bank case, I think. And then he says in 2 of them, they rejected those personal orders because he says that they were the worst form of personal orders of the automatic knee-jerk type of court order. Then in the 4th one, he says it was not sought in the High Court, but in the Court, there was an insistence by the respondent. And as he puts it politely, the Constitutional Court declined that invitation.
So exactly that the respondent institution tries to use the courts to punish the
Absolutely.
public protector, which goes against all our principles.
Yeah, well, that's the conundrum, isn't it? That's the central conundrum of this particular inquiry. That this parliament is now an extension, or at least the intended extension of those who are affected by the public protector. Because it might not be clear to others, but the chain reaction is like this. The public protector investigates, let's say, a multi-billionaire called Mr. Ngola. And that multi-billionaire is then going to use their deep pockets to fight the public protector in court, right? Because how dare she wants to investigate him. The court, if it falls into the trap that Mahlanga J is talking about, will automatically give that knee-jerk cost order for her to be bankrupted and pay the personal costs, right? In doing so, that court has to justify that. And then it comes with what he calls unjustified nouns and epithets to describe her conduct, because it has to justify why it must give the costs, right? Then it's going to say, no, she's the worst person who has ever lived, and therefore she must be mulcted with the costs. Issue a judgment, right? And then Parliament says, oh, Ms. Mazzoni in particular, not Parliament. Ms. Mazzoni says, oh, there's this scathing judgment, takes it to Parliament. The rest of anybody who doesn't like the public protector says, yeah, well, let's chop her head and take that judgment because, quote unquote, it's binding, and then it's the basis for impeachment. Then the reaction, which is exactly what is happening here. That's why I said to you, 90% of the charges here are based on this cost, on these utterances of the courts and the cost orders. You've testified yesterday very clearly and unambiguously that the Parliament should not allow itself to be, what to call it, the whip, as it were, when the arm and the hand actually belong to all sorts of other people, and the Parliament is just taking a judgment and imposing it on a process like this for an impeachment. Can you please just talk to us as South Africans or this Parliament about the dangers inherent in this, and maybe to the continent, because it's not, as you said, these are not things that should be copied by other people. Taking into account what we've, the quotations that I've given you from the Constitutional Court.
I think maybe just to put it very simply, the legislature and the judiciary should not be used as enforcement mechanisms on behalf of the executive. The judgments that have been issued are mostly between the public protector and the executive. And once these judgments come out against the public protector, if they're then taken up by the legislature as a justification for any disciplinary procedure against the ombudsman, it means that the executive has managed to get their back at the ombudsman, firstly through the judiciary, but the judiciary are allowed to review the reports of the ombudsman and to stop at that, to either reverse, uphold, and then it should end at that. The public protector should then look at it and say, okay, I have to change my work ethic, my work style, and the way I report and the way I investigate. But then if the judiciary again punish the ombudsman by issuing personal cost awards, and then those reports, the judgments again lifted by the legislature, the respondents and the complainants are allowed to complain if the officer of the ombudsman is not performing optimally, and they can use the courts of law. But for the three arms of government to start to also become complainants in the process where the ombudsman has not misconducted herself in any way, I think it's really put the institution of the ombudsman under threat. And I would want that, you know, a healthy discussion is held around this matter in various jurisdictions by all three branches of government. They all have to understand what they're putting in, what their stake is in this institution, so that this sort of issue never arises again. It takes us so much back, as I said.
All right, now I'm sure that, well, as I said yesterday, at least some of the people who are taking us back like that probably is out of, it's not intentional, although some of them it might be. There are many ways in which who are sought to be taken back in this country. But finally, I want to take you through, because of time, we won't be able to go through your slide presentation, but it's at page 272. I'm just going to highlight 2 or 3 of the slides, just to wrap up really what we have discussed in the past 2 days. Thank you. Chair, the witness had prepared the slide presentation, and at some stage I thought we would follow it but we decided to follow the statement rather. So, but it's available to the members. Okay, slide 1 and 2 are just I think we've covered that. Slide 2. Yeah, you say that the ombudsman institutions have become a crucial component of the contemporary model of good governance. They are crucial in protecting and promoting administrative rights and giving people a way to file complaints free of charge when such rights are allegedly violated. So that's the broad mandate. The emphasis there is on the fact that the services are free, unlike the courts, which are not accessible to the poor. And then the next slide, you can jump. Next one can jump, next one can jump. And then 278, yeah. There is just a summary of what you call the comparison between the classical model, which you say is to be found in places like Zambia, Malawi, and the hybrid model, which is to find in places like South Africa, Uganda, Nigeria, and Zimbabwe.
Yes.
Okay, and Namibia. Namibia is also a dual mandate. Next one, 279. Then this is the typical conundrum. The office is in a difficult situation because it needs to use the government's resources while at the same time checking on the same government.
Yes.
And you say, nevertheless, the independence, there it is again, from other governmental branches is likely the most crucial condition for a successful ombudsman's office. And that would also entail issues such as the institutional immunity and autonomy.
Yes, exactly.
So that means this process really suffers two major flaws, to put it bluntly, in that it's this issue of taking judgments and using them, which you just spoke about, but also the other issue of breaching the protocols on institutional autonomy.
Yes.
All right. And natural justice was spoken about. Next slide, you can jump. 281, just for the sake of emphasis, your third bullet point highlights the autonomy and independence of the Ombudsman's office.
Correct.
All right. Then you go to the instruments. We won't do that because we've dealt with most of them. You deal with the AWOC, the role of AOMA, those principles of, on the next slide, the quest to take this to the AU and all that. And the role of the South African government in the establishment of such institutions. 284. We deal with the security of tenure and natural justice again. To 87. Yeah. Okay. There you deal with the Venice principles and you highlight the immunity from legal process in respect of activities carried out in their official capacity. Do you want to add anything to that? Or its importance?
Really, I think what I should state here that the option to have a matter taken to court against the Ombudsman should relate only to the findings and recommendation of the Ombudsman. That is also what the court should address itself to. And once the judgment comes out, it is a tool for the Ombudsman to use to improve the performance of the office.
Okay, thank you. Next, 288. Those are the Paris principles, which is one of those instruments. 289 is the UN. We've covered that. 290, the issue of the UN. Again, your last sentence there goes back to your original point about the protection and promotion of human rights. 291, 292. Right, and then I think this is your last slide at 292.1. Yeah. And I think it covers for me what I really would like us to take this discussion to, which is the question that you posed there. Who is the ombudsman's ombudsman? In other words, who shall protect the public protector? If Parliament, the judiciary, and the executive, in the way that we have now described, become a chain of punishment, a continuum and a continuous chain. And by the way, maybe let's pause there. In your speech, you refer to something that you call the party whip system. So political parties are also able to abuse the public protector, correct?
Yes, according to that particular example in the Lost at Sea case.
Yes. And no, because here we have, well, political parties that one, as I said, that I told you there's one that was had a vendetta against the public protector even before she started work. But you talk there specifically about the ruling party, which obviously would wield a sufficient majority to do as it likes, basically, in the parliamentary system. So if we have all those weaknesses and the continuum of punishment, as I've termed it, then who's going to protect the public protector? And I think that's the profound question on which you end this. And I just wanted to ask you, maybe if you don't, there's one place where I'll propose an amendment to your slide there, or an expansion. So that's why I'm taking you to that slide. So if you go through the bullet points, you said appointment and accountability to the legislature and protection of the office. So you agree that the real ombudsman of the ombudsman should be this parliament?
Yes. The investigation mandate covers the executive. Once the investigations have been carried out, special reports are submitted to Parliament. But however, even in its operation, if the Office of the Ombudsman has difficulties, they should be able, when they are tabling their reports or the annual reports, they should be able to bring out any operational problems, administrative problems, and even legislative issues to the attention of Parliament, so that there is no issue of compromise. Yes, but however, practically speaking, because it is the executive that funds the office of the ombudsman, they often have to have daily interactions with the executive regarding the running of the office. But if there are any problems, it should be directed to the legislature to act sort of like as an arbiter for the office, to speak for the office.
Yes. And if we go back to our example of what I call the continuum of punishment, in the cases that feature in this case, there are members of the executive who feature very prominently, such as Mr. Kodan. In the cases that there are two cases in particular. One is called the so-called rogue unit. The other one is Pillay pension matter. And then there's the infamous CR17 matter, which is one of the charges. That's the one I was talking to you about the alleged bribery to hold office. And then you have a host of SOE entities. So the cases really represent what you are saying, where the executive takes on the public protector, and now it wants this parliament to be its extension, so to speak. What are the dangers in that?
Well, basically, I think it goes down to the independence of the office. The office holder, in a way, accounts to Parliament, and the independence of the office to investigate executive bodies must not be undermined by in any way at all by the legislature or by the judiciary. So this is the reason why I said that having brought these standards, these international standards, to the attention of the government at large, I think it would be very, very important to look at the standards and see where the application of these standards falls short, so that some of these issues may be corrected.
Yes. Okay, very quickly, before the chair now runs out of patience.
Let's just before you proceed, can we now wrap up?
Thank you, Chair.
Advocate Mbofo.
Yes, thank you, Chair. All right, so I'll just go through the rest of them in point form. So security of tenure and the judiciary, we've dealt with that. Judges' terms and conditions, referring to the judiciary, we've also dealt with that. Powers to issue orders, judiciary and so on. The one that I wanted to contest with you or to debate with you is you say adequate funding for operational and administrative and various interactions. Whether that's really just the executive, or does the legislature not have a major role to play in that as well? Well, obviously the legislature is not going to give you money, but at least in assisting you to lobby, quote unquote, for the.
Yes, definitely. When the office budget is being debated by Parliament, of course, they have the power to increase that budget. Yes, in that sense, yes.
Yeah, good. Okay, so then also the establishment and administrative and operational autonomy, we spoke a lot about that. And you said that that's a function of the executive. But again, I would say that the legislature also has a role to ensure that those lines are not crossed or blurred. Correct?
Yes.
Use of principles of national justices. Well, that goes without saying, and to say that applies to all three branches, including the legislature.
Yes, each and every branch of government, when they're dealing with the ombudsman, they must exercise those principles to ensure that they're doing the right thing, and the ombudsman as well. When they're dealing with the executive as respondent institutions, you have to ensure that you apply the principles of natural justice as your standard. Yes.
And lastly, without talking about it in detail as you did yesterday, it's what I've called the fundamental thesis of your evidence, which is that if there's a way, we should find a way of going back to the system where the issuing of reports is backed by recommendations only, as opposed to binding remedial action, which, as I said, probably is what has brought us here.
Yes, it protects everybody. It protects the courts. It protects the executive from trying to, influence anybody. It protects the ombudsman, because then there's no one who has any grudge against the office of the ombudsman. The system just works well, it's self-accounting, in other words, but it's a way of using soft power in order to influence the system to ensure that the tenets of good governance are being respected. Yes.
Using more brain than brawn. Okay, well, thank you, Chairperson. I was going to ask you if I had time just to contextualize, but at the end, the Chairperson in any event will give you an opportunity to say anything that doesn't necessarily come from the questions. Thank you, Chair. Those are my questions.
Best case ever.
Thank you,
Thank you.
Advocate Mpofu, and thank you, Ms. Sokoni. We now going to pause for tea break, and we'll be back at 10 to 11.
Thank you.
10 to 12. Thank you.
Recording stopped.
Thank you, colleagues. Hope you had a good quick tea break. We now resume and we're going to start the cross-examination. As indicated when we started yesterday, we said Advocate Mpofu had the day dedicated to him. He did make a request and he made good to it that he didn't finish yesterday. It's just concluded before tea. And as I indicated thereafter, we'll invite evidence leaders for cross-examination. I am still also indicating that members will come today still. So if we spill over a few minutes or an hour, we will do that so that we conclude. Ms. Sokoni has been here. I hope you don't want to be here until tomorrow. Yeah, I know you enjoy Cape Town.
I'm sure we'll finish today.
Chair, sorry, I don't want to be pedantic, but just to remind you, in case, just for the record, that the evidence leaders are not allowed cross-examination, but they can put questions.
Thank you. Well, we're not going to discuss that. Thank you. Advocate Bauer, I now hand over to you.
Good day, Ms. Sokoni.
Good day.
I just want to understand your evidence. You are the public protector of Zambia, and you come and you give a perspective from a perspective of a position. Well, from the perspective of a public protector. Would that be correct?
From the perspective of public protector, and also from the perspective of the international standards that have been set in place for the Office of the Ombudsman.
And you use those international standards as the benchmark by which you give your evidence, as I understand it.
Yes.
Right. You also, your organization which you represent have issued statements and have come out in support of the South African Public Protector, correct?
African Ombudsman and Mediators Association has not issued a statement according to my knowledge, but I believe the International Ombudsman Institute must have written a statement in support of the process that is going on now. I'm not very sure, but I suspect the International Ombudsman Institute.
I wasn't going to put the statement up because I didn't think it necessary, but I think Ms. Kajuju can confirm with you that she did issue a statement in support of the Public Protector in June of last year.
Oh, on behalf of the African Ombudsman and Mediators Association?
There is another, sorry?
Because there are two organizations. There's the International Ombudsman Institute and the African Ombudsman and Mediators Association. And I believe Madam Kajuju issued a joint statement with the president of the International Ombudsman Institute. That is the one that I'm aware of, as in her capacity as Africa Director for the International Ombudsman Institute.
Okay, I think during the lunch adjournment, I'll provide you with that statement. I don't want to delay, Matt, because I don't think much turns on it. But the statement which is attached to your affidavit is a statement by the African Ombudsman Mediators Association.
Maybe you could just...
Correct, it is. Do you have a hard copy of your affidavit with you? It would be the annexure CCZ2. Yes, put it up, please. It's on the screen.
Yes, this is the statement, yes, that we have just submitted in support of these proceedings. This is the statement you're referring to?
Yes.
Oh, yes, okay. Thank you.
And that is attached to an affidavit which you deposed to.
Yes,
Did you prepare the statement?
yes, this statement was prepared by me.
And this was based on your knowledge of the legal principles that's contained in the statement.
Yes,
Right. Now, there was some confusion about whether you have been appointed as a judge, or whether you have not been appointed as a judge. The committee last year was told that you had been appointed as a judge and that it was just a matter of the I's being dotted and the T's being crossed before you would be taking up such office. Can you perhaps clarify this?
thank you very much. Yes, I was appointed to the office of judge and I was awaiting ratification. However, as you well know, the office of Ombudsman is supposed to have security of tenure, or it's supposed to be for a term certain. And I had brought this to the attention of the authorities that there was this conflict, that there is a term certain for the office of Ombudsman. And they looked at the issue and they looked at the laws, and then they agreed with me that I was supposed to actually finish my term of office as Ombudsman before I could be considered for any other appointment.
Okay, so
Yes.
there was no, there's a Judicial Service Commission process in Zambia, am I correct?
Yes, the Judicial Service Commission recommended for my appointment as judge. And then the president appointed on the recommendation of the Judicial Service Commission. And then the matter was sent for ratification to Parliament.
And was it ratified, or is it in between that it was?
Before the ratification process could be completed, the matter was brought to the attention of the authorities.
Now, can you maybe explain to the committee, what are you an expert on?
I beg your pardon?
Can you explain to the committee, what are you an expert on?
I have come to address this committee on the aspects of ombudsmanship. I've been an ombudsman for 18 years. This is the 19th year, actually.
And in those 19 years, how many instances or involvements have you had in the removals of public protectors via constitution and legislative process such as this one?
I have had occasion to look at aspects of ombudsman offices under threat. As a member of the Executive Committee of African Ombudsman and Mediators Association, and also as a director of the International Ombudsman Institute, but not to the extent that of the South African process, where there is an actual involvement of an international organization. Yes. But we have considered such matters at board level, either at the IOI or the African Ombudsman and Mediators Association.
So can we just limit this to removal proceedings such as this nature? We accept that you've been an ombudsman for many years. And let's distinguish between what is under threat and the removal process. How many such removal processes have you been involved with?
As I have said before, in removal processes, no. But where ombudsman offices are under threat, yes. I'm just distinguishing.
So the proposition was put to Mr. Hassan Ibrahim, who's a who's an experienced South African constitutional lawyer with a South African law degree and an experience of some 20, 25 years in constitution and constitution making, that he was not an expert in the removal proceedings of public protectors or ombudspersons. Would you regard yourself to be an expert in the removal proceedings of public protectors?
I would consider myself as an expert in ombudsmanship, and I think ombudsmanship would include any other issues that are incidental. So it is just an issue of applying the principles to any situation that affects an ombudsman.
So he told the committee that it was a relatively new area, that there hadn't been such formal proceedings of removal processes pursuant to a constitutional and legislative framework, and that one wouldn't find a jurisprudence in respect thereof. Would you agree with that?
I wouldn't be able to say yes or no, but because ombudspersons all over the world, it's not all of them who serve their full terms. Some are removed, some even forcefully removed from office. However, I couldn't off the cuff give you any cases regarding removal of ombudspersons.
You see, I think we were in agreement that this is a novel process. And so we searched high and low for purposes of assisting the committee to see if there was some, as lawyers, you look for a precedent to see how you can be guided by a similar like process. And the closest we came was a process that took place in Philippines that got aborted before it was completed. So my question to you is, in the removal of public protectors in the world that you would be aware of, or your international organization would be aware of with your some 100 members, are you aware of any case law being reported or any process through a parliament of an impeachment process of a public protector?
Maybe let me put it like this. I think that if the principles of ombudsmanship are being followed and are being applied strictly, there wouldn't really be a similar process found anywhere, unless it is a situation where the ombudsman has, like I said, grossly misconducted themselves, the ombudsman himself. And for you to appoint an ombudsperson, you have to have gone through a very careful vetting process. So I would not expect that there would be several cases of impeachment of an ombudsperson, really, considering the type of office that it is.
Ms. Sokoni, I accept that if you play by the rules, you shouldn't get impeached. But the converse is also true, that if you don't play by the rules, you may be subject to impeachment as a general proposition. Would you agree with that?
Yes, as a general proposition.
As a general proposition. Now, at the level of the question I'm asking you is, are you aware of any public protector anywhere in the world where the legislature, as the oversight body of public protectors, has made a call that you are going to face impeachment proceedings because, and let's put this colloquially, you haven't played by the rule, and whichever national standard you had to meet as a public protector, you didn't meet? Are you aware of any process of that nature that has occurred?
To the level of the process that is going on here in South Africa, no.
Okay.
So to the level of the process that's going on here in South Africa, there wouldn't be an expert on this process anywhere because you're not even aware of such a process having occurred anywhere else. We're not talking about the levels of generality of threats or the levels of generality of the standards by which ombuds people are protected. We're talking about the actual impeachment process.
I would say that I am not an expert in South African law. I'm not an expert in South African constitutional law, but I can speak knowledgeably on matters of ombudsmanship. So what the process that is going on here in South Africa is unique to South Africa because of the way the constitution has been crafted and the way the laws have been put together. So I wouldn't say I'm an expert on the process that is going on here in South Africa. I can only speak to the general principles of ombudsmanship.
Thank you. So, and I fully accept this. And you're a trained lawyer and you can read a case and you can read legislation. Can we accept that? You'd be able to look at the law and you'd be able to explain it and you'd be able to read a case and you'd be able to understand the judgment.
Yes, I am a lawyer.
No. I'm wanting to make it clear that I'm not questioning that for any moment.
Okay.
Okay, so I'm not trying to say you can't do that. You can look at South African laws and you can look at South African cases and you can form an opinion on it, even though you're not an expert on South African law. Would you agree with that?
Well, yes, but I wouldn't be able to give, for example, the sort of evidence, the level of sort of evidence that Mr. Ibrahim gave, because he has studied South African constitutional law, and he's able to give his opinion on the Constitution of South Africa and the constitutional processes of South Africa. So I don't think we can be equated really.
And I noted that when you answered some of Advocate Mpofu's questions, you prefaced it by saying in a classical system. And your Zambian experience is a classical system, correct?
Before, it was not a classical ombudsman system because we were an executive ombudsman and we were answerable to the executive. We only became a classical ombudsman system from 2016. But again, of course, with the fact that we now have binding powers, which again, I cannot say. Yeah.
So we accept that South Africa is not a classical ombudsman. It is not answerable to the executive, it's answerable to the legislature, correct?
Yes.
And then the post-2016 Zambian experience is a classical one, but the South African system is a hybrid one.
It's a hybrid one because it has a double mandate.
That's right. Okay. Now, and were you integrally involved in the Zambian changes from an executive to a legislative process that occurred in 2016?
Yes, I was.
And so can I maybe ask you this question? You're not an expert in South African constitutional law, and you're not an expert in the application of South African law, right? And as I understand, you testified that your reasons for coming to testify here is about protecting of an institution in South Africa that can't be allowed to go backwards. And it's an institution which is informed by a constitution and provisions of the Public Protector Act, which is almost an example for other countries. Would that be a fair summation of the reason you gave for why you came to testify here?
Yes, I said the reason why I came to testify here is because after 18 years as ombudsman, the institution of the ombudsman in Africa has made great strides. And for me, it was important that I come here as well and try to also contribute to ensure that the institution of the Ombudsman continues to make progressive strides.
Indeed, and this was done pursuant to a letter that was addressed to the organization by the Public Protector's Attorneys, which is 214. It was addressed to the Secretary General of IOMA and the African Regional President of IOI. Correct? You received the letter on the 23rd of August, it's 214, annexure to the affidavit. And the organization's assistance was sought, and I quote from paragraph 2 while it's being put up on the screen, because I'm sure you're aware of this. You might be aware of the fact that the process underway is the first of its kind and unique in the sense that there's no precedence thereof. As a result, it is of paramount importance, I'm reading paragraph 2, that the public as well as the committee tasked with this function must fully understand the role played by the Office of the Ombudsman within a constitutional democracy. Correct?
Yes. Yes.
And that's the purpose for which you've come to give evidence, to assist the committee in understanding the role played by the Office of the Ombudsman in a constitutional democracy. Would that be fair?
Yes.
And in the letter on page 213, you were nominated. It's just a page, 2 pages before that. Yeah, 1 page before that. You in fact were nominated by the organization to make a presentation before the parliamentary inquiry. Correct?
That is correct.
And that is the presentation. Am I correct in assuming that that is the presentation that Advocate Mpofu took you to near the end of your evidence?
Yes, that is correct.
And you prepared that presentation?
That is correct.
And they say this followed your observations of the inquiry of the proceedings from the 24th to the 31st of July on behalf of IOMA. Right? Can you tell us how IOMA came to be in the proceedings on the 24th? I'm not sure if you were here all 6 days, but I can't remember. But the letter says you were here from the 24th to the 31st.
Repeat the question, please.
How did it come about that you came to be observers to the parliamentary process from the 24th to the 31st of July?
There was an executive committee meeting which was held in African Ombudsman and Mediators Association executive committee meeting, where it was decided that there should be an observer team sent to come and first observe.
Right. And what was the purpose of that?
The purpose of?
The observation that you were coming to observe.
We had received, I believe we had received a letter from the public protector. I'm not very sure. The Secretary General to our OMA would be able to answer that question, but I think there must have been a letter received from the South African public protector requesting for our intervention. And I think that was the reason why this matter came up before the executive committee of the African Ombudsman and Mediators Association.
And is the South African public protector part of that executive?
She is part of that executive, but I believe she was not at that particular meeting. She was not at that particular meeting.
And what was the nature of this intervention that was sought?
She didn't ask for a specific intervention. She just wrote about the process, and she was unhappy about it, and she sought intervention of the African Ombudsman and Mediators Association. I think that was following her request even to the International Ombudsman Institute. I'm not very sure, but
Now, in the course of your evidence, you testified that there are standards that public protectors should adhere to, and natural justice and procedural fairness are included in those standards, correct?
yes, both of the principles that really guide and protect the office. So whenever you're dealing with a complainant, when the complainant comes before you, you find out what the complaint is, whether the principles of natural justice were applied, were they heard, were they given an opportunity to present their case. And then when we go and investigate again with the respondent institution, that is the guidance that we use. And then when we, even internally, when we are dealing with our members of staff, we always try to ensure that we give everybody a fair hearing, because we should be the example par excellence. We should ensure that we are leading by example all other institutions.
And maybe if I could paraphrase what I think you were saying, that the office holder of the public protector must exhibit the highest tenets of integrity, professionalism, transparency, and accountability to the public interest, the cause of justice, the Constitution, the rule of law, and democratic principles. Would you agree with that?
That is correct.
Right. And they must also assist with the maintenance of law in the country.
We're now going to resume. Advocate Bauer, back to you because we are now connected. The members on the virtual platform can hear us. I hope that the YouTube is also working. Slow sample. Check that. Thank you. Advocate Bauer, over to you.
Mr. Sokoni, before we were interrupted, and I'm not sure how much is on the recorder, so I'm just going to go a few propositions back. I put to you that there were certain standards that the public protector should adhere to, and I said to you that those were the standards, just broadly speaking, of natural justice, procedural fairness, that the public protector must act in a manner that shows she is independent so that people can perceive that she is actually independent, that she must take responsibility for every report being issued, and that she must comply court rules and court orders, and that she has a special responsibility to tell the truth to courts and to file affidavits truthfully before the court. I think that's as far as we got. Would you agree?
Correct.
And you agreed with me that those were characteristics that on the standards that you are proposing for a public protector, that those would be included.
That is correct.
Right. And included, and if I continue with this list, would you agree that one would expect that there would be honesty in the reports issued from the public protector, that evidence that is being referred to in the compilation of those reports would be, if there's a list in the report, would be complete? Would you agree with those?
Yes.
And would you agree that the reports would reflect an understanding of the law?
I beg your pardon?
The reports would reflect an understanding of the law.
Yes, that is correct.
So as I understand you, you draw the analogy that the public protector should be akin to the judge. So would you say that a public protector should also have the legal acumen of a judge?
Yes, I did state that. That is why it is necessary that the vetting process for the public protector and ombudsman should be of such a high standard that there will be no need to cast any doubt that there is a certain level of professionalism, the required level of professionalism in the reporting standards.
And you would agree that there mustn't be anything that the public protector does that a member of the public who would want to access the public protector's office would believe that there's any collusion or improper behavior between a public protector and a member of the executive. Would you agree with that?
That is correct.
Right. Now, would you also agree that if there's, and I'm putting this hypothetically to you,
Yes.
if there is an abuse of power on the part of the public protector, or if there's a breach of principles of legality, or acts of unconstitutionality, or breach of any of the principles that I put forward to you, that would attract judicial scrutiny.
That will?
Attract judicial scrutiny. That the court would then, a litigant would go to court, would complain about what the public protector does, and a court, if find that that is correct, would rule against the public protector.
That is correct.
So if we go, and I'm going to try to make it easier and quicker, if we can in some ways go to the statements that you have, you set out the background in your statements, which I indicated to my learned colleague that we didn't really take issue with, except that I did find it interesting that you say that the concept emanated from the Turks. There seems to be another innovation that has been attributed to the Europeans, but actually originated somewhere else. Would you agree?
Would you repeat the question?
The concept of an ombudsman, the
Yeah.
notion, you indicated that originated from the Turks.
Yes, it's originated from Turkey.
And even from its inception, even from its inception, it wasn't a free pass to any ombudsman. They had to comply with the laws of the land. Would you agree?
Yes.
And that doesn't matter whether it's a common law system or whether it's a civil law system.
Yes, the ombudsman is a creature of the law. It's a creation of the law. It's a constitutional institution.
And so when Parliament and its elected members decide to apply the law, then like everybody else in the country, the public protector must comply with it as well.
Yes, the public protector must comply with the law, but also the institutions that are trying to implement the law and the provision of the law must also comply with the law and with the standards.
And so I raise this with you because in the first instance, the people in South Africa must comply with the laws of South Africa. And so even if you come and give evidence to this inquiry about what you prefer to be a better system or a fairer system, if that's not a reflection of what bona fide laws in South Africa allow for, then it is the bona fide laws in South Africa that would prevail. Would you agree?
Yes, I would agree. The evidence here that I am giving is merely advisory and of maybe persuasive value.
So I just want to take you to some of the basic provisions that deal with the role of the public protector and specifically the removal and the criteria of the public protector. And I'm going to draw a comparison between South Africa and Zambia, because I think that there is a blurring of the lines between your evidence and our understanding. And I just want, for the sake of the committee, to be sure that we're not leading the committee up the garden path.
Yes.
If we put up the Constitution and we go to section 194 of the Constitution, right, it's 39, number 1. The heading is, it's the removal from office. And so it is the removal from office. It refers to the removal of an individual from various Chapter 9 offices. The public protector, the auditor general, a member of the commission established by the chapter. Do you see that?
Repeat the question, please.
The heading says removal from office.
Yes.
And it refers to the removal of an individual from an office.
Correct.
It doesn't deal with the removal of the institution itself. So it's not harmful to the institution of a public protector. It deals with the incumbent in the public protector's office.
Yes.
Would you agree with that?
Yes.
And a hypothetical level, and I'm not suggesting that you have to get engaged with the evidence with me in any way. If there is a conclusion reached that an incumbent must be removed from a public protector's office because the criteria for removal have been met, that doesn't automatically follow that that's harmful to the institution of the public protector. Would you comment on that?
Because the office of the Ombudsman is very unique in that it investigates the executive. If the removal of the office is not carried out according to, let's say, the legal provisions or according to the laid down standards, it is likely to harm the integrity of the institution of the Ombudsman in such a jurisdiction.
So my question was, if it meets that criteria, then you can't draw the conclusion that it's necessarily harmful to the institution. So let me give you an example. The Zambian public protector, the Constitution provides 4 grounds on which the Zambian public protector can be removed. A mental or physical disability that renders them incapable of performing functions, or it says judicial functions, but let's read into it, public protector functions, incompetence, gross misconduct, and bankruptcy. So let's assume bankruptcy is the most objectively determinable one, is hypothetically the situation that a Zambian public protector finds him or herself in. Then there's an obligation to remove that public protector from office. Would you agree with that?
Yes.
So if somebody approaches the parliament and claims any one of the 4 criteria that is there, then there's an obligation on the legislature to commence a process. Would you agree with that?
That is correct.
Now, we know that both the South African and the Zambian constitution makes provision for the removal of a public protector, and it also makes provision for the suspension of a public protector by the president. You familiar with that? I think it's section 144(3) of the Zambian constitution, which allows for the suspension of the public protector.
Yes, the public protector may be removed from office, or investigations or disciplinary procedures can be commenced against that office through the Judicial Complaints Commission.
I'm coming to the Judicial Commission at the moment, but let me ask you this. When the public protector is removed from office, does that office continue to exist? Does it continue to function?
Yes, it continues to function.
So a removal of a public protector on a suspension isn't necessarily detrimental to the functioning of the office. Would you agree with that?
Yes, on just cause is not detrimental to the office.
Now, the Zambian constitution says the public protector can be removed in accordance with the same procedures that apply to a judge.
Yes.
Right. And that procedure is set out in the Zambian constitution, and I'm going to paraphrase it, and if I've got it wrong, please correct me. There's a Judicial Complaints Commission, or a complaint to the Judicial Complaints Commission that initiates this removal process based on one of those 4 grounds that I referred to, correct?
Yes.
Right. This Judicial Complaints Commission must then decide whether there's a prima facie case that has been established against the individual, and it must submit a report to the president.
Yes.
Right. On the basis thereof, the president must suspend the public protector.
Yes.
Within 30 days of that suspension, the Judicial Complaints Commission must have a hearing.
Yes.
Right. In that hearing, it must be in camera, and the individual is then entitled to appear, to be heard, to be represented by a legal practitioner of his choosing, and the Judicial Service Commission must then make a finding as to whether the allegations have been has been substantiated or not substantiated.
Correct.
They must then recommend revocation of the suspension to the president if it's not substantiated, and that suspension must be immediately revoked.
Yes.
If they find that the allegation is substantiated, they must recommend removal, and the president must then remove.
Yes.
Right? So this is a process which is not exactly on all fours with South Africa, because South Africa does not involve each Judicial Service Commission or any judicial committee under that auspices in its process. Would you agree with that?
Yes. In fact, I had pointed out that when the office was an executive ombudsman, it had a similar provision as you have now for removal. But then later on in the later constitution, they standardized it with that of judges.
So let me take you to the South African version and just point you out where I think there's a difference in our understanding.
Yes.
Under the South African Constitution, which is section 194(1)(a), the removal is based on misconduct, incapacity, and incompetence. There's no provision for bankruptcy. Let's just state the obvious. And moreover, Our drafters of our constitution has said that a public protector must be removed for misconduct, not gross misconduct. So, and do you accept that there is a distinction between misconduct and gross misconduct, the latter being more serious than the former?
Definitely.
Right. And so when you state in paragraph 34 of the statement, that in both jurisdictions, the grounds are the same as would be the removal of a judge from office. That's not entirely correct. Would you agree with that?
I believe the grounds for removal, you'd have to show me the provision for the removal for judges for South Africa, but they should be the same.
So the grounds of the removal for a judge is, are you comparing a Zambian judge with a Zambian public protector? Are you comparing a Zambian judge with a South African judge, or are you comparing the two public protectors?
This was a comparative analysis. Let me just look at the particular paragraphs.
It's 234. You see, because the preceding paragraph talks about the grounds of removal for a public protector. And so I could have read it wrong and thought you were referring to a comparison between the two.
Yes, so I was comparing both offices, and I was stating that in both jurisdictions, the grounds are the same as would be the removal of a judge from office. So that would be both offices. I was referring to the grounds of misconduct, incapacity, or incompetence.
But if I take you to section 177(1)(a) of the South African Constitution, which sets out the grounds of removal for a judge from office, then one sees, Shippo, if you just have to scroll up, I don't have the page number. Right? A judge may be removed from office if the Judicial Service Commission suffers from an incapacity, which is correct. For a judge, it's got to be grossly incompetent or guilty of gross misconduct. And you would agree that gross incompetence and gross misconduct is a higher standard than incompetence and
Yes,
misconduct.
it is a higher standard.
So in other words, in our South African Constitution, we set the removal of judges at a higher standard than what we set for the public protector.
Yes.
So it's not entirely correct to say that it's the same standard as a judge for the removal of a public protector in South Africa. It is indeed so in Zambia, but not in South Africa.
In terms of the fact that it is qualified by the use of grossly incompetent and gross misconducts, if we have to qualify that way, yes.
And I don't want to go to there at the moment, but I will tell you that the way the definition of misconduct is characterized in the Zambian Constitution, it is also different as to the way the National Assembly has crafted it in its rules. The definitions of misconduct, even without the gross, are not entirely the same. Now, as I was saying to you, the Zambian uses the Judicial Complaints Committee, and South Africa involves an independent panel. Right? Have you had an opportunity to look at the independent panel report?
No, I don't think I've had occasion to look at that report.
So in South Africa, that independent panel is like the Zambian Judicial Commission. tasked with trying to make a determination as to whether there's a prima facie case. And you are aware that that independent panel in South Africa found that there was a prima facie case.
Yes,
Okay.
I'm aware.
And you're aware that the public protector was afforded an opportunity to make submissions, to put evidence before the public protector and to deal with any allegations that was before that committee.
Yes, I believe so.
Right. And in this process, Parliament had to take at least two separate decisions. One, to refer to the committee to investigate the prima facie case. And once this committee has done its job, it has to then go back to Parliament. And so there is a process which at every stage of the way, the public protector is afforded a hearing. Do you dispute that in any way?
No, not at all.
And that is also a manner in which the Zambian process is different from the South African process. So for example, when a report is generated out of this process, before it goes to Parliament, the public protector is afforded an opportunity to provide comments to that report. That's not a similar process as what exists in Zambia, correct?
Yes, yes.
So would it be fair to say that to say that the two processes are analogous would also not be correct?
To say that,
The two processes, the Zambian process and the South African process, are not exactly the same.
no, they're not the same. I would actually even venture to say that you have a well-refined process, that you have at least 2 or 3 tiers of reviewing the process of disciplining a public protector, whereas we have, I think, just 2, but it's still with the Judicial Complaints Commission. So, yeah.
So when that Judicial Complaints Commission refers its prima facie case to the president to make a decision on whether the Zambian public protector, the hypothetical one, not you, of course, should be suspended, is it the job of Parliament to interfere with that president's functions?
In the particular instance of Zambia, because it's not the Parliament that is involved, but all the same, taking into account that the whole process has proceeded as it should, I don't think there would be any need for anybody or any branch of government to interfere.
Right. So let's work on the assumption that everything as is, it is. So if I take you back to section 194 of the Constitution. Specifically 194(3). You see, that is the provision that deals with the president's powers to suspend. And it says the president may suspend a person from office at any time after the start of the proceedings of a committee of the National Assembly for the removal of that person. And must remove a person from office upon adoption by the Assembly of the resolution calling for that person's removal. Let's look at A first. Let's assume, all things being equal, that there is no breach of any law. Let me put it to you simply as that the constitutional precepts have been complied with. Is it the role of the legislature to interfere with the president's discretion as to whether he should suspend or not?
Well, all things being equal and everything having been carried out according to the law, there is no need for the legislature to interfere.
And if the president doesn't do what the president is supposed to do, there is recourse to the judiciary. Would you agree?
Legally, yes.
Legally, you take the president on judicial review as the public protector had done.
Would you repeat the question?
So if you're of the view that the president in suspending the person from office pursuant to the exercise of his powers under section 194(3), then your recourse is to the courts to review the decision of the president.
I believe that the president is a public officer and the office can be, is subject to judicial review. So it depends on the officer. If the officer feels that there is a need to review the decision of the president, then they could submit the decision of the president to judicial review.
We don't take issue with it. In this country, the president is subject to judicial review. That's been decided years ago. That judgment to which you were referred to, the paragraph 157, did you read the judgment in its entirety?
Which judgment are you referring to?
Advocate Mpofu took you to 157, paragraph 157 of a High Court judgment, which reached the conclusion that the president had improperly exercised his powers.
I don't know if you could show me the
Sorry.
paragraph.
Give me a second. It's bundle H. And it's item.
Chair, yeah, just for the record, I did not take it to judgment. I just referred to a particular paragraph from our country in the air.
31.3.
You did you referred to a paragraph is correct from the Western Cape High Court. Yeah,
31.3.2.1.
that country in the air.
Yeah, you can get it from our documents. We uploaded it.
I am a new reference. It's H. Under Zulu-Sokoni 31.3.2.1. No, 14, item 14. (157). Page 414. I'll give you a moment to read it. That is a court judgment from the Western Cape High Court in which it concluded that the president had not acted properly or lawfully when he suspended the applicant. And I asked you the question whether you had read this judgment.
I read the judgment, but not really putting particular paragraphs to mind. So you'd have to bring my mind to bear on each paragraph as we discuss it.
And so when the suggestion was put to you that if the country acts in this manner and they act unlawfully towards, I might not get the word right, but the proposition was put to you, or it was suggested that we're running the risk of expulsion from the IOI because of improperly acting in certain circumstances. Is that correct?
I must qualify that. The International Ombudsman Institute would not lightly expel any country from the International Ombudsman Institute. And I must state here that although I'm speaking on behalf of the African Ombudsman and Mediators Association, I will just talk a little bit about the IOI. So the IOI engages, they will engage the ombudsman, they will engage the country, they would go through a whole process. I think in their history, perhaps they've only ever expelled one member. So it's something that they don't do, they don't take lightly. It's a very, very serious process.
And as far as you're aware, has the IOI commenced any, taken any steps to engage with the South African Parliament?
No, they have not.
Now, as I understand your evidence, you are not saying that the president cannot suspend the public protector, but that when the president suspends a public protector, it must be done in a procedurally fair manner.
Beg your pardon, could you repeat?
You're not saying that the president should not suspend the public protector. What you are saying is that when the president suspends a public protector, it must be done in accordance with the laws of the land, and it must be done in a procedurally fair manner.
Yes, correct.
And if ultimately the courts find that that is the case, then there would be no quibble with it.
No, not at all.
Sorry, I'm sorry, Chair, maybe I misunderstood. Is there a suggestion that the courts found that it was procedurally fair?
No, I didn't say the courts found it. I said if ultimately, yeah. So maybe to complete it, are you aware that that judgment is currently the subject matter of a reserve judgment?
Confirmation proceedings.
Confirmation proceedings at the Constitutional Court.
No, I'm not aware.
Just to be clear, Chair.
Yes,
Because I'm in that court, just in fairness to the committee. It's much more complicated than just confirmation proceedings.
Yeah.
There's confirmation proceedings in terms of 172(2)(b) of the Constitution. Then there's an appeal by Parliament and the DA. Then there's a cross appeal by the public protector, just so that we're clear here.
Thank you. Proceed, Advocate Bauer.
Sorry, in paragraph 32, on page 233 of your statement, you deal with the appointment process. And you make the statement that the public protector has the same qualifications as a judge of a high court. You see that?
Yes.
Now, let me say this, in South Africa, the criteria for a public protector is that the person must be a South African citizen and must be fit and proper. You're a lawyer, you understand what I mean when I say fit and proper.
Yes.
Correct? Now, the Public Protector Act says that there must be legal experience as a judge. For the record, that's section 1, capital A3, but I'm not going to take you to it. A legal practitioner or lecturer or experience in the administration of justice, public administration, public finance, or experience as a member of parliament. For a judge, the Constitution in 174(1) says, any appropriately qualified woman or man who is fit and proper. There's no requirement for a judge in this country to be a South African citizen.
That's not quite true.
There's no constitutional requirement, let me rephrase it, for a judge to be a South African citizen.
There is. Okay, but Chair, we can move on. It depends what kind of charge you're talking about.
We're talking about an ordinary High Court judge. Let's qualify this. Because the statement started qualifies as a judge of the High Court.
Yeah, no, okay. I don't want to debate this, Chair. It's not as simple as that. For certain courts, such as the High Court, you may be non-South African. But for example, for the Constitutional Court, a Constitutional Court judge, you have to be a South African citizen. That's
Advocate Mpo, for the statement says you must have the same qualifications as a judge of the High Court. So let's confine our conversation here to the judge of the High Court. So if we look at the provision 174.1, you will see that the person who's to be appointed as a judge must be an appropriately qualified woman who's fit and proper to be appointed as a judicial officer. Any person to be appointed to the Constitutional Court must be a citizen. So only requirement for the highest court of the land, as Advocate Pofu was helpfully pointing out, I apologize if I was misleading, has a citizenship requirement. And we know that there's what we as practitioners know as the Mohammed guidelines that says that the individual must be a technically competent lawyer. In other words, they must have a legal qualification to be appointed as a judge, right? But there is no requirement in South Africa that an individual must have a legal qualification to be appointed as a public protector. Were you aware of that?
I'm not aware of that, but the standards, the OR Tambo standards and the Venice principles put it at a minimum that at least the terms and conditions of service should be at a minimum those of a judge, which means that even the qualifications, and if it's not the qualifications, at least the status of that person and the levels of integrity. So because it's not in all countries where the ombudsman is a lawyer. For example, in New Zealand, there is no requirement for the ombudsman to be a lawyer. And I think in several other jurisdictions, but it's the standard that we are talking about here.
And that standard, which is common to both, is what you and I as lawyers understand as what encapsulates fit and proper.
Yes.
Right? Whether you've got the law degree or not, it would be that criteria that we would understand and that courts would generally understand. Sorry, I had it somewhere and I'll come to it in a bit. It's somewhere in here. Anyway, I want to come back to this fit and proper standard in a bit. But in Zambia, to become the public protector, you must also qualify. You must have the same qualifications as for appointment of a judge.
That is correct.
Right? And you must be a person of what they call proven integrity. And you must have been a legal practitioner in the superior courts for a minimum of 10 to 15 years.
Yes.
So there is a more stringent requirement in Zambia than in South Africa. So, for example, the public protector in South Africa would not have been appointed as a public protector in Zambia because she would not have had the requisite, as I understand it, 10 to 15 years experience in a superior court as a practitioner.
Well, if you say so, yes, I suppose.
So, in other words, the criteria for the qualifications required by a South African public protector is not the same as what they would be in Zambia. Do you agree with that?
Well, for the fact that there is references to a judge in the provisions, that is the reason why we equated both offices to have qualifications that are equated for a judge before one can be considered to the office of ombudsman of either country. However, of course, if you go into the technical details of the framing of the different legislations, you're bound to find some differences, you're bound to find some similarities.
That's correct. But
Yes,
the analogy between a public protector and a judge comes about, or I'm assuming it comes about, tell me if I'm wrong, is because of the analogy which exists in the Zambian environment in the way that's couched, which is absent from the South African legislative regime.
I think when doing this paper, I also looked at the issue of the terms and conditions of service. I think in your legislation, I think it should be in the Public Protector Act, where it's is that the conditions of service should be equated at a minimum to those of a Supreme Court judge. So according to my understanding, if you are willing to accord a person the terms and conditions of service of a judge of a Supreme Court, it must be a person who is sufficiently qualified to be appointed as a judge. So I think that is the reason why I was looking at I looked at it holistically.
But that will come to conditions of service at the moment, but you would agree that conditions of service include a number of issues such as your term, your remuneration, your leave, your conditions under which you are engaged or employed, depending at which level you are at, correct?
Correct.
And one can understand that you do not want a public protector in office at a salary which is so low that makes the office of the public protector susceptible or vulnerable to what is the word I want to look, undue influences given the job that the public protector
That is
doing.
correct.
Would you agree with that?
Yes, I do.
And so
agree.
you would say, let's pitch it at the same level as you pitch it for a judge, because you also don't want the judge to be susceptible to those kinds of undue influences.
That is correct.
Now, let me just deal with this fit and proper for a moment. All right. We earlier on, we talked about independence and impartiality. That's non-negotiable, correct?
That is non-negotiable.
High standard of professional ethics, transparency, lawfulness, those are also non-negotiable.
They are not negotiable, but a person in office is a human being, so there may be lapses here and there, and that is the reason why the decisions of an ombudsman can be subjected to judicial review.
So let me put it to you this way. If you want to decide, and when you consider whether there has been misconduct or whether there has been incompetence, you must have regard to these standards and duties that you expect from a public protector.
That is correct.
Whether you couch it and give meaning to it as fit and proper or as other standards, you can't ignore those. Would you agree with that?
No, you can't ignore those.
Now, we had a conversation, you had an exchange about this binding effect of court judgments. And there was some suggestion about making public protector reports or decisions. Sorry.
Just getting water to Ms. Sokoni.
Yes, you may
Sorry.
continue.
Now, there was some suggestion that when you make public protector decisions binding and enforceable, you in some way make the office vulnerable or you in some way impugn the independence of the office because you make it susceptible to interference. And if I'm not understanding this correctly, please correct me. You make it susceptible to interference by the judiciary in the decisions taken by the public protector.
Not necessarily by the judiciary, because in both instances where you have a classical ombudsman and a hybrid ombudsman or an executive ombudsman and a parliamentary ombudsman, the decisions can be subjected to judicial review. So what is a problem with the binding power? It's a problem with the executive. So the public protector is going to go in and investigate day-to-day office functions of a respondent institution. And where the findings are binding, and you see, because the ombudsman has got a wider mandate, a law enforcement institution will go in and investigate a specific complaint. But when the ombudsman goes in, they can widen the net of their investigation, and as much as they want, they can pick up documents without necessarily going to a court of law. A law enforcement agency would need to get an order from a court in order to come and pick up documents and search, but the ombudsman can go in. So in that, because of the nature of the job, you find that the executive panic because they know that when the report comes out, it will be binding. So we are saying it is the impact on the executive, which may cause them to try to compromise either the ombudsman or try to compromise with the judiciary. It is just the way it is. It's the nature of the office. So it's not that we are saying that the judiciary itself may want to interfere with the office of the ombudsman, but because it's a binding decision, and it's sort of like, for them, it's like you're creating parallel court system, and that cannot be. Of course, you and I know that cannot be. The courts are the courts, and they dispense justice, and that is their duty. So you find that there may be a lot of decisions that may be going against an ombudsman in that respect. So it is just for the protection of all the arms of government that an ombudsman is really, the systems are encouraged to not give the ombudsman binding powers. It's just the uniqueness of the job.
It also gives the ombudsman power to make sure that its reports are complied with.
So,
which is the converse of that coin.
Yes. So now the reports must be complied with, and this is an argument that we have also been having in Zambia. That, for example, the Auditor General, our Auditor General in Zambia, tables reports before Parliament, and then the respondent institutions are called to Parliament to answer to the committee that deals with financial matters. And then they are compelled by the committee to either adhere to what the committee orders, or the matter is taken. And I think in our financial provisions now it says that any recommendation from the Auditor General has to go also to the law enforcement agencies. It's a requirement. So we have been also requesting for that we should be able to table our reports before a parliamentary committee and have our reports enforced by way of the parliamentary committee. So we have binding powers now. We've been given binding powers, so we don't need to use the legislature, and our act does not even require us to table our reports. It's just for notification of Parliament. We just send our reports to Parliament, and it's just for them to say, oh, yes, we have received, and they can comment if they want to. But then that's the way it is.
So there seems to be two notions that seem to arise from that. One, that it results in unwanted or unwarranted attention to your reports because you have binding powers. And two, that it automatically gives rise to costly litigation. But in the second, you've said that that hasn't been your experience in Zambia.
Ever since we're given binding powers, now respondent institutions can take us to courts. And there's been just that one instance when the respondent institution took us to court. But then, like I said, it has made us up our game now, because we have to ensure that we interrogate each and every submission when we are carrying out our investigations, to ensure that we don't get called up by the courts for judicial review because a respondent institution is not happy.
So let's test this, take it one step further. There's an assumption to be made here that you only get taken to court because the recipient executive authority or government department is not happy. But do you also accept that if you get taken to court and the court finds that you did not comply with your legislative regime or you didn't give implicated parties a hearing, then that can't fall to the fact that your order is binding. That goes to the fact that you were derelict or didn't do your job properly in the first place. Would you agree with that?
I would not agree with that, because even a court can find against a particular party and that party can appeal. It does not mean that the court has not done its job properly. It's just an issue of the judgment of that court being reviewed. And that is the way that the reports of the Ombudsman also must be taken. When the matter goes for judicial review and the matter is reviewed, if it goes in the favor of the Ombudsman, well and good. If it does not, it's a duty of the Ombudsman to interrogate that judgment and ensure that they don't repeat the sort of errors that were caused in that particular report. Like I said, the concept of having the reports of the Ombudsman being reviewed by the courts is a cleansing process. It's a quality control process.
So you presuppose in your hypothesis that the public protector looks at the judgment, fixes what's wrong, cleanses her office and goes on. But let's take a hypothetical, for instance. What if the next 10 reports after that judgment reflects that the public protector does exactly the same thing? Can you then say there's a cleansing process?
I wouldn't expect that an Ombudsman would commit the same mistake. I wouldn't expect that.
That's not what you expect and what you don't expect. One of the, if a implicated person has come and taken the Ombudsman to court and said, you didn't give me a hearing before you made a finding against me. And a year or two later, that very same person is again the subject matter of a report. And he comes back to court and he says, again, the public protector has issued a report and did not give me a hearing in respect of that. Now, if that actually happens.
Well, the courts can still take the matter further within the judgment. They can note it. I mean, it's not good for the reputation of an Ombudsman, definitely, to have judgments coming out continuously on the same issue, especially on the same matter, the same error, the same mistake. Obviously, I would take it serious and I would ensure that that error is corrected.
So if there are judgments that repeatedly come out with errors of procedural irregularities or non-compliance with natural justice, and there's no cleansing process as you put before the committee, what do you expect the watchdog of a public protector to do?
Same mistake, same error.
Same mistake, same error, repeatedly happening. I'm taking this to you at the hypothetical level because I don't want a suggestion that I'm misrepresenting. I'm talking to you at the level of principle.
Yeah, we're still on that general, so that I'm reminded now that you wanted specifics when he was on general, so let's stay there. The general. Thank you, Advocate Power.
Okay, so I think, let me put it this way. It's a self-cleansing process because the respondent or the complainant has got the right to go to a court of law and appeal to the courts to say this, there's been this injustice by the public protector. And I think through the process of appeal and through the court judgments, it is sufficient, I think, for the ombudsman to perfect their trade and ensure that they don't carry out a similar mistake. But I don't know, with the watchdog, the oversight responsibility of Parliament. I'm trying to compare it with our jurisdiction. I think it's different. The system is different, and in the way the laws are set out. I don't think there would be an instance where Parliament would interfere still with the operations of the Office of the Ombudsman.
And let's take this to, so on the hypothesis that you've answered now, when the poorest of the poor reports to the public protector and they aggrieved by what the public protector does, and let's assume there's 10 or 20 poor people that come to the public protectors, their last resort, you're saying if you don't like it, you must go to court. You can't go and complain to Parliament, and Parliament as the oversight can't do anything about it. Is that how I understand what you're saying?
No, they can go and complain. I think that is your system here in South Africa. They can go to Parliament. I'm saying, comparing it to our system in Zambia, I think a person who is unhappy with the professional conduct of the ombudsman would equally go to the Judicial Complaints Commission. That is the mirror reflection that I can give you of the way the process would happen. But it would have to be a complainant to go to the Judicial Complaints Commission. It would not be any of the branches as a branch of government to say, oh, the judiciary submits a complaint against the public protector, or the legislature submits a complaint against the public protector. I think that is where the fine difference is, that it must be a member of the public, a person who has an interest, who complains. So I don't know if that answers your question.
Partially. And there would be nothing which stops a political party from complaining.
They can complain.
I just want to quickly take you to the Indeni judgment. I'm assuming that is the one judgment you're referring to.
Yes.
That came out. And I know you were, it's in bundle F now. And it's item number 176, right? As it was put to you in evidence put to you that you can't really blame the Zambian court because they were misled by the South African court. That was what was put to you yesterday.
Sorry?
You put the
Chair, because
proposition,
I'm the one who's being quoted now, so I want to hear properly.
Hear properly. Okay.
Yes.
Just
Advocate
read that
Mpofu, you-
advocate Bauer.
Yeah, it was
put
put,
you put the proposition in passing and the witness didn't answer. That you couldn't really blame the Zambian Constitutional Court because they were misled by the South African court.
no, I never said anything of that sort.
Am I, well, let's leave it at that. You didn't say that, okay? Now,
Yeah, maybe if I may just be of help, Chair. Yes, I said that the Zambian court in that case relied on our case Home Affairs versus the public protector. And what I said I couldn't blame them for, if you're talking about this morning, was the issue of the reviewability versus non-reviewability, which is separate from the question of the binding or recommendation regime. I think the last thing I said about it was that the Home Affairs case was not really about the powers of the public protector, but about whether the public protector is an organ of state and therefore susceptible to perjury. That's.
my apologies, Advocate Mpofu, if I misconstrued what you said yesterday. But when we argue the matter, we can. look at
Apology
it.
accepted, Chair.
Now,
Thank you for sorting each other out. Proceed, Advocate Bauer.
my apologies, Chief, for not going through.
Proceed.
The way the judgment is set out is it first sets out what each counsel has argued to the court and the arguments that's been made. And one of the counsel had in effect argued and relied as one of the grounds what the South African court had found in respect of it. But if you go, let's just use you have a hard copy of the judgment there. I want to go to, it would be what's 5, you see the 484 reference on top. Look for 511. The page and the number would be J28.
Chair. Again, I don't want to make a big fuss about this, but I just wanted to record that this judgment was not given to us until about tea time. But and I raised it very sharply with my learned friends.
Tea time today.
Yes,
Okay.
but on the basis, I just let it go. But I'm just placing it on. I let it go
Okay.
on the basis that well, we had referred to it, and the witness also referred to it in her speech of last year. But it should have been given to us earlier. But I'm leaving it there.
Okay. That's been placed on record. Thank you for that. Advocate Bauer.
Yeah, it was referred to, but that wasn't the reason. I would have passed it on to my colleague had I had a hard copy. It was an oversight, but I mean, it was referred to. So it wasn't as if there's any prejudice because you were the applicant qua public protector in this matter. Isn't that so? Right. And so,
Well, okay, Chair. Sorry, I do accept the apology, but I don't accept that qualification that there's no prejudice just because she was the applicant. I was not the applicant. I was talking about professional courtesy.
no, I was,
Let's stay on the apology. Apology
yeah,
accepted.
the prejudice is the witness, not to you.
Thank you.
If we go to J28, the court says we have considered the written argument. Go down to the second last paragraph. It says 511 on top.
511.
Yeah. Just go down again, please. Down. No, 511. I want to get to the second last paragraph on the page. The highlighted bit. The court says we've considered the written arguments and oral submissions made by counsel on both sides, as well as the authority cited. They have to determine 2 issues in this matter. One is that the Office of the Public Protector ranks equivalently with the High Court. And on the basis that it would so rank equivalently, there's an argument to be made that it's not amenable to judicial review by the High Court. That was the issue before the court.
Yes.
Right? And so what the court then does in this judgment is it in the first instance, if you see paragraph 13, it repeats that and they say they will consider 513. That's it. They set out the issues and they say they will consider it in that order. And they then on that page detail what they have regard to. The relevant provisions of the Constitution, the Zambian Public Protector Act, on the establishment functions and powers of the Public Protector. They've considered the constitutional provisions and the provisions of the High Court Act, Chapter 7 of the laws of Zambia, relating to the establishment, jurisdiction, and powers of the High Court, as well as its practice and its procedures. And then in the next couple of pages, it sets out a number of those legislative provisions that it then considers and discuss. Right? And if we come to 518, it says an examination of the provisions of Article 243(1) and 2 of the Constitution reveals that although the office of the Public Protector is created by the Constitution, and although the qualifications for appointment as Public Protector are the same as those required for appointment as a judge, the Public Protector is not a court and does not perform adjudicative functions as a judge of the High Court. The Public Protector's role is completely different from that of the High Court as shown by the functions of that office, which in terms of Articles 244(1) and 2 are to investigate an action and decision taken or omitted to take by a state institution in the performance of an administrative function, which action is unfair, unreasonable, illegal, or is not compliant with the rules of natural justice. Further, in terms of Section 6 and 13 of the Public Protector Act, the Public Protector mandate is to investigate allegations of maladministration by a state institution. The court then concludes with references to the provisions of the Constitution and the Public Protector Act that the jurisdiction of the Public Protector Act is specific. It's restricted to investigations of allegations of maladministration, and as already observed, it's different from the jurisdiction of the High Court, which has unlimited and original jurisdiction in civil and criminal matters, appellate and supervisory jurisdictions, and jurisdictions to review decisions in accordance with the law subject only to the article. Would you agree? They come to this finding on the basis of a look and an interpretation of the Zambian legal provisions.
Yes, although they did consider the South African.
We're coming to that in
authority as
a
well.
moment.
Yes.
But even if they didn't consider the South African case, they come to that conclusion based on their own Zambian's legislative thing. They go a bit further. They then say, in the South African case, which is then referred to by one of the counsel in the matter, cited by the respondent, the Supreme Court of Appeal of South Africa stated the following regarding the Public Protector of South Africa. Public Protector is not a court, does not exercise judicial power, cannot be equated with a court. Her role is completely different to that of a court, and the jurisdictional arrangements of the courts are entirely irrelevant to the determination of the Public Protector's jurisdiction. And then, as the Zambian court did, the South African court looked at the provisions of the Constitution and the South African Public Protector Act to ascertain the bounds of the Public Protector's jurisdiction. The two constitutional courts, or the two courts, performed the same exercise in different jurisdictions. Correct?
Correct.
And then they say, similar, in the case of Zambia, it is evident that the Public Protector is not a court based on Article 20 of the Zambian Constitution, which states the composition of the judiciary does not include the office of the Public Protector. Correct?
Yes,
Right.
correct.
And so without belaboring the point, they then come to the conclusion that because you're not a high court, you are subject to judicial review on your decisions that are binding.
Correct.
Correct? And I won't take you through But go to 5.23 of the judgment. Page 523. They consider whether you should be amenable to judicial review by the courts and the public protectors. And they come to the conclusion that it is settled law that judicial review lies against an inferior court. Go down. Down. And against any person or bodies which perform public duties. Go down. Or public functions, as was held in Ridge versus Baldwin. The office of the public protector is a public office, and they then define it. Go down, and they say further, it is undisputed that the public protector performs public functions. Since we have determined that it's not on par with the High Court, it follows that as a public office, it must be amenable to judicial review. Right, and the argument was made by your office that the public protector should not be amenable to judicial review because the office is independent. And that argument, your constitutional court rejected, correct?
Well, according to the judgments, yes.
According to the judgment, yes. Right. And as you indicated earlier on, this was the only judgment. There wasn't anything after this to say something to the contrary. Right. Now, go down. And here the court then concludes that the exercise of the power of a court to review the decisions of the public protector does not impugn the independence of the office of the public protector. Correct?
Correct.
So the review emanates from, and if you go to page 526, just to put this to bed, just after the quote. In determining this matter, we have found South African case authorities regarding the status of the public protector in that country helpful, in that they clearly state that the public protector is subject to judicial review. So the Constitutional Court doesn't put it any higher than saying, well, we find the jurisprudence of South Africa helpful, but in its own, the Zambian law does allows for. Am I correct?
Repeat the question, please.
So it's almost an obituary remark in the judgment that the South African authorities are helpful. Prior to coming to the South African authorities, based on Zambian law, the Constitutional Court already concludes that the public protector is subject to judicial review.
Yes, that is exactly the reason why I actually quoted this judgment to show that precedents across the region can be used to help to build up jurisprudence in the regarding the concept of the Ombudsman, and it's really, really very important that we build up such jurisprudence, and this is the reason why I quoted this judgment.
No, it is so. But the point I'm trying to make is that the conclusion is reached by the Zambian court. Even if that South African case wasn't there, the Zambian court was likely to come to the same conclusion.
But the South African judgment was of persuasive value, and that is the reason why they quoted it.
I'm not okay. If we go to paragraph 20 to 22 of your affidavit, you take the view, let me just see if it's the report or the affidavit. It's 210.
Paragraph 22.
20 of the general affidavit. It's where you put forth the view that it's what you explained earlier on your affidavit. We've already said it offers you some protection from the executive, and that an ombud can only have a complete independence from interference if the reports go no further than a recommendation. It is also so that irrespective of whether you have a recommendation or a binding effect, if there's a desire to interfere with the public protector's report, that would happen.
As I have said, this is a tried and tested system which has been going on for 200 years or so. I'm sure there were jurisdictions even within the Scandinavian era where they may have tried to give binding decisions to the ombudsman, but they found that it was not working. So this is the reason why you find that all the standards reflect that the ombudsman must, the reports of the ombudsman must only have the effect of a recommendation. As I said, it's a way of using soft power and suasion to make the respondent institutions comply, and where they do not comply, Parliament then comes in to enforce. And Parliament enforcing is also a good cleansing system for the ombudsman, because where the ombudsman appears conflicted, that report is going to sit before Parliament, and it gives a chance for Parliament not to be the complainant against the ombudsman institution, because the ombudsman is tabling the report before them, and they are able to say, and it's mere recommendations, they're able to say, ombudsman, we reject your reports. The ombudsman can go back, redo the report, and resubmit. They're able to ensure that all the standards that we are talking about in ombudsmanship, impartiality, independence, and all the other processes that the principles of natural justice have been followed, Parliament is able to screen and quality control. And there would be no need for a process where Parliament is actually the complainants, because they quality control themselves. They ensure that the standards are being met, the standards of the reports.
That is in the Zambian system, correct?
Zambian system, we issue binding reports. I'm talking now as in the AOMA representative say, and talking about the standards, the ombudsman standards. I'm saying if you look across all the documents that we have presented, they're talking about recommendations, and I'm saying it's because it's a tried and tested system.
So in other words, if I understand you correct, you're a proponent of the recommendation system, whereas the parliaments of Zambia and South Africa have chosen a different system.
That is correct.
Right. Okay. But you also accept that the mandate of the public protector has been strengthened in Zambia by making the recommendations issued into final reports binding. Because that is said in paragraph 38 on page 238 of the statement.
Paragraph
38 of page 238. The mandate of the public protector has been strengthened by making the recommendations issued in the final reports binding.
Yes, the mandate, the aim of giving binding decisions is to strengthen the institution of the ombudsman, but it's a double-edged sword. It comes back to bite the ombudsman. So as I have said, for us in Zambia, what we have done is just to ensure that each and every report that it is coming out, we ensure that we really interrogate each and every standard to ensure that it's there. But, you know, there can be an instance, and there will be an instance where, again, we come up with a finding which may not be acceptable to a respondent institution, and we may have to go to court again. Again, we've tried to avoid going to court. We don't have the sort of funding that can allow us to keep on continuously litigating. And again, even I think if I may state that how should I put it? An office becomes more actually challenged to go out and investigate even the most sensitive of cases, because you know that you don't have that binding power effect. And when the report comes out, it is Parliament that is supposed to ensure that the report is enforced, the recommendations are enforced.
I want to put to you that you look at this from the premise of a diligent public protector. Because a diligent public protector—
Would you kindly repeat?
You look at this from the perspective of a diligent public protector, in the sense that, and again, I put this at the level of generality without making any reference. You have said that because this report is binding, we make sure and we work hard at ensuring that our reports comply with all the requirements. But the flip side of that is, if you're not a diligent public protector and the reports are not binding, you may very well just ignore what you're supposed to do and just hand out sloppy reports. Would you agree that that is also a danger which public protectors run into? I'm putting this at the general proposition. In other words, I want to say to you that there's nothing's cast in stone. There are pros and cons to both systems.
It will really be at their own peril to do such a thing, because again, it goes back all the way to your vetting system, when you have an ombudsman put in office. And then maybe I should state that for ombudsman institutions, really, there is no training school, you know. You get into the job and you start learning on the job how you're supposed to carry out your duties. And this is the reason why we even saw the need that we have to have this association where we have the tailor-made courses. We have newly appointed ombudspersons coming to these courses. And we engage them. We try to find out what problems they are having when they are in their operational problems. And in fact, if I may speak for the IOI even has a fund for each region where they ask each region to say, what problems do you have? What challenges are you facing? What do you need help with? Is it report writing? Is it having an investigations manual? Is it investigations procedures? So it's a continuous learning curve for the ombudsman, you know. So even for when a report is prepared, for example, I'll give you an example. When a report is prepared, that the report has to go to all the parties, respondents, plaintiffs, you know, it has to be circulated to all the parties. If they make any comment at all, it comes back. If they make any comments and you incorporate those comments, the report goes out again until everybody is agreed that the report is as it is. So these are standards that ombudspersons have to learn, because some ombudsman will just say, okay, I've sent out the report, people have commented, now issue the reports. You know, so principles of natural justice have to follow each and every stage. You have to follow at each and every stage.
Well, let's test that with you for a second, because again, reports have to go to people who are implicated. They get an opportunity to comment, and the public protector must take those comments into account. I think those are first principles. We don't take issue with that. But let's assume an implicated person comes up and say, well, you didn't give me an opportunity for whatever reason, whether it was a bona fide error, whether it was deliberate, I am implicated and I didn't get a hearing. That would be a basis if you went to court for a court to set that report aside. Would you agree with that?
Yes, yes.
Right. Now a court comes, the parties are agreed that X didn't get a hearing. The report is set aside. The public protector then appeals that report and the decision of that high court right up to the constitutional court. What do you then make of that?
Well, the public protector may appeal if they feel that they did not get justice in a particular judgment. I know for speaking for ourselves, we did want to appeal in any case, but we didn't have the resources. We had to pay. These were private lawyers that we had engaged. We had to pay them, and we didn't have the resources to pay them to take them up to the next level because we're not satisfied. But that is just.
And if you've lost at every step of the way up to the Constitutional Court, your application for leave to appeal, your petition to the Supreme Court of Appeal, your reconsideration by the Judge President of the Supreme Court of Appeal, and by the Constitutional Court. And you don't do that in one case, but you do that in more than one case.
I would then think it's time to rethink the system. You must move away from binding decisions to recommendations, because what if the next ombudsman who comes in does the same, and the next ombudsman who comes in does the same? You have to rethink the whole situation.
And you don't think that an ombudsman who must have the same qualifications as an experience as a judge must at some point realize that maybe I got the law wrong?
The ombudsman does not operate in isolation. And I think they do seek out legal opinions. They do seek out the counsel of the legal officers and investigations officers within their offices. I wouldn't be able to say off the cuff that is the decision of just one person, but because we are looking at the ombudsman as a legal entity, so we always ascribe all the blame to say the ombudsman didn't do this, the ombudsman didn't do that, but ultimately, I think
who's ultimately accountable?
Okay, can we pause there and then you come back? We'll take a 15-minute break for tea and we'll continue after tea. Thank you.
Recording stopped.
Until Patabas, thank you. We're getting both. Welcome back, colleagues. We're just waiting for Heidi. And thank you. Advocate Bauer, back to you.
Mr. Sokoni, I want to take you to the presentation or the paper you presented on the 21st of September 2021, the one that Advocate Mpofu took you to. And I want to start by saying that I'm taking you to this paper to show you that the paper reflects the South African law erroneously. And so let me have this discussion with you in that. So now we're going to have a bit of a reference problem because I didn't use that, but I think it's page 6 where you discuss, just count the pages. Yeah, that's page 6 of the actual article. Where you discuss, yep, it's for the record, it's page 336. The case of the economic freedom fighters versus the speaker, where you say the mandate of the PPS was strengthened when recommendations were converted to judgments, and you then make the statement that before the judgment, it's just 2 lines from the bottom, just move it up, Shepherd, so you could see the sentence, right, the last sentence. Before this judgment of EFF versus the speaker, the remedial recommendation of the public protector has always been taken as a mere recommendation, which protected the public protector from litigation from government departments, which was not happy with findings of the public protector. You see that?
No,
It's not from the bottom of the screen, it's about 8 lines up. There we go.
before this judgment, yes.
Now, I'm going to put to you that this judgment was handed down on the 31st of March, 2016. The appeal court in the judgment of SABC versus the Democratic Alliance in October 2015, which was prior thereto, had indicated the following, that the language, and it's paragraph 52 of the judgment, which I'm not going to put up, I'm just, where it was accepted before that court that the public protector's report, findings, and remedial measures could not be ignored. In other words, it was more than a mere recommendation. Were you aware of the DA versus the SABC versus DA judgment?
No.
If we go to what you say about the CX case, which is further down, page 6, 7, yes, it regarded, it's the latter report regarding the Reserve Bank of South Africa. And I want to, go down again. Go down. You discussed this case, and I want to come back to the facts of the case, but I first want to take you to the part where you say the most concerning part of the public protector's report. 8. You have to go down. I'm not. It's down. I have it in the middle of the paragraph. It ends with resolution of the PPSA. So let me just help you, Shepherd. Maybe highlighted. It reads, the most concerning part of the public protector's report was because of, and since the Nkandla case, the remedial action proposals contained in the public protector's report had now become binding, and the Reserve Bank and the legislature would have been compelled to comply with the remedial action resolution of the public protector. Correct? You see that?
Yes.
Now, one of the remedial actions in this case was a recommendation. Well, let me not paraphrase it for you, but give you the actual wording. If you go to bundle A, page 70. Yeah. Let's just look at what the public protector actually said. Paragraph 7.2. Page 70, paragraph 70.2. Here's 70. I want to go, just go up. 7. Yeah, there we go. Stop there. You were taken to this issue of a constitutional amendment. Do you recall Advocate Mpofu discussed with you whether the public protector had the power to recommend a constitutional amendment? And you agreed with him. It was put to you that the public protector is entitled to make recommendations, and you agreed with him.
Within the framework of the standards that I had quoted, I'd say that in some jurisdictions, especially in Europe, the ombudspersons do make recommendations for the changes of laws. I think you saw it under the Venice Principles.
That's correct.
So it was in that regard that I answered in the affirmative.
In fact, it's healthy in a democracy that anybody can make a recommendation to a parliament if they think that there should be amendments made to laws of the Constitution. Would you agree with that as a general proposition?
Yes, if it's a recommendation, but when it's binding, it becomes a problem.
Well, when you issue a report, well, let me take you back to first principles as a lawyer. Before we get to what's on the screen, Ms. Sokoni.
Yes, please.
When you, as a lawyer, you and I would understand that the use of the phrase must indicates peremptory language. In other words, you must do it. Would you agree with that?
Yes.
Right. So when the public protector, and we now in the CX case, and we now post EFF and Kandla, and we all know that the public protector's reports are binding and everybody must now comply with it. Correct?
Correct.
Right. So when the public protector issues a report that says the chairperson of the Portfolio Committee on Justice and Correctional Services must initiate the process that will result in the amendment of Section 2224 of the Constitution in pursuit of improving socioeconomic conditions of the citizens of the Republic by introducing a motion in terms of 73(2) of the Constitution in the National Assembly and thereafter deal with the matter in terms of Section 74, 5, and 6 of the Constitution, and then goes along and tells the Portfolio Committee of Justice and Correctional Services what that amendment should read as. Would you agree that in the context of South Africa, that is not a recommendation? That is a binding on the legislature by the public protector to amend the Constitution in a particular manner?
Yes, in the specific case, because the public protector issued this as a binding report.
Yes.
Yes. However, I don't know if before this report was issued, whether there was consultation with the...
Absolutely no consultation. The provisional report that went out had made no mention of a constitutional amendment. That is common cause. The constitutional amendment came in afterwards and there was absolutely no consultation.
So I would have expected that learning a lesson from this one, if the matter went to court, obviously the matter went to court, and I'm sure her decision was declared ultra vires. So it should have been a lesson learned for the office of the Ombudsman for future reference to ensure that if there was an ultra vires action, then it would not be taken in future. As I said, the Ombudsman work, there is no course book or directory that tells you that this is the way you're supposed to do your work, and you're supposed to apply the standards accordingly. So I do agree with you, as you have stated.
So the public protector opposes this relief sought. Well, I think initially abides by the relief and then later opposes the relief, and there's an order taken. The report, the remaining parts of the report is the CX judgment with which you agree with the minority judgment. This is the abscess CX matter dealing with the amendment of the Constitution. Do you recall?
Yes.
Right. Now, precisely which parts of the minority judgment do you find yourself in agreement with? Because it's a very complicated and lengthy judgment, but if you can, maybe without just telling us you agree with the minority judgment, give us some idea as to what precisely you agree with.
Yes, I would state that the minority judgment departed from the other judgments precisely because of the 15% personal cost award to the public protector. And it is with that respect, that is, I think, where I took issue with the judgment of the other judges. So I think it was enough for the court to say either the actions of the public protector were wrong, were unconstitutional, and award costs accordingly, but to award costs personally, the cost of a whole entire institution. We're talking about the Reserve Bank of South Africa here. To award the cost of an institution against an individual who was performing official functions during the course of an official function. And secondly, that person was not even a party to the whole action. I think that is the reason why I agreed with the minority judgment.
You then further state in this paper, which just disappeared on us for a moment there, but maybe we'll go back to it for a moment. You say that, you see, this judgment wasn't just issued in favor of the South African Reserve Bank. In fact, I have it and I've checked on it. The South African Reserve Bank did not claim the 15% from the Public Protector's Office, but there were other parties in this matter who had incurred legal costs. For example, Absa Bank, who's not a government body, who may have deep pockets or maybe a banking institute, but they're not an organ of state, or they are litigant before court, or if a court orders costs, would be entitled to those costs. So you go further in paragraphs, page 7, you say, the majority judgment ordered the public protector to be held liable for 15% of the legal. Sorry, I'm in the article still. Go back to the article. 12, yeah. Right? For procedural errors, which would have been easily corrected, that the public protector's appropriate remedial action conclusions be left at the level of recommendation and not binding decisions. Yeah. I think you must go up. 7. Go down a bit. No. The pub, well, it's in the middle again. So go, just, I think you must go down and see if there's another paragraph. Now go back up. It is page 7. So must be above the quote. Yes. Go up. No, sorry, let me just find it for you quickly. It's 337 first. Yeah. The South African Constitutional Court in a majority judgment delivered on the date upheld the High Court order issued in February 2018 for the public protector to be held liable for 15% of the legal fees in the case of the public protector for procedural errors which would have been easily corrected had the PPSA's appropriate remedial action conclusions been left at the level of recommendations and not binding decisions. Now, can I put to you this? We seem to be blaming a system and not the person who incurs the errors or the institute or the person who incurs the errors. Every answer seems to be that when there's a mistake, it's because these decisions are binding, as opposed to, should we not explore why these mistakes occur and whether they are bona fide mistakes or whether they have other motives behind it?
I recently issued a report regarding land management in Zambia. And in that report, I actually quoted a whole act, I think, that had been repealed. It had already been replaced by another act, but because our law indexes didn't have the new acts, I actually issued the reports. And then I was advised by the particular sector, I think it was to do with building regulations. And I had even sent that report to Parliament. And I was advised by that particular sector to say, you have quoted the law wrongly and you have misapplied it. And because they brought it to my attention, I called for the reports back, and we are in the process actually of doing the corrections. We haven't reissued the report again. We're in the process of doing the corrections, but my office has binding powers. But because it was still in the process of circulation, I was able to recall the report. So this is why I'm saying these mistakes can happen. But if you apply the appropriate principles, there is no way that you can, have a situation where you're actually litigating over and over again over a matter.
I want to just read you a few of the paragraphs of majority judgment.
Yes.
And I want to say to you, on a reading of the majority judgment, the court's decision wasn't simply based on what you refer to as procedural irregularities. And so I'm going to give you the paragraph references and hopefully Shepo can get to us there in time, but just to do that. In paragraph 146, the court says, personal cost orders are granted when the representatives show a gross disregard for their professional responsibilities and where they acted inappropriately and in an egregious manner. Let's take the public protector out of the equation. If it had been anybody else before court and the court found that they showed a gross disregard for their professional responsibilities and they acted inappropriately and in an egregious manner, and the court exercised its discretion on a cost order, would you take issue with it?
I beg your pardon, rephrase the question, please.
Let's assume the litigant is not the public protector. Let's assume the litigant is, let's see, anybody else. Any litigant before the Constitutional Court.
Yes.
All right? Let's forget about the facts of the matter for a moment. But whatever is before that court on affidavits, and the court concludes the following in respect of that litigant, that you showed a gross disregard for your professional responsibilities and where you acted inappropriately and in an egregious manner, would the court be entitled to show its displeasure in its cost orders that it awards?
I think for me, it would be sufficient for the court to declare that the particular subjects had acted ultra vires their powers, and to either reverse, review, But to ascribe personal costs and the personal costs of an institution to an individual, I really, and especially being the ombudsman, this is why I said that who was aggrieved in this matter? It was the parties, whether it was the Reserve Bank, ABSA, they were the aggrieved parties. And they go to the court and say, we seek redress in this matter. And then against a person who is acting in their official capacity. Then the courts effect personal costs award on a single individual against this institution that is complaining, and this person was acting in their official capacity. I wouldn't agree with that.
But a court is entitled to exercise its discretion and issue court orders. And those who appear before this court must obey those court orders. Would you agree?
And what was the result of that? Personal cost award kept on following her.
Now, well, let's come to that in a moment, all right? Under the Zambian constitution, a public protector can be removed from office for gross misconduct. We'd already agreed on that.
Yes.
And that gross misconduct includes behavior that is prejudicial or inimical to the economy or the security of the state. That's what you're correct?
I haven't read
That's
that.
Article 266 of your constitution. Gross misconduct includes behavior that is prejudicial or inimical to the economy or the security of the state. Now, would you say conduct that causes a significant depreciation in the currency, in the Zambian currency, to the point of where the country loses billions of rands, would be regarded as behavior that is prejudicial to the economy?
Well, I suppose so. It would depend on the facts of the case. It could be in error. It could be deliberate. I don't know.
So in the circumstances of what's before the Constitutional Court, the public protector issued a final report in circumstances where the Reserve Bank had specifically asked for an opportunity to look at the report to ensure that there wasn't harm to the economy. That was not adhered to, and the report was not provided to the Reserve Bank. This resulted in a significant depreciation in the rand and the sale of by non-resident investors of 1.3 billion rand worth of South African government bonds. Now, on the Zambian test, that could conceivably fall within the category of gross misconduct on the level of principle. Would you agree?
According to what you have read, yeah, I suppose so, because I haven't read.
Let's assume I'm correct on what Article 266 says. Let me take that a step further of what the court says. The court says personal cost orders are against those who exercise public power when they act in bad faith or they act in gross negligence. At the level of principle, is there something wrong with that reasoning?
No.
The court then goes further and it says, the public protector's explanation of the meeting with the state security agency is not only woefully late, but almost unintelligible. Would you expect the public protector to put explanations before court that's unintelligible?
I would have to look at those explanations. I don't know what the court is calling it unintelligible,
but the court is calling it unintelligible. This is the court's ratio and the basis upon which it made its cost order. So this is its reasons for the cost order. In paragraph 205, it says, in this court, the public protector has contended that the adverse findings made against her by the High Court were based on innocent errors on her part. The public protector's persistent contradictions, however, cannot simply be explained away on the basis of innocent mistakes. This is not a credible explanation. The public protector has not been candid about meetings she had with the presidency and the state security agency before she finalized the report. The public protector's conduct in the High Court warranted a de bonis proprius personal cost order against her because she acted in bad faith and in a grossly unreasonable manner. Now the court finds contradictions, lack of candid explanations, and a response to the High Court that was extremely wanting. And on the basis of that, it refused to set aside the High Court's cost order. What is your comment on that?
I still am of the view that any action which causes an ombudsman to be punished by the respondent institution, because the award was to the respondent institution in her personal capacity. That is where I have the problem. If they had awarded the costs against the institution, it would still have hurt. It would have still been a mar on her professional integrity and reputation.
Just a pause, Advocate Bauer. I recognize Advocate Mbofu.
Yes, thank you, Chair. I don't want to interfere with this, but honestly, for the life of me, don't understand what this line of questioning is supposed to achieve. This is a person who's testifying about the standards and measuring what this process against international standards. But for her to be taken ad nauseum about paragraphs and paragraphs of a South African judgment, which she was not commenting on at the level of that judgment per se, more than what it represents as against those principles. I think it's a complete, well, I don't know what in the end of this process that could achieve for someone who's an outsider and is here for a specific purpose. I'm sure there'll be witnesses where these things can be tested, including the public protector. I know she's going to deal in detail with this kind of thing. So.
Okay, thank you.
Okay,
I think
this
both Advocate Bauer.
This witness wrote the article, and she reduced the irregularities at the Constitutional Court to those of procedural errors, and said in this article that this 15% of legal fees is attributed to procedural errors. Now, I'm going to, after I read the next paragraph, ask the public protector whether that is, the Zambian public protector, Ms. Sokoni.
You're going to ask Ms. Sokoni.
I'll ask Ms. Sokoni.
She's here not as the public protector.
Yes,
Thank
my
you.
apologies. I'll ask Ms. Sokoni whether her statement that the Constitutional Court's decision to dispense and award a 15% of the fees cost order against the South African public protector was simply based on procedural errors, based on what I'm reading out to.
Okay, let's watch the space, Advocate Mbofu. Let's Advocate Bauer.
So I have one more that I want to say to you. The public paragraph 207, and I'm giving Advocate Mbofu the references. The public protector's entire model of investigation was flawed. She was not honest about her engagements during the investigation. In addition, she failed to engage with the parties directly affected by a new remedial action before she published the final report. This type of conduct falls far short of the high standards required of her office. Now, that's a finding of dishonesty from the highest court of the land. And I want to put to you that your categorization that the majority judgment in which 15% of legal fees for procedural errors is not a correct encapsulation of the majority judgment. I'm affording you an opportunity to comment on that.
I'm not quarreling with the judgment, really. My emphasis was just on the award of 15% of award of personal costs, 15%. So the process has continued, and we are now at this point where she's still being disciplined. So had they still awarded costs against the institution, this ongoing process of the disciplinary procedure would still have continued. She would still have faced up to it.
So let me take this issue. Do you know what happened with that cost award afterwards?
No, I'm not privy to that information.
So you're not familiar with the fact that an organization stepped in through a crowdfunding mechanism Are you aware of that?
I'm not aware of that.
And that, as I understand it, not a cent of the cost was paid out of the public protector's own pockets, but
Sure. No, really, I'm sorry, Chairperson.
It was Advocate Bauer, Advocate Mbofu.
Honestly, what has that got to do with yeah, let's assume that happened in that particular case. There were hundreds of other awards where the money might have come from. This witness is about the principle, not about some specific organization and assent or whatever.
now, can I finish the question? And if you want to object to the question, then
Sure, sure.
to do that. The costs were paid through a crowdfunding organized by a third-party organization. And the reason why I'm raising this with you is because I want to know whether, to the extent that you indicated that the award of costs against a public protector is an infringement on the public protector's autonomy and independence. What is your comment on the receipt of funds through crowdfunding from any organization to pay cost awards on behalf of her personally?
I can't comment on that issue because I was not made aware of the information. However, the principle still stands that the award of personal costs against an ombudsman directly to a respondent institution is sort of like the respondent institution is punishing, getting at the ombudsman through the back door, really. So if the award was made against the institution, well and good. The judgment was against the institution, well and good. The courts gave a very scathing comments against the behavior of the public protector, well and good. But to award personal costs where somebody is acting in a public capacity, I don't know how much was the amount. If there was need for crowdfunding, then it must have been a colossal amount.
It was 225,000. In fact, the legal opinion obtained as to whether crowdfunding could be used or not cost more than the amount.
Well, anyway, that is according to in your personal knowledge.
Well, no, that was the evidence before the inquiry. So it's not that evidence was led as to what the cost was and much earlier on already. The question I'm linking to this is it okay for the public protector to take money from third parties?
This award was made against her personally. If I have to take that 225,000 to Zambian money, that is about 200, maybe about 250,000 Zambian kwacha. That's about 4 or 5 times my salary. I don't know how long it would take me to pay that money. But all I'm saying, it was awarded to her in her personal capacity. If it was the institution that was awarded and the institution went on a crowdfunding venture, I don't know. But it was awarded against her in her personal capacity. I don't know how was she supposed to pay the money.
So you benchmarking that because the actual amount is several times more than your salary.
No, I'm just.
No. That was what you stated. What if that amount was about 10% of your salary? Would your answer change? Hypothetically.
She would have to pay it herself. It's a small amount.
I'm just putting it to you. You see, we were having these debates at generalities and at principle. And so at the level of principle, should a public protector, be it as an institution or be it in a personal capacity, be taking funds from anybody for private benefit? At the level of principle.
Then we should be asking the question that should a public protector be asked to pay personal costs for an organization. It goes both ways because this award was made against her in her personal capacity. And we are arguing that that should not have been.
Can you maybe answer my question first as to whether at the level of principle, a public protector in a personal capacity should be taking funds from third parties? Would any of the organizations, is it permissible under any of these principles that you've relied on?
There
Yes
was
or no?
none of the principles say anything about it, but all I'm saying is that the award was made against her personally in her personal capacity. So she could pay personally.
So are you saying that if there was a member of the executive, hypothetically, who offered to pay her because it was in a personal capacity, it would be okay for her to take it? I'm putting it at the level of hypothetical because you're
I
not
think-
answering me whether it's
I
okay for the public
I
protector
really
to
find,
take the money.
I really find the question unfair. And I find the question unfair because the public protector was subjected to pay costs in her personal capacity. If she had not paid that money, what would have happened? If she had been incapable of paying that money, what would have happened?
Well, we don't know that because we didn't reach that point, but you're taking it a step further. Can we answer this at the level of principle? Do you agree with the notion that the public protector in a personal capacity does not infringe on her independence or autonomy qua public protector by taking funds from a third party in a personal capacity?
She was surcharged in her personal capacity. So she paid the money. She was surcharged in her personal capacity. Was she expected to get the money from the institution? She was surcharged in her personal capacity. So I don't know. In fact, let me say this, maybe to answer the question properly. I don't know what terms and conditions were put for her in order to pay the money. So
let me give you a different example, a more innocuous example. A car breaks down, or the public protector's car breaks down, and it's her personal transport to take her child to school, and she can't pay the car. But because it's not qua public protector, it's in a personal capacity, she can then take funds from somebody who perhaps complained to the public protector's office and who steps forward and says, I'm doing this for you in your personal capacity. It's actually okay for you to take the money from me.
okay, now you have clarified the question. So thank you for clarifying the question. No ombudsman can engage in any commercial transaction with either a complainant, a respondent, a member of the public. This is the reason why in terms of the conditions of an ombudsman, I can't remember which of the standards states that, but in our legislation in Zambia, before the previous legislation, Commission for Investigations Act, it stated that the ombudsman cannot engage in any business or any other gainful employment when they are employed as an ombudsman. So
I didn't say no, I said nothing about the commercial transaction. I gave you a possible hypothetical.
Because you mentioned the
Let's
complainants.
Can I maybe rephrase the question before let us be on the same page. Let's assume I'm the public protector and I need to have my car fixed, but I don't have the money. And Advocate Mayosi here says to me, I'll offer to give you the money. What does that do to my independence of perception? Let's say 6 months later, Advocate Mayosi lodges a complaint at the public protector's office. Isn't there a perception by taking that money in the first place, in my personal capacity, I'm opening my door up to all kinds of vulnerabilities? that as a public protector, whether it's personally or professionally,
Yeah.
I should not be taking the money. I'm putting a hypothetical.
No,
Okay,
No,
Advocate
I'm
Bauer,
putting-
just pause. Advocate
I
Bauer.
can answer the question.
Yeah,
Okay.
just hold.
Thank you.
He is addressing the chair.
yes.
So I don't expect any of you to intervene on behalf of the chair when the attention is drawn from the chairperson.
Yes, thank you very
Advocate
much.
Mpofu?
Chairperson, really, firstly, this is completely inappropriate. I'm just letting it go because I'm in a good mood. Because this is firstly cross-examination. That's why I said we should not have cross-examination. So when you're asking questions of clarity, which is all that should happen or whatever, once a question is answered, it's answered. And that's it. You can't be spending 2 hours trying to bring it this way and that way. But secondly, so what? Let's assume the public protector took money from 1 million people went shop to shop taking money. Is that one of the charges? What has that got to do with what we're dealing with here?
Thank you, Advocate Mpofu. I'll come to you and then back to you,
We had
Ms. Sokoni.
we had extensive evidence on autonomy and independence. And the question of the role of the public protector in the context of independence and autonomy. And I want to come to 2 further paragraphs in the Constitutional Court where they deal with why they gave the cost order further. But what I'm trying to explore with the public, with the witness, is where is the line drawn on independence and autonomy, and maybe going about it in a way by using the example and taking it out of a personal cost order against the Concord and saying, when do you draw the line between a personal and a public?
So, like I said, I'm glad that you clarified further to talk about a complainant and the situation that you have described. So it would not be appropriate or in order for an ombudsman to go seeking for funding from, let's say, members of the public generally, to say, oh, I'm in this situation, members of the public, please help me. However, hence we mention that the protections around the office of the ombudsman must be entrenched. Don't put the ombudsman in a situation where they are made vulnerable. And when you start awarding personal costs against a person, you make them vulnerable to being compromised. So this is one of the issues that we talk about, that the ombudsman can be compromised if he's put in a situation, a desperate situation. So the principle we should state here is that there should be no reason to award personal costs against an ombudsman where they are paying the cost for an institution, because that institution goes out and gets very, very expensive lawyers, you know, and at the end of the day, the cost that will come out of that will be really, really colossal. So the ombudsman should not be put in such a compromised situation. That is what I can state.
I'm going to take you to 2 paragraphs in the Constitutional Court judgments, paragraph 153, which says the purpose of a personal cost order against a public official is to vindicate the Constitution. These orders are not inconsistent with the Constitution. They are required for its protection because public officials who flout their constitutional obligations must be held to account. And when the defiance of the constitutional obligations is egregious, it is they who should pay the cost of the litigation brought against them and not the taxpayer. Because you would agree, if it's the institution, then it's money that comes out of the taxpayer's pocket. Correct?
Yes.
Right. The second paragraph is, despite this clear authority that personal cost orders are constitutional and necessary in order to hold public officials to account when they fail, for example, to fulfill their constitutional obligations, the public protector argues for an exception in her case. There is no merit in the public protector's contention that the independence of her office and proper performance of her function demand that she should be exempted from the threat of being marked with adverse personal cost orders. On the contrary, personal cost orders constitute an essential constitutionally infused mechanism to ensure that the public protector acts in good faith and in accordance with the law and the Constitution. And lastly, the fears that the public protector has about the impact of a personal cost order on the institution of the public protector are unwarranted. Personal cost orders are not granted against public officials who conduct themselves appropriately. They are granted when public officials fall egregiously short of what is required of them. There can be no fear or danger of a personal cost award where a public official acts in accordance with the standard of conduct required of them by the law and the Constitution. Now, on your version, our courts can never hold such a public official to account by issuing some form of accountability by issuing a personal cost order. Am I correct?
I have no argument with the reasoning of the courts. I'm not arguing with the reasoning of the courts, but I'm just stating that they could have found another way to ensure that public protector was punished. And as I have said, we are sitting here right now because there is a need to conduct a disciplinary proceeding. So there are many ways in which it could have been done without having to compromise the integrity of the office.
Well, are you suggesting that the personal cost order compromised the integrity of the office, or the behavior which the court complained of compromised the integrity of the office? What happened first?
Because you asked me a question about crowdfunding, I think we are still talking about crowdfunding. So I am saying that in a situation where a public official ends up being compromised directly because of an order from a court, I'm saying there could have been another way in which it could have been done. That is all. But otherwise, I have no problem with the reasoning of the courts. The reasoning of the court is very sound.
That's the reasoning of the majority judgment, which you didn't prefer, but you preferred the minority judgment.
Yes, and the reason why was because of the 15% award of costs I've explained.
So if I then take you to the principles we referred to, let's go to the UN General Assembly position first, right? These are principles. They are not binding on.
Yes, they are persuasive value, yes.
Right, because yesterday the suggestion was made that the UN General Assembly resolution was binding on South Africa, but that's not correct. General Assembly resolutions are not binding.
No, they are persuasive.
Right. So that is not binding. The OR Tambo principles, which you refer to, are also not binding on the South African state. The IOI principles, none of them are binding on the South
None
African
of them are binding.
Not even the Venice things. I'm not
They
disagreeing with you on independence, autonomy, etc. I'm just saying at the level of principle, they're not. Would you agree?
I beg your pardon?
You would agree that none of them are binding on the South African state?
No, none of them are binding.
What is binding is the South African judgments, the Constitution, and the laws of the country. Correct?
That is correct.
Right. So, while we've got that out of the way, let's deal with this. The OR Tambo principles, the submissions made to the UN, the Venice principles, the people largely involved in putting those together are the ombudsman and the public protectors from around the world. Would you agree with that?
Yes, that is correct.
Right. So it's done from the perception of looking after their interest and to protect public protectors, ombudsman.
It is not really just to protect their interests. It's in a bid to ensure that they are protected in their work.
Yes.
And that the public also get the services that they deserve.
Well, I don't know if you've had an opportunity to read Mr. Ibrahim's statement, but I think the principles you relied on, independence, objectivity, transparency, fairness, he doesn't take issue with any of those being part of what the public protector should adhere to. Would you agree with that?
I can't recall what the content of his evidence was.
Now, if you look specifically at the our Tambo declarations, they were, and I must admit, I at some level battled to follow my colleague, and I wasn't quite sure precisely what you were agreeing with. So let me see if I can put it in a way that I can understand it. Right? You were taken through the principles, or some of them, and there was a statement made either before reference was made to the principle or after that South Africa didn't comply with it. And then a question was put to you, and sometimes you answered the question directly, and sometimes you answered the question on the level of generality. And what I'm not clear on is whether, as you're sitting there, because it's not apparent from your statement, you are saying to this committee that this process is inconsistent, this process, and assume that all the procedural stuff are complied with in terms of the law, because we've had numerous court challenges and we're still here. This process.
Chair, I really.
Now wait, hold on. I can finish my question, please. Because the subjective connotations put to the process in the statements made to you. Are you saying, as you're sitting there, that this process doesn't comply with those minimum standards?
Chair, can I object before?
Okay,
Answer, yes.
just hold back, Ms. Sokoni, advocate in both.
Thank you, Chairperson. What kind of question is that? You can't ask a question that says, are you saying that this process is doesn't comply, but assume that it complies? Assume that all the procedural things have been made. Then obviously the answer is, if you assume that it complies, then it complies. What kind of question is that?
Let me.
Okay. Just Ms. Sokoni.
This process and procedure is compliant with the laws of the Republic of South Africa, and that is what is important. These principles, as we have already stated, I've already answered the question, these principles are not binding and they are merely persuasive.
And these persuasive principles agree that on misconduct, incapacity, and questions of competence, they constitute just cause if a country seeks to have a public protector removed, correct?
Yes, that is correct.
Okay, can skip that. Can I ask you at the level of generality and the question of investigations that the public protector, in terms of your minimum standards, must comply with? As I understand it, they either have a complainant or they, on their own initiative, investigate a complaint.
That is correct.
And there must be parameters that they have to observe within the investigation of that complaint. And they must look at all aspects of it, and they can't ignore evidence or choose to not explore any avenues within that investigation.
It depends on the nature of the investigation, but so long as the general principles are followed.
And in the course of this investigation that the public protector undertakes, if new issues come to light which falls within the mandate of the public protector, should those issues be ignored or should they be considered?
They should be considered.
And if there are implicated parties and these new issues come to the fore, should those new issues be brought to the attention of the implicated parties or should a report just be issued?
Depending, are we talking about public service entities?
Yes. Or private individuals, either way. If you come up with new evidence while you're doing an investigation, let's assume you're investigating A, B, and C, and now you expand your investigation to include D, E, and F, and it implicates X bank and Mr. Y under D, E, and F. Should you be giving them an opportunity to deal with it?
Okay, according to the way we work as ombudsman officers, I'll speak maybe about my example. I deal with public service entities, and I will only go as far as informing the public service entities and the private individuals who have complained regarding the progress of the investigation. And if there is a need to include anybody, it must be a public service entity. Private service organizations, we only go to the regulator. We'll go to the regulator and say XYZ. There is an issue that touches on this entity. Can you go out and investigate this particular matter? So we'll go to the sector regulators.
And if it's a private individual, you make that findings against a private individual, or do you refer it to an appropriate body?
Yes, we could refer the matter, for instance, to the Human Rights Commission if it's a human rights case, or to the Anti-Corruption Commission if it involves corruption.
But let's assume in South Africa, you have the powers to make those findings against individual people. You would expect them to have been given an opportunity to comment on it, correct?
Yes.
If I take you to page 15 of your statement, it's on page 223. The AOMA statement. Sorry, paragraph, page 15. You talk about the enforcement, it's under functions on page 232. You talk about, sorry, this was done last year already, so I'm a bit lost in my notes in doing this. You say that the office has the functions of enforcing the code of conduct for public officers, combating maladministration and corruption. And you're referring to the office in South Africa. So I was just trying to work out what code of conduct you were referring to. The public service.
Yes, I think this must have been lifted from the legislation.
Okay. And to take you to this, to close off on this issue of what is binding and what is not binding. And the Nkandla judgment has been repeatedly upheld as the authority that says public protector decisions are binding. But are you aware that what the Constitutional Court actually said was that the public protector's remedial action is not always binding, but that whether it is binding depends on the circumstances of the case? But that's actually what the judgment says in paragraph 73.
So so who decides whether it is binding or not?
Now, I want to move this question on South African judgments and what was termed as judicial harassment. There are, out of all the court judgments that have been found against the Office of the Public Protector, I think 3 or 4 that have made personal cost orders against the Public Protector in a personal capacity. Right? And the overwhelming number of judgments have found against the Office of the Public Protector for a variety of reasons, which, because you're not steeped in the South African law, I'm not going to take it. Do you regard, under the caveat of judicial harassment, the findings by courts of non-compliance on the part of the Office of the Public Protector to be judicial harassment per se?
No, as I said, having the reports of the Public Protector reviewed is part of the quality control of the work of the Ombudsman.
And have you scrutinized all the judgments in respect of which there were personal cost orders made against the Public Protector, or are you only objecting to it at the level of principle? That as a matter of principle, there should be no personal cost orders against the Public Protector, irrespective of what the Public Protector does?
As I stated earlier on, the Public Protector or the Ombudsman investigates the executive, and it would send a wrong message if the Ombudsman has to pay personal costs for respondent institutions. It would just open up a flurry of such orders, and maybe not only just in South Africa. So I just think that it's a power that has to be used with care, especially when it concerns the office of the Ombudsman, because of the particular mandate that it has to investigate the executive.
So if I break down my question, and maybe I did that, let's take the first part of it. Have you scrutinized all the judgments where the courts have made personal cost orders against the Public Protector?
No, I have not scrutinized all the judgments.
So if I now listen to your answer, you're not saying as an absolute, a court should not issue a personal cost order against the Public Protector. You are cautioning at the use of that as a tool. Am I correct?
Yes, that is correct.
Okay, that took us long. All right. Now, you accept that, and I understood you to say, I don't know of an organ of state when they put their budget in to Parliament or to the National Treasury and get back what they're actually going to give, that's going to say, actually, you gave us too much money or you've gave us enough money. Would you agree with that?
That is correct.
As an African country, there are always competing demands that has got to be met.
That is correct.
So your minimum standards say you must have a budget, and your budget must allow you to be efficient, and it must allow you to carry out your tasks. The fact that you are given a budget that doesn't cover everything you want to do doesn't necessarily amount to an infringement of your independence and autonomy. Would you agree with that?
Yes, I mean, Ombudsman offices are operating all over the world, and they're some of the most underfunded offices, actually. It's a constant cry that Ombudsman offices are not well funded. So In Africa, I would think that perhaps the Office of the Public Protector South Africa is one of the best funded if we have to compare with other jurisdictions.
So if we look and we did this exercise, this is ending 12. And I don't necessarily need to take you to it, but if she does get it up on the board, that in the 25 years that the public protector, qua-public protector has been in existence, annually, if you look at the second last column, the Parliament has increased the funding to the Public Protector's Office. Go down. Now down, down, down. So if you look at the years of the current Public Protector, go up. You will see, stop, right? You will see that not only has there been an increase in funding, but there's also been an increase in staffing. This is not a government that has taken money away from the public protector because of findings made against an executive. Would you agree?
Definitely, as I said, we are aware, even as AOMA, and even as the IOI, that the South African Office of the Public Protector is one of the best funded in Africa, if not the best.
So when officials of the public protector come and tell this committee that there are funding constraints within the organization, it's not a simple question of how much money is allocated to the public protector, but what that money is actually spent on. Would you agree? One would, and it's not a question you can answer, but as a level of principle, it's not a yes or no answer. It's got to be a greater, and the committee's heard evidence about this as to what is the funding actually going towards. Would you agree? That's what this committee must consider.
Well, I really can't comment either way. I'm so sorry.
So, okay. Are we staying with this? Are you moving to something else?
What? No, we're off. She can't answer. Oh.
Okay, no, then that's fine.
Can't get an answer if she can't answer. Okay.
Shouldn't be asked.
You were taken to the provisions of the Constitution about how entities should protect, I think it was section 180 of the Constitution, about how other organs of state must support the Office of the Public Protector. Let's see if we can just get the wording right. It's 180. Institutions are independent and subject only to the Constitution and the law. They must be impartial in the exercise of their powers, perform their functions. And then there's a statement that says other organs of state through legislative and other measures must assist and protect these institutions to ensure their independence, impartiality, dignity, and effectiveness.
You're struggling, Sabo? Put it up.
It's, you know which provisions I'm referring to. Section.
Yes,
Yeah, we
Ah,
also
simple.
just follow, so.
We assume our legislature knows the provisions of the
Okay,
Constitution.
good.
Give it to the witness, man. Yes. There we go. So when we say no person or organ of state may interfere with the functioning of these institutions, and that applies not only to the public protector, to the Human Rights Commission, to the Commission for the Promotion and Protection of the Rights of Cultural, Religious and Linguistic Communities, Gender Equality, Auditor General and Electoral Commission. Do you see that?
yes,
That's our Chapter 9 institutions, we call them.
yes.
And not all of them can be equated to fulfilling anything close to a judicial function. Would you agree?
Yes.
Right. Now, if we go to section 165 of the Constitution, which deals with our courts, we have a mirror provision in subsection 4 that says organs of state through legislative and other measures must assist and protect the courts to ensure its independence, impartiality, dignity, accessibility, and effectiveness of the courts. Would you agree that that obligation rests on the public protector as well?
Yes.
And nothing, even on your minimum standards, would digress from the position that the public protector must respect the judgments and orders of the court.
The question again?
The public protector must respect the judgments and orders of the court.
Yes, the public protector must respect the judgments of the court. But the office still has the right to appeal. Whether it need to appeal, they can still appeal.
And should the office of the public protector be involved in, for example, third parties writing articles about judges that vilify judges? Media articles.
Should the public?
Should the public protector be behind third parties? So I'm a third party and there's a judgment handed down that's very critical of the public protector. Should the public protector, under the guise of a third, well, not under the guise, let me rephrase that before I get into trouble with Advocate Mpofu. Mr. X is going to write an article.
Chair,
Was Advocate Bauer, Advocate Mpofu?
thank you, Chair. I'm sorry to interrupt. Now, what is this in aid of? Firstly, no such thing was raised in the questioning. And I don't know if we're now going to traverse all the charges, even those that are completely not related to this witness, who is not even from South Africa, and put all sorts of propositions about all the 20 charges. And, you know, that's not the purpose of this witness. And I think it's just a complete waste of time. And it certainly doesn't arise from anything that was raised with this witness. Quite apart from the fact that this whole thing is just not allowed because it's cross-examination, which she knows she's not entitled to do. But I don't want to deal with now. I think I'll deal with it when we finish this witness. Because if this trend is going to continue, we're going to have a problem. But I just don't want to make a meal of it now. Just the specific question. What does it serve? What purpose does it serve?
Thank you. Advocate Bauer,
Yeah,
respond.
I've accepted the mandate that allows me to ask the witness any question. It's Advocate Mpofu that sought to characterize questions, be that as it may. The whole question was put to the witness during direct examination by Advocate Mpofu as to the contrast between section 181 of the public protector and section 165 of the courts. The courts are operated by judges. There's a particular relationship between the public protector and the judges. There was a suggestion made of judicial harassment because of judges and judgments handed down by the public protector. What I'm testing is, what is the level of reciprocity between a public protector and the very judiciary that is being complained of as being harassment, and whether what is expected of a public protector acting independently and autonomously is to not be party to vilifying the judiciary as at the level of principle. We can put that at different reasons. But we've had evidence before this committee as to what has been going on behind the scenes, and it goes to the complaint that's before this committee, the motion which this witness hasn't been taken to it all under direct, as to how the resources of the institution is used and whether that's acceptable.
I think you want to respond, Advocate Mpofu,
Yes.
before I proceed.
Chair, yes, I accept that there was such evidence. That's not where I am. I'm saying whether those questions should be put to this particular witness. about some theoretical things that were raised with, I think it was Mr. Van der Merwe, I think, who gave the
Yes.
evidence about Mr. Ngobeni and whatever.
Yes.
Are we going to go down that path of testing every proposition that was put by all the 18 witnesses with this witness? For that's the point I'm making. I'm not saying that that evidence was not led, but as to whether we're now going to go through the path of testing everything that was ever said in this commission to this witness, whose only job was to tell us about the higher level standards of international behavior or conduct.
When it suited Advocate Mpofu, we relied on evidence of witnesses. And I is turning around and saying, well, actually, this witness can't actually deal with evidence. But when it came to whether it was HR matters, or when it was a question of whether it's something that should be in the labor court or before the committee, then we didn't have a difficulty referring to evidence. But I take
I want us to
I'm not going
proceed,
through
yeah.
18 witnesses. I want to put 2 or 3 issues of principle to the witness as to what is expected of a public protector.
Chair, in fairness, sorry, Chair. In fairness, I'm not blocking all I'm saying, let's give an example. I would have said to the witness, for example, if this and that situation happens, but if I'm going to sit here and drill down the entire evidence of, let's say, Mr. Kekana with this witness, then, you know, how is it going to aid us? Yeah. It's one thing if I say to her, the idea of calling disgruntled employees, you know, that's at a particular level, but not to go to the minutiae. Yeah.
No, thank you, Advocate Boff. Advocate Bauer, can we proceed?
I was putting to you, and I want to put this at the level of generality. A judgment comes out, and the judgment is scathing of a public protector. And there are third parties who are aggrieved that judges make such conclusions and findings against the public protector. And as of their right, they write articles in the media, on social media, etc., in which they vilify these judges, be them in whichever way. Let's just assume it's a vilification. And the question I'm asking you is, should the public protector, be it behind the scenes, be party to such vilification?
I will state what I stated before, that the Office of the Ombudsman is not supposed to have any commercial transactions, contracts. The Ombudsman is not supposed to have contracts with other people where he or she is getting a benefit, whether it's monetary or any other type of benefit. It's not allowed.
And as a follow-on on that, would you say that the funds of the institution should also not be used for purposes which do not fall within the mandate of the institution?
That is correct.
Can we come to this question of security of tenure? South African Public Protector has security of tenure, correct?
Yes.
So when you have this debate about security of tenure, it actually isn't applicable in South Africa because there is security of tenure.
There is security of tenure in South Africa. The constitution is very clear.
Whether it's 7 years or whether 10 years, it matters not.
Yes, so long as it's for a term certain, even if it's 5 years.
Okay, that's the end of security of tenure. Sources. Okay. South African laws do protect the independence and autonomy of the public protector, correct?
They do.
So the minimum standards in respect of endeavoring to protect the independence and autonomy has been adhered to in South Africa.
And they have been adhered to, and that is the reason why the Office of the Public Protector South Africa was actually spearheading the drafting of the OR Tambo Declaration, because they were coming from a standpoint that we are already enjoying these benefits, and we should ensure that, you know, the entire Africa enjoys these benefits.
So when you ask questions as to whether this system is fair or that system is not fair, it doesn't mean there's non-compliance with the provisions of independence or autonomy. It's just your preference over which system you would prefer to see in place.
Yes, yes, definitely.
Chair, okay, I don't know. Again, that's a misleading question, deliberately so. The questions about fairness and unfairness were specific questions about, for example, whether a complainant is called or not called, not some theoretical thing about whether the law says there must be fairness. Of course, the law says there must be fairness. The question is whether there is fairness now in the ground, not whether it's in a piece of paper.
Okay, thank you, Admiral Bow.
No, I didn't understand this. The position and one of the propositions, let me take that to you. You were asked the proposition whether you regarded the system where decisions were binding to be a fairer system than the decisions where it was only a recommendation, and your answer was that you thought the system of the recommendation was fairer. Do you recall that?
Yes, and I'm glad that you have qualified it yourself, because the South African legislation is compliant with all the principles, but whenever there is such legislation, sometimes in the application there can be problems and there can be mistakes, but otherwise on the face of it, South African law is compliant.
So, and this is simply so that I can understand, you understand this to be a committee that is seized with the removal of, to make a decision as to whether the public protector should be removed or not.
Yes, yes, I understand.
Right. You've testified that the system, it complies with the prescripts of the constitutional law. It's in accordance with the law that this process is taking place.
Exactly.
Right. You would rather not have had this country reach this point because it's not good for public protectors or for the institution.
Yes. Insofar as we are trying to grow ombudsmanship in Africa, and we are trying to entrench the principles of the institution of the ombudsman in Africa. So whatever we do, especially the countries that are leading in ombudsmanship, we have to ensure that we are taking care for the other countries that are more vulnerable, that don't have very strong ombudsman institutions. So that is in the spirit in which I gave my testimony here.
And in the course of you giving evidence, certain examples were put to you. And let me give you one example. Let me put something to you. The oversight of a public protector in South Africa is the legislature, the parliament. And you are in agreement that that is best practice.
Yes, it is best practice. But as I said, in its implementation, we should always look at how we are implementing. But otherwise, that is the best practice.
But you haven't been privy to all the evidence before this inquiry that you can pass an opinion on the process itself. Or do you feel confident enough to pass an opinion on the process?
I haven't passed an opinion on the process, simply because I believe that it's ongoing. We have not yet come to the end of it. It would be precipitous for me to actually say this is wrong and that this is right.
You will put, and so let me take one example from a different angle that was put to you. Parliament is made up of elected members. And those elected members serve the public. Would you agree with that?
Yes,
And those elected members must fulfill their constitutional obligations to Parliament
that is
in the
correct.
performance of their functions.
That is correct.
And in doing so, they must act in a constitutional manner.
That is correct.
Now, if you are a member of Parliament and you belong to a particular political party and your husband is the chief whip of that party, and that party lodges the complaint to Parliament. And it was put to you that there's a conflict of interest if you serve on this committee simply because your husband is the chief whip of that political party and on behalf of that political party submitted the complaint to Parliament.
Is the husband also serving on the committee?
No. Only one of the couple is serving on the committee.
So is the person who is serving in the committee the one who submitted the complaint?
No,
So the other partner is the one who submitted
the
the
wife
complaint?
is serving on the committee. The husband submitted the complaint. You're both members of Parliament. The husband submits it on behalf of the political party. The political party tables it at Parliament. Parliament accepts the motion. It's a parliamentary motion and it gets referred to the committee on which you serve. And as I understood your evidence, you were saying you can't serve because that's a conflict of interest.
Exactly, it is a conflict of interest. And that partner who is serving on the committee must actually declare his interest.
Well, let's assume everybody knows that he's the spouse. It's known to every member of Parliament that the two of them are married. And let's assume, to make this more complicated, that they're the only two members of that political party. And so only one of them can serve on this committee. And on your conflict of interest, that political party would not be represented on this committee.
It would still be a conflict of interest. I would even, if I were that person, I would give, I would allow another person to actually represent me or vote in my stead, you know, but it's still a conflict of interest, whichever way you put it.
So
it's still a conflict.
So I want to ask you why you say it's a conflict of interest.
But Chairperson, okay, I'm saying this for the last time, I'm sorry. Even in under cross-examination, which I don't know what she calls this, my learned friend. Once the question is answered, it's answered. You can't probe it like this, especially if you are an evidence leader, you don't have a version. You're not representing a party. You're just an evidence leader, not a prosecutor. And you ask a question and it's answered, it's answered. The witness even says, even if you put it in 1,000 ways, it will still be a conflict. And then, but, being argumentative with the witness, she has answered the question, that's a view. You might, when we argue the case later, my learned friend might say that view was wrong for whatever reasons and bring authorities, whatever, but you can't squeeze a different answer from this witness on this.
Okay, thank you.
I'm not asking.
No, sorry, Advocate Bauer. I've not recognized you. Just in fairness, Advocate Mpofu, the question has been put to the witness and she has emphatically responded in saying, in her own view and understanding, that would constitute a conflict of interest. She's done that. There's a second question being asked that says, why does she think it is? So I'm saying in
Why is
fairness,
there a
yeah,
conflict of interest?
in
Okay.
fairness, let's allow that to proceed.
I catch you.
But I get your point.
Ms. Sokoni, I'm not,
See it, Advocate Bao?
sorry, I'm not, I accept your view is it's a
Okay,
conflict of interest.
I'm so sorry, I really am. Chair, I'm not going to object. I just want to explain what I'm saying. All I'm saying is that to argue with the witness, because even that, why are you saying that, is challenging the question. I'm just saying that's not the role of an evidence leader, but I'll leave it there. As I said, it's a bigger debate, but my learned friend knows exactly that she's not supposed to do it.
Mr. Sokoni,
Sure.
I'm not challenging your answer. I accept that you are of the view that it's a conflict of interest. So let's get that out of the way. I think it would assist the committee if they understood what was the reasoning that you understood it to be a conflict of interest. That's why I asked you why.
I think let's maybe to put a matter more simply, if there is a complainant, for example, in a criminal case, there is a complainant, and you have, if it's a jury system, let's say for argument's sake, it's a jury system, and the husband is in the jury, he would be automatically be disqualified because the other party would not feel that they would get fairness, because it's already like you have, was this committee supposed to be neutral? They are hearing the evidence and they're trying to make a decision whether they should send this matter for impeachment or not. So there shouldn't be anybody who is sitting in this committee who has already made up their minds. So if this person is the person who is in the committee is the husband and the complainant is out there, so it means that already from the start, we already know that when it comes to voting time, there's that person, the decision of that person is already a fait accompli. So it's just a very, very straightforward matter.
Just so that I can understand, it's based on a presupposition that husbands and wives always agree.
It's not a presupposition. Even when you have a bidding matter, let us say we are bidding for a contract here, and the person who is bidding is a husband, and in the bidding committee there is the wife. Obviously, that person has to declare an interest and say, no, this person who is bidding is my husband. It's just really straightforward.
You raised this issue of conditions of service, and the proposition was put to you that there's no conditions of service. What do you understand conditions of service to be?
Well, it's, of course, the remuneration, the pension, and also the perks that accompany the position. So normally these would be laid out in a contract to say you shall be entitled to this, you shall be entitled to that, you'll be entitled to a gratuity of so much, you'll be, yeah.
Okay.
So it's the entire package for you, even the separation package, how you're going to separate with that institution.
And it's important for the independence and autonomy of a public protector that the public protector is aware of what that public protector is going to earn, what the pension is going to be, probably what leave they're entitled to, the term of office remuneration.
It should be certain. It should be certain because I was in a situation myself earlier on when I came into office where I didn't know what my terms and conditions of service were, so it's like today I would be given this, then that would be taken away, and then tomorrow I'm told, no, you're entitled to this, and then another person says, no, you're not entitled. And this is because the terms and conditions of service were not written down. And of course, the terms and conditions of service are not supposed to be whittled away slowly. Sometimes there's a tendency for the executive to start whittling away the terms and conditions of service. Slowly you start losing. So it's just better for all the terms and conditions of service to be put in a contract.
So that is different from a job card. Would you agree as to how you're going to tackle the job?
I beg your pardon?
Well, there's conditions of service which governs your employment. And then let me say at a lower level, if I go and I'm employed as a typist, I'm going to be told that I must be, well, maybe that's not a good example. Let me see. I must be at the office between 9 to 5. I must be able to do 10 letters a day. That's a job card as opposed to conditions of service. Would you agree?
Yes.
You're not referring to a job card. You're referring to conditions of service.
No, I'm referring to terms and conditions of service. Yes.
Right. Thank you. You then were asked about these possible threats, which was the 15 IOI possible threats. And the proposition was put to you that South Africa has infringed all of them. But while that proposition was put to you, I didn't hear you answer in agreement that South Africa has infringed all 15 of them. And so I just want you to clarify that.
Speaking on behalf of AOMA, I don't think we have sat down to look at the threats to the institution to say, oh, this is a threat that is existent in South Africa. This isn't. So we haven't done that. We haven't done that exercise. And we came here just with an open mind to try and see if we would add any value to the process.
Chair.
You've just got rid of a.
Okay. No, I was just about to say, in fairness, that the reason why Maladministration didn't hear the witness saying that is because nobody asked her, the witness, to say that. All that was done was to take the witness and then either give an example to demonstrate. But it was said that when we argue, we will then, using those examples, say that all 15 are not met, not ascribing it to her.
Thank you, Advocate Mpofu. Thank you, Zulu-Sokoni. Advocate Bauer,
I can move on. That's fine.
okay.
There's a statement in paragraph 40 where you say that the South African courts feel threatened by the public protector's powers. Paragraph 40 of the statement, which is on page 239. It is evident that issuing of binding decisions makes the Ombudsman amenable to review of its decisions by the courts of law. The courts also seem to feel threatened by the judicial powers of the Ombudsman, and there is always a temptation by one of the three arms of government to trim down the powers of the Ombudsman, as evidenced by the matters in Zambia and South Africa. Can I maybe ask the first question arising from that? You accept that in South Africa, the public protector does not have judicial powers?
We have talked about the three arms of government, each ceding something to the institution of the Ombudsman in order for it to work effectively. So for the judiciary, they give the powers to issue orders during the process of an investigation. And I think those provisions are generic across all jurisdictions, that the Ombudsman must have the powers of a judge during the course of an investigation, to issue orders, to uplift documents, contempt proceedings. But at the point where the report is being issued, the report then only should have the force of a recommendation. So now, when the Ombudsman is given binding powers, the Ombudsman can make mistakes, can overstep its boundaries, perhaps, as we have been discussing, you and I have been discussing the issue of the Reserve Bank of South Africa. So then the courts will take issue with that, and they will castigate an errant ombudsman for going beyond his or her powers. So this is it's in that spirit that this paragraph was written, that it's actually much better, I think, for the ombudsman to only exercise powers of recommendation. And you find that they will not come into conflict with the judiciary. I think that's the only time when the ombudsman comes into conflict with the judiciary, when they're exercising binding powers, usually the only time. So it's just, anyway.
Now, I was interested in the statement that the courts feel threatened by the public protector. And I wondered which judgments of the South African courts you had regard to that reflected that the courts felt threatened by the.
I think if you read the statement, it's a general statement. I've said, however, it is evident that issuing of binding decisions makes the ombudsman amenable to review of its decisions by the courts of law. The courts also seem to feel threatened by the judicial powers of the ombudsman, and there is always a temptation by any one of the three arms of government, meaning that if you give binding powers, to trim down the powers of the ombudsman, as evidenced by the matters in Zambia and South Africa. So we're talking about trimming down the powers. They trimmed down the powers. In their interpretation, they said the ombudsman does not have judicial powers, and the same was said in the South African judgment. But it would be much better if they give powers of recommendation to these officers. So we are not actually saying that the ombudsman should have judicial powers. On the contrary, we are saying give respect to the courts. Let the courts exercise their own powers, and let the ombudsman just be given power of recommendation. This is not really meant as a criticism per se, but it's meant to make a point that the office of the ombudsman should only exercise the power of recommendation, not binding powers. So we are setting this scenario to say, when you give the office of the ombudsman binding powers, there is always these conflicts that may arise between the office of the ombudsman and the courts.
So as I understand, you're saying this at the level of generality. You're not specifically referring to any particular judge or court in South Africa.
No. This is, it was a general paragraph. I think I've read it.
So I want to come to this question of civil servants. Your concern stems from the fact that those employed at the public protector should be selected by the public protector, not the executive. So I understand that correct?
Well, that is according to the standards that the ombudsman should employ his own members of staff. They should not be drawn from the executive, but in its practical implementation, it becomes very, very difficult. I can say that for sure, because even for the Office of the Public Protector Zambia, all the employees are drawn from the executive.
So if
I don't know if in the Western world, it's they do have that setup, but I think in most African countries, the employees are drawn from the executive.
But if the public protector has its own human resource division, it manages its own employment of members or persons in its employ, then this criticism doesn't arise. Would you agree? Even though they become part of the salary of the public service, the actual feet on the ground is selected by the institute itself.
So the question is,
your criticism of a civil service being selected by the executive doesn't apply if it's the Office of the Public Protector that chooses its own employees.
if that is the situation here in South Africa, then it's a more independent office than many in Africa.
So that's the case. Now, if you that independent office and you are entitled with your own HR department to employ people, to put out adverts, to select from the public, to decide who you're going to be employed, should you be seconding employees from government departments?
I think that it depends on the agreement between the government and that Ombudsman office, because I know for a fact from our legislation, we are allowed to employ, but we are getting employees from the public service simply because a lot of the times we don't have the budget lines to employ these people, and they're able to give us those employees and create they have specific employee numbers when they give these employees to you.
But at the level of generality, ideally, a public protector's office should be employing their own employees.
Yes, ideally.
And they should
All
not,
things, yeah,
they should not be co-opting from other government
No, no,
departments,
no.
even if they're allowed to do that. Looking at your standards.
Yes, looking at the standards, we're not supposed to.
And should they be turning to government departments for purposes of deciding what should be contained in their reports, or should they be compiling the reports independently?
The reports are supposed to be compiled independently, independent of any other government institution. But I will say the acts will usually say maybe the public protector may use experts, may use assessors when there's a very specific technical issue that is not within the specific knowledge of the ombudsman.
Okay, with that silence, we're going to take a 15-minute break. When we come back, I would like you to wrap up, Advocate Bauer, and then we get to members. Let's take a tea break. Thank you.
Recording stopped.
Pass me the motion. of the shepherd. My motion, in my bag is the motion. Just take it for me. Mm. Oh. Moa hasn't sat down. And sat down. No, sit down. Is there any point in me asking? Contents of the motion? Because that's my last section. That's my last. Most of the other things, no point in taking pushes such as generality. And she's accepted as other issues, so these. Now I got one in. this committee does find that on the basis of the evidence before it, that there is misconduct or incompetence, would a recommendation to Parliament be an infringement of the independence and autonomy of the Office of the Public Protector?
According to the provisions of South African law and the Constitution of South Africa, all procedures have been followed as you stated to me. So this committee is a committee of Parliament, and I do not see any reason why at the end of the day, whatever findings you make should not comply with the very law, your very laws and constitution.
And I've got one last question to you. You are not able to assist this committee in respect of the details or the subject matter on which this committee is seeking to impeach or is considering the impeachment process.
I'm not able to do that, and perhaps in a way it should help the committee, because I feel that this is a subject matter which the committee members themselves are experts in, being members of Parliament. Their procedures. So I wouldn't be the best person to say this procedure that you have followed is correct or wrong. I've come to speak to the principles of ombudsmanship and just to ensure that if possible, if there is any way that these principles can be considered, if it will be helpful, then they can be considered.
Thank you, Mr. Kani. We appreciate your assistance and hope I didn't keep you unduly long today.
Thank you.
Thank you, Advocate Bauer. That concludes the questions by Advocate Bauer to Ms. Sokoni. I now invite members who have questions to interact with Ms. Sokoni. I will deliberately start in the A and exhaust all of them as we were. Yeah, I'll start in the country there. Honorable Gondwe, I'll start with you. Honorable Heron. Honorable Tlape Mangetsi. Is there any other member in the air who wants to contribute? I leave that for now. There's no one. I come to the ground. Okay, Mananis. Thank you. Honorable Sukas. Honorable Mylam. Who says his hand was up now? Oh, okay. Honorable Denner. Honorable Manili. Honorable Ngola. Honorable Lakude. In that order, no one is left outside. Thank you. Honorable Gondwe,
Thank
do you know the drill?
Thank you very much, Chairperson. I don't have a lot of questions, which is quite rare, I guess, but I have 4 questions for Honorable Sokoni. Good evening, Honorable Sokoni.
Evening.
Yes, my first question goes like this. You conceded or admitted in your evidence before this committee that you're not an expert in the removal process of an ombudsman, and neither are you an expert in South African law or South African constitutional law. So I want to try and understand, and I know Advocate Bauer asked you this question, perhaps not as directly as I'm asking. So what exactly is the relevance of your evidence to the work of this committee? I'm asking this because Mr. Ibrahim, who appeared before this committee earlier, admitted that he was not an expert in the removal process of a public protector, as this is very much a novel process for our country. But at least he has the knowledge on South African law and the South African Constitution. In fact, he's an expert in constitutional development and has been engaged in the development and implementation of our country's constitution, whereas you don't have that specific knowledge and experience insofar as our law is concerned. So what exactly is the relevance of your evidence to the work of this committee?
Ms. Sokoni, so depending on each member, so which might be easier, you respond as they ask the questions. So we take them one by one and go to the next.
Okay, thank you, Honorable Bandri. You stated that I admitted that I'm not an expert on South African law, and I'm not an expert on, there were two.
The removal process of an ombudsman.
That I'm not an expert on the process of an ombudsman.
Of a removal process. You're not an expert on a removal process. That's the second point she is making.
Thank you so much for your question. When we applied as AOMA to be given a hearing before this August committee, we had informed the committee that we wanted to address the issue of the principles and international standards of an ombudsman. And that is just for the committee to help the committee understand the context in which the ombudsman stands, not just the national context, but that there is also an international context. As to the relevance of the evidence that I have submitted, it will be up to this August committee to decide whether the evidence is relevant, whether it can be used or it cannot be used. But for the sake of building up on knowledge of the Ombudsman institution, both within South Africa and out of South Africa, I again reiterate my thanks and gratitude that this honorable committee allowed the African Ombudsman and Mediators Association to address you on issues relating to international standards of the Ombudsman institution. Thank you.
Thank you. My second question is as follows. You stated in your evidence in chief that the legislature and judiciary should not be used as enforcement mechanisms on behalf of the executive. So is it your evidence before this committee that this process, this inquiry is an enforcement mechanism on behalf of the executive and is not an exercise in accountability, or at least in holding the public protector accountable? Parliament is the very institution that recommended the appointment of Advocate Mkhwebane as the country's public protector. So surely we must be able to also hold her accountable.
Yes, according to the South African system, according to your laws, it is the legislature that is supposed to hold the ombudsman accountable. And I think when we were giving the general outline of an ombudsman institution, we did state that the ideal model for an ombudsman institution is the classical model which states that the ombudsman should be accountable to the legislature. So unless I've not answered your question.
It's fine, ma'am. I think I'd also asked whether you viewed, this inquiry as an enforcement mechanism on the behalf of the executive, because you indicated that the legislature and the judiciary should not be used as enforcement mechanisms on behalf of the executive.
Yes, I did state that, I said that when a matter goes to court, the review, the powers of review of the reports of the public protector is actually a self-cleansing mechanism. And if the courts decide that a matter should go back to the public protector after the review, the public protector still has a chance to review the processes within the institution to ensure that such an occasion where a matter has to go back to the courts of law for review does not occur. With regard to the legislature, I think maybe my concern was broadly around the issue that it was the legislature itself that was complaining against the office of the public protector. I would have expected that a member of the public would have come through to make the complaint to the legislature. But for example, in our case in Zambia, if the public protector has to be disciplined, it's the Judicial Complaints Commission which disciplines, but I don't know if there would be again the same institution that would lay the charges without a complainant. I think that it is where the issue lay, my concerns lay, because the court judgments came across to the legislature. But again, I would not go into that because like Advocate Bauer said, I've not had occasion to look at the charges, but that was where my area of concern lay. But otherwise, the legislature is the correct institution to discipline, according to the laws of South Africa, to discipline a public protector who has been found wanting.
Thank you, Honorable Sokoni.
Thank you.
You further stated in your evidence in chief that the courts, by issuing personal court orders against the public protector, erode the respect for the office of the public protector. And this could also have a chilling effect on investigation. So is it your assertion or your contention that the office of the public protector and the incumbent are one and the same? Were the courts in issuing these personal court orders not invariably protecting the office from the incumbent and separating the two, that is the incumbent from the office that he or she holds? I'm asking this because we heard from a previous witness, Mr. Ibrahim, that the office of the public protector and its incumbent are two separate things, and the office of the public protector is more important than any incumbent. And there will be instances where the office will need to be protected from an incumbent. Would you agree that there are instances in which the office will need to be protected from the incumbent?
Public officers are not personal to holder positions, so there is a difference between the office holder and the office. My statement regarding that the erosion of respect for the office of the public protector when there are personal costs awarded that office is that assuming you have the same public protector in office and there are these personal costs award being made against the office, I'm speaking for myself as a public protector, and I'm going out and I'm carrying out investigations and I'm having hearings, and the perception from the public and the perception from the respondent institutions would actually be like, well, this is a lame duck ombudsman. Even if she goes ahead with her investigations and she submits her reports, and if the matter goes to court, well, she'll lose anyway, and personal costs will be awarded against her. There's just a taint on the office as officials are working. But again, I must say, when matters go to court, I've already said that it's a self-cleansing mechanism for quality control, and it is to be hoped that once an ombudsman has a case brought before court, it should not be the norm that always matters should be going to court and there should be personal costs award. But I'm saying if there is a trend, it tends to stigmatize the office.
Thank you, Honorable Sokoni. This is my last question for you. So is it your evidence before this committee that much like the South African courts, the Zambian courts hold the view that the office of the Ombudsman is not a court of law because it does not perform the adjudicative functions of a court? It has a different jurisdiction from that of a court of law, and the Ombudsman is excluded from the composition of the judiciary. Can you also confirm that when you were at pains to state in your evidence that the office of the Ombudsman should not be subject to judicial review, you were in actual fact not articulating the position in Zambian law, but rather your own perspective? Because you were speaking with such authority that I thought you were articulating the position in Zambian law and not your own personal perspective. I would have not known that you were giving your own personal perspective had Advocate Bauer not taken us through that Zambian judgment in bundle F of the evidence.
Thank you. That was your last question. I hope you got them, Ms. Sokoni.
Yes.
Because I nearly got lost myself in that long question.
I have said.
Would you like me to ask it again, ma'am?
No, it's recorded. She's got it.
I have said, I think several, I've repeated myself severally during this session, that judicial review is a form of self-cleansing. It's a cleansing process for the office of the Ombudsman. And I've said that it's also a method of quality controlling the work of the Ombudsman. The Zambian context, the reason why that matter had to be put to test was because in the Zambian constitution, it states that the reports of the public protector shall be of binding effects. And that is the only reason why we went to court to query why we should be subjected to judicial review. But otherwise, in other jurisdictions, I know Malawi, the Ombudsman is subjected to judicial review. I think even in Namibia, the Ombudsman institution is subjected to judicial review. So our case was peculiar. But otherwise, I have conceded that judicial review is a cleansing process, and it's also a quality control measure.
Thank you, Ms. Sokoni. Honorable Heron.
Thank you, Chairperson, and thank you, Ms. Sokoni, for your evidence and for introducing us to, or introducing me, I wasn't aware of them, the Venice Principles and the Tambo Declaration. I want to ask you, would it be fair to say that these two documents could be regarded as best practice for the work of a public protector or the Ombudsman, or the manner in which those offices are established?
Thank you so much. Venice Principles, the OR Tambo Declaration, and the UN resolutions regarding the Office of the Ombudsman were actually meant to guide both Ombudsman officers and states to use as best practice directives, yes. And also eventually, I think the hope is that these can gain the status of treaties where states can actually sign up to these treaties to ensure that the institution of the Ombudsman is protected. But of course, we all have to have an agreed position of what should be, what should constitute an Ombudsman office. But otherwise, as best practice guidelines, I think they are acceptable internationally.
And having regard to the way in which South Africa has established the Public Protector's Office, the practice of the Public Protector's Office, the legislation, the constitutional provisions, would it be fair to say that South Africa, by and large, meets these standards of best practice?
South Africa meets these standards, I think, in the best way possible. The best way that I can actually put it is to say that, as I said before, South Africa is actually a champion of upholding human rights. Your constitution is a model constitution. And the Office of the Ombudsman has actually been leading, the South African Public Protector's Office has actually been leading in ombudsmanship here in Africa. And I suppose that is the reason why the African Ombudsman Mediators Association was interested in actually following the proceedings, the impeachment proceedings of the Office of the Ombudsman here in South Africa. We are also learning lessons, and we hope that we are also leaving something of value also here in South Africa.
So, I mean, the process that we're involved in right now is an unusual one. I mean, it's unprecedented in South Africa, and it appears from the two documents, the principles, the Venice Principles and the OR Tambo Declaration, that even the drafters of those documents and those who agreed to those documents didn't fully engage with what best practice would be for the removal of a public protector. Is that correct?
So I believe that the international standards that have been carved by various organizations wanted to address the issue of the protection of the Ombudsman while he's in office and while he's carrying out investigations. And then the standard which has been advised in these documents is that the Ombudsman should enjoy the status of, at a minimum, a High Court judge. So I think they envisage that in most jurisdictions, they would accord the Ombudsman the status of judge in terms of terms and conditions of service, which means that removal would also be equivalent to that of a judge. But then different jurisdictions have taken different routes in order to remove an ombudsman. And I think maybe that is something that's these international organizations will have to address themselves to now that it's becoming apparent that it needs to be addressed.
Thank you. I mean, I raised that point because I think the documents are quite detailed with regards to the values, the credibility, the sort of high office of what a public protector or ombudsman should be, but both documents have one clause really that deals with removal. And if I look at the Venice Principles, it talks about on the basis of incapacity or inability, then refers to misconduct. And we're dealing with charges relating to misconduct and incompetence. But in the Venice Principles, it talks about the misconduct should be narrowly interpreted. And I wondered if you could share how we as a committee can consider what that means, if it's relevant to our process. What does it mean to be misconduct which shall be narrowly interpreted?
I think that the aim of all the international instruments was to ensure that the executive does not take advantage of the office of the ombudsman, because it's a single person operating as a legal entity, and then this office does not sits almost alone, because the ombudsman is not an employee of the executive. The ombudsman is not supposed to be an employee of the judiciary, is not really an employee of the legislature, just accountable. So it was the way it's phrased, narrowly interpreted, is to ensure that the ombudsman is not victimized, that the executive does not try to trump up charges against the ombudsman in order to ensure the ombudsman is removed from office. So when we say narrowly interpreted, really that's what they are referring to.
So do I understand you correctly that your interpretation is it really depends on whether it's the executive who's bringing the complaint, rather than whether the legislature has adopted a motion? Because you're talking about protection from the executive, but in our case, we're dealing with a motion that was adopted by our parliament, so the legislature.
I think when at the point when you established that there was a prima facie case against the public protector, it would have been at that point where you would have interrogated the charge to ensure that the charge is not coming indirectly from the executive, and that you have ensured that the ingredients of the offense are sufficient that you can commence an inquiry. So what is important is that the charges that are being brought against the ombudsman must not be because the executive is unhappy with the ombudsman, and then the matter comes through as a complaint to the legislature. So really it's meant for the protection of the office.
Thank you. Chair, I just have one more question. The last one is about a similar question with regards to the Tambo Declaration, which also only has one clause on the removal of a ombudsman or public protector. And that clause is 3.3, which talks about it should be on the basis of just cause and shall be fair, transparent, and regulated by the Constitution, and preferably involve an independent body. Can Mr. Corney, can you perhaps assist us or share with us how you think that process should play out so that we meet those standards of just cause, fair, transparent, and regulated?
So for the situation here in South Africa, you already have a system in place where I assume that even a member of the public can come and complain to Parliament to say, I have a complaint against the public protector. So if the system has been followed through and the principles of natural justice have been observed at each and every stage of the hearing for the removal of the public protector. And I think according to what is in your constitution and the rules that you have here at Parliament, I assume that all the procedural fairness has been ensured, and that the principles of natural justice are being accorded, that this person who is before you for disciplining has got legal representation, has been given a chance to understand the charges, and that she's before an impartial body. So if all these have been covered and you're satisfied because you're a committee, then the OR Tambo Declaration has been fulfilled.
Thank you. Thank you very much, Mr. Sokoni. Thank you, Chairperson.
Thank you. Thank you, Honorable Aaron. I now recognize Honorable Mangitsi Tlabe.
Thank you, Chairperson. Greetings to the participants of this committee and Ms. Sokoni. Ms. Sokoni, let's start on this one, that in your opinion, what would constitute misconduct and incompetence by an ombudsman, and what should be done to hold an ombudsman to account?
For the aspect of misconduct, the ombudsman is supposed to be an impartial official, holding in the highest, upholding the highest levels of integrity. And that is the reason why an ombudsman is not supposed to be in employment, is not supposed to have any company or a business that he is running. So misconduct would be if the ombudsman is conniving either with parties, maybe for his own gain or for the gain of another person. I think that is the highest level of misconduct for an ombudsman. It would erode the trust in the office, and erode the trust in that particular individual who is holding office. So any misconduct that is related to how would I say, endearing him or herself to the complainant for gain, or endearing him or herself to the respondent for gain, or to an outside party, so that a decision that comes from that office favors a party. And with respect to incompetence, it would deal with how the work is being conducted internally. Are reports being issued on time? Are the complainants and the respondents being consulted? Are the principles of natural justice being applied in the interaction of, with respondents, with complainants, and with the three separate arms of government? So incompetence really speaks to the work, the actual work that the ombudsman is doing, and misconduct will deal with both the conduct with all the parties that deal with the office, especially with third parties. Thank you.
Okay. I have also requested that you advise us what could be done to hold an ombudsman to account in case of these allegations, if such allegations comes to the fore.
So, I believe you already, this is the process that is going on right now, that a member of the public can come to the legislature and complain, to say, I have a complaint regarding the conduct of the Ombudsman. I think that is the system that you have here in this country. When the Ombudsman is working, they can either receive a complaint from a member of the public, or they can commence an investigation on an own initiative. So I'm assuming that that is the same with the legislature here, that either the complaint can come from an outsider can come and complain to the legislature, or a member of parliament can complain. Which is what has happened in the current situation. A member of parliament has complained. Again, I will repeat, I don't know whether that is the procedure here, that the legislature can, on its own initiative, call in the public protector and discipline the public protector. I would think that the public protector and the legislature are one. The public protector is accountable to the legislature, and the complaint would have to come from outside of the legislature for the legislature to commence disciplinary proceedings against the public protector. But that is just my thought. However, you already have a procedure in place, and I think it is good, a good procedure, and it's working for you.
Thanks, Ms. Sokoni. Now, as you know, here at home, a preliminary panel was appointed by Parliament and has found out there's a prima facie case or evidence related to the misconduct and the incompetence of the public protector or ombudsman. Considering what you just explained from the classical model, do you think it is necessary for Parliament to establish whether there is substance in those allegations?
I believe you already have such a process in place. I think Advocate Bauer referred to it, if I'm not mistaken, where there was an initial committee that sat and found that there was a prima facie case established against the public protector, and then this committee was constituted. So I believe that is already in place, unless I'm mistaken.
My question was, do you think it is necessary that Parliament should establish that committee to just find out if there is substance into these allegations? In your own thinking, is it necessary, or was it necessary?
I think it's necessary. It's absolutely necessary, because like I said, in this particular case, the complaint came from within Parliament. The complaint came from within Parliament, yes. And so for the avoidance of establishing whether there's a conflict of interest when the complaint has been made. At that stage, it should be established that it is a genuine complaint before it can come before the committee, because I think to constitute this committee is a very big thing and it has been going on for a long time and it must be very expensive. So there must be a level at which the complaint is screened and then it goes on to the committee.
Thanks. My last question, Chair. You also indicated, Ms. Sokoni, that there has been interventions in Malawi and another country that you couldn't remember by international organizations on ombudsmen. Do you think the current situation in South Africa that we are dealing with currently with our public protector warrants such intervention?
I beg your pardon, warrants such?
The intervention. You indicated yesterday that there has been interventions in Malawi and another country that I didn't remember. Now, considering the charges of allegations that we have, do you think the situation here warrants such intervention of an international body?
The situation in Malawi, I've remembered the other country was Mali, where the African Ombudsman and Mediators Association was forced to intervene in a situation where an ombudsman was under threat. So both these interventions came in because it was the executive that was actually carrying out acts of retribution against the office of the ombudsman. And before the matter could even go to any tribunal, before any tribunal, the African Ombudsman and Mediators Association was able to intervene to rectify both situations.
Thank you, Chairperson.
And then the last part of your question, you were saying whether it's necessary for this interaction that is going on here. Of course, there are different methods of meting out disciplinary measures. Of course, a letter could have been written, for instance, a letter could have been written to the public protector, and she responds, and maybe a decision could have been made to either just suspend, or I don't know. But I think the process that you are going through is actually the best process because this is a high level office. And there is need for everyone to be sure that the office holder is worthy of holding the office. But I don't know if there are other administrative ways that could have been used, whether a letter of warning could have been written to the office holder. I don't know if that is available. But in our jurisdiction, like in Zambia, if someone goes to complain to the Judicial Complaints Commission, then you have started a process which will go on until the end. I think it's the nature of the office, really.
Okay, thank you.
As I exit, my question actually was, Chairperson, Ms. Sokoni did not understand. My question was actually, does the situation, looking at the allegations of the charges we're dealing with, warrant international body, those mediators, does it warrant their intervention here in South Africa?
Oh, sorry. Thank you so much. As I said before, South Africa is a leader in ombudsmanship, and we are thankful that the proceedings that are going on in South Africa are being carried out in a very transparent manner. and the whole world is able to follow the proceedings here in South Africa. In other countries, maybe we wouldn't even have known what is going on. So the issue of the African Ombudsman and Mediators Association coming in here was merely to ensure that the international standards or best practices, as it were made, were put at the disposal of this committee for the committee to know that this institution also has an international character, an international nature, and then the international documents that guide the operation of this office. And if it would be possible if these international documents would help the process. It is also building us up. It is building up Africa, you know. And as I said earlier on, what happens in South Africa really impacts what happens the rest of Africa. So it is actually good that you have interacted with us, and we're hoping that from this interaction that we have had with you, it will be possible for actually South Africa to champion the cause of ombudsmanship in Africa and to ensure that the OR Tambo declarations are adopted by the African Union. Thank you.
Thank you, Ms. Zulu-Sokoni, and thank you, Honorable Tape. I now recognize Honorable Mananiso.
Thank you, Chairperson. I just want to check first if I'm audible. Am I audible?
You are audible, Honorable Mananiso.
Okay, thank you, Chair, and good afternoon, colleagues, and welcome, Ms. Zulu-Sokoni. Chair, one would want to indicate that I'm covered by Honorable Gondwe on the issue of the relevancy of the testimony of Honorable Zulu-Sokoni, which was her first question, and the last one that was asked by Honorable Mankit. However, I have 4 questions. The first one, Ms. Zulu-Sokoni, for you is, do you think this process is not a fair process for the PP?
Could you repeat
Just repeat that. I didn't get that. I think Ms. Zulu-Sokoni as well did not. Just repeat the question.
Okay, thank you, Chair. I just want to check, Ms. Zulu-Sokoni, that do you think this process is not a fair process for the PP?
She's asking if you think this process is not a fair process for the PP.
The reason why we have made our presence, we requested for our presence here at this process was because, as I stated before, this institution investigates the executive. So it was absolutely necessary for us to come and witness how this process is being handled, and whether it is in conformity or compliance with the international standards that have been set out. So I think on the whole, the process has been explained to us as the African Ombudsman and Mediators Association, and we will see how this process is handled up to the end. I think it would be premature for us to state at this time whether this process is fair or not. A question was asked of me by Advocate Bauer as to whether the complainant's spouse could be a member of this committee. And I did give an answer. So there are all these little issues that have to be resolved to ensure that the public protector feels that she's getting a fair process before this committee. But we will be, we'll keep a watching brief on the proceedings that are going on here. Thank you.
Okay, Ms. Sokoni. Then my second question is, do you think this process is an HR-related process? Because I believe you've been following through witnesses that have been coming before, witnesses that have been examined by the evidence leaders and as well ourselves. So do you think, according to you, this particular process is more related on HR processes?
When the actual question warasha, it's always fast. We don't get
oh,
it.
okay.
With-
Eric, can you hear me, Chairperson?
Karo toilet, man. Yeah, there's a little
No,
echo there.
You are out of order. I'm not in the toilet. It's just that I'm in the rural area.
Okay.
So can you hear me? Can you
Just
hear
do
me,
it
Chair?
slowly. Just do it slowly.
Okay. My question to Ms. Sokoni is that she has been following through the process and all the people who have come before us. So I want to check, according to her, is this particular process more related on HR issues?
That's very clear. Thank you. You got it, Ms. Sokoni. Aibo. You didn't
Is
get
this
it.
particular process from the point where she says that several witnesses have testified, and she would like to find out from me whether this particular process, and then I lost after that.
Yeah, but it's better to be done by her. Repeat the last part, your HR issues and so on, Honorable Malaniso.
Yeah, Chair, as I indicated that I'm at the rural areas, ne? My point is, according to Honorable Sokoni, does she think this particular process is more related on HR issues?
Oh,
Got you. Thank you.
I had occasion to look at the charges, but I'm not in detail. But I did hear one witness. I think that was Mr. Samuel, the last time that I was before this committee. And most of the issues that he was talking about were the internal working processes of the office. And I don't know what the other charges are, but usually if charges are being are coming from, let's say, from the executive, you know, are backed by the executive, you usually find that you get complaints against the office holder regarding the internal working mechanisms of the office. So members of staff will come and complain. I'm saying this from experience. I think it was in 2006 when a complaint was submitted against me to law enforcement officers. So the key witnesses were actually the workers within my department. And I think at the end of that, at the end of the investigation, it was said that these were matters which could be best resolved administratively. And the matters were resolved administratively. Whatever issues were raised were resolved administratively. And the members of staff, a lot of them are still working with me. They're still working with me. So it was a process of internal learning. We all had to learn. This is the way we are supposed to do these matters. This is the way we're supposed to do these matters. Some people were sent for training. We had to send people for training. I actually even went for a training also in administration, just to ensure that I understand how it is that procurement procedures are supposed to go. I understand how it is that human resource matters are supposed to be handled. So after we had that inquiry in the office, we had to restructure and ensure that matters were being handled more professionally. And we were we were a very small institution at that time. We only had 2 investigations officers, but we learned from that, and now we have grown. We have an office of over, I think, 20 investigations officers. But it was a learning process. It was a learning curve. So when it's more related to human resource issues, I would expect that these matters can be dealt with administratively if it's more leaning on human resource issues. But I saw from that one witness, he was talking about the internal workings, the internal mechanisms of the Office of the Public Protector, which, if they are worked on, can help the institution to perform more optimally. Thank you.
Thank you, Chair. My other question to Member Sokoni is that, do you think people with functional autonomy, they must not account?
Okay, repeat again. Sorry that we asked you to repeat. We know there's a network issue. Just repeat again that question.
Yeah, Chair, I'm asking Member Sokoni to say, does she think people with functional autonomy, they must not account, like people like your Ombudsman as well as the PP, according to her?
That's, I think if I heard properly, that Ombudsman must not be held to account. I think that was the
Yes,
gist of
yes, yes.
This is why the standards have been put into place to ensure that the office of the Ombudsman is actually held to account. This is the reason why there was a need for standards. But however, the standards were put in place to ensure that even if the Ombudsman is being held accountable, it should not be as a result of victimization, because this office investigates the executive. And then equating the office, the terms and conditions of service to a judge means that the disciplinary process for the removal of an ombudsman has been put at a very high level to ensure that the ombudsman is held to account at the highest level. So the process that you have here is the correct procedure according to the classical model, that the ombudsman must be appointed by the legislature and can only be removed from office by the legislature. So you conform to international standards, and I would not have it any other way. I have been held to account several times in my country. Whenever there is an audit, there is a need for an audit, we are audited. Whenever there is a complaint by anybody, whether it's a complainant, a respondent, we have to give an account of how we have handled a particular case. So even by process of judicial review. That is another method of holding an office holder accountable whilst in the office of Ombudsman. Thank you.
All right. Thank you, Chairperson. Then my last question, Member Sokoni, do you think this process is to threaten the PP?
Do I think this process is
to threaten the PP, according to you?
Is prejudging?
No, I'm asking if you think this particular process is threatening the PP.
Is threatening the public protector?
Is to threaten the public protector, yes.
Okay, so as I said before, this is the normal process that has been adopted by the South African Constitution, and there is no way that I can say that it is threatening the public protector. It is following the normal procedure. But everything, having said that, everything in its implementation, we must ensure that we have respect for the process, respect for human rights, and we are ensuring procedural fairness. That is all.
Thank you. Thank you, Honorable Mananiso. I now recognize Honorable Sukas.
Good afternoon, Mrs. Sokoni. Thank you for addressing this committee. My first question, a number of questions has already been answered by some of my colleagues. My first question to you, you have brought a number of standards and principles to our attention. And even though they are not binding on us, they can act as a guide to practice. You stated that the Ombudsman must be given the highest level of support because the Ombudsman has the final responsibility for all decisions in the office. Is that correct?
Yes. The Ombudsman operates as a corporate soul, a single person operating as a legal entity in an office. So every single reports, actually, the Ombudsman has to take personal responsibility for that report. It's not like at one time in Zambia, we had a collegiate body. We had the Investigator General and Commissioners. So the collegiate body was making the decisions as a whole. But for the office of the Ombudsman, the classical Ombudsman, the standards and the principles that have been set as a guide to practice require that the Ombudsman should have the highest levels of integrity because all the decisions fall upon the shoulders of that office holder.
All decisions of that office.
Yes.
So the Ombudsman cannot say my responsibilities are only in regard to the reports that I deliver. Is the Ombudsman responsible for what happens within that office? All aspects of that office.
Okay, maybe let me qualify that. If I have to give an example of, for example, judges. So judges have got a constitutional responsibility, and then the administrative functions of the judiciary, there's usually an officer who is supposed to be in charge. So ideally, for the Ombudsman office, the Ombudsman should have like a chief operating officer or a chief or the executive officer who takes care of the administrative functions. But where the functions of administration and the constitutional functions become mired, This is where you find that the ombudsman has to take responsibility even for administrative decisions. So that was a problem I had when I was operating as executive ombudsman. So the final decisions, even for decisions for administration, were on my shoulders. And that is the reason why we had this problem of members of staff going out to complain, to say, oh no, this is not being done right in the office, and this is not being done right in the office. And this is the reason why I said, I'm not an administrator. Yes, I'm a lawyer, but I'm not administrator. I don't know all the government procedures, and I need to learn the government procedures. I had to do training for that. And then when we became a parliamentary ombudsman, we separated the functions. Now, I carry out the constitutional functions, and I have a permanent secretary in my office who is responsible for the administrative functions. So it's made me a happier ombudsman.
So where the administrative function has a, or the lack thereof, of, let's say, where dysfunction within the office, whether it be administrative, primarily it would be administrative, has a direct impact on the quality of work of that office. Does it not primarily squarely lie with the ombudsman?
Yes, it's at the end of the day, because all the operatives of the office of the ombudsman, for example, for the reports to be prepared, you have to use the investigations officers, and the levels, the standards of integrity, the standards of excellence all emanate from the ombudsman. And at the end of the day, the ombudsman must take responsibility for the culture, for the working culture of the institution, especially.
You also stated that an ombudsman must learn from the judgments of courts. What actions should an ombudsman take to put this into practical effect? And if they do not take these steps, would the ombudsman be guilty of misconduct?
Depending on the nature of the judgment. So, for example, if the judgment states that there was insufficient consultation before the report was released, then the procedures in the office would have to be changed. The standards would have to be changed in that office to say, okay, like I was explaining, for instance, in our office, a report goes out once, and according to the Public Protector Act, the respondent institution and the complainant have got 30 days within which to respond. If they respond and they have no comments, they have made no comments to the reports, then the report goes out as it is. But if they have submitted comments, we must look at their comments, and if we need to incorporate the comments, we incorporate the comments. Where we don't incorporate the comments, we must give reasons that we're not incorporating the comments, and release the report only if we have not incorporated any comments. If we incorporate comments, the report must go back to the complainant and to the respondent to show them that your concerns have been taken into account and they have been included in the report. So once a judgment comes back to you and it was not in your favor, you must look at the specific technical steps that you have missed out, and correct. Either if you're able to correct the report, if it's not a binding report, you can still be able to correct the report. But if it's a binding report, it's for future reference to ensure that the next investigation that you do, you get it right.
So repeatedly, when you do not do corrective or take corrective actions, and there is a repeat of the same, would you not say that it is misconduct? That is the question. Would it amount to misconduct to ignore, not to implement, to implement corrective actions? Would that be misconduct?
I would then think that the ombudsman does not understand his work.
Okay.
Yeah. Simply puts,
Thank you.
yeah.
My question for you now, you've highlighted the appointment of an ombudsman must be handled with great care. But will you admit that it is possible that an ombudsman could be incompetent? And what role does the international organizations you represent play to address the potential or real issues of misconduct by incumbents who are members in your organization? How do you as an organization practice self-cleansing?
First of all, when an ombudsman is incompetent, we're talking about the internal workings of the office. They are not able to write reports, they are not able to deliver reports on time. They have a backlog of cases. If this comes to the attention, and it will only come to the attention of the African Ombudsman and Mediators Association, if the office holder himself says, I'm having difficulties. And if he says he's having difficulties, we are able to ask, for example, a seasoned ombudsman or a retired ombudsman to go to that office to see if they can help to work with that office. This happened in the Gambia. There was a need, I think, even put the legislation in place and then to have the office start working. So the Commonwealth, I think, was it the Commonwealth Secretariat? The Commonwealth helped to fund that activity, helped AOMA to fund that activity so that the country could be helped. And then there have been instances where the Commonwealth Secretariat has sent experts to come and help ombudsman officers and to carry out training for ombudsman officers. And even the International Ombudsman Institute also, like I said, gives a grant to each continent. So where there is need for expertise, where there is need for training, they do give the countries assistance. However, because we are an organization that is there to encourage cooperation, to encourage growth, unless the country is not adhering to the standards, that is when we take an interest in trying to see whether it is the ombudsman or it is the government that is not giving sufficient support to this ombudsman. And as I said, issues of expulsion or suspension, we are at pains to do that unless we see that an institution or a state is not adhering to, is failing absolutely, even after assistance and after intervention, and then that's when we look at such matters. But otherwise, our interest is to grow the ombudsman institution in any country.
In what way is this impeachment process a threat to the ombudsmanship on the continent? And I put this question together before your reply, I think, to one of my colleagues. And I think I'm still answering the question because I'm trying to ascertain whether there is still in your mind that this process in any way poses a threat. You have extensively answered, I think. I've heard you say that you've looked at the process. You do think that we are trailblazing, that we are ahead South Africa in many aspects. But I want to hear from you, and I'm asking the question, in what way is this process, impeachment process? Because that was the impression almost that one had listening to you before.
The issue of threats to Ombudsman institution has been a cause of concern, both at the AOMA level, the IOI level, and even at the United Nations level. So when this impeachment process was commenced, it was the first of its kind, of course, you will understand. And then also, secondly, the process had been going on for some time. I think it was brought to our attention from the onset when it started. So we were sure that the process would actually end sooner or later, and there would be no need actually for the African Ombudsman and Mediators Association to actually come in, because in most countries, it usually just fizzles out before we even intervene. However, in the case of Madame Mukwebane, I think it came more because the OR Tambo principles, we had already drafted the OR principles, and we had some standard to look to. So we wanted to ensure that these standards which we have put in place are being adhered to here in South Africa, because as I said, South Africa is a beacon, and if you get it right here in South Africa, it will be done properly in the rest of the continent.
Yeah. I've got 3 more questions.
So yeah, you're wrapping up now. You can't be having 3 more. You'll have to squeeze all of them into one last question. Thank you.
Let me choose. In labor matters, when an ombud loses court cases brought by or against staff, what are the self-cleansing steps that should be taken by an ombud? I know you used your example, but if there are other commissions that finds an ombud guilty or upon appeal, or finds that people has been treated unfairly, what self-cleansing steps should be taken?
You say when an ombudsman loses a case.
When ombudsman loses labor cases, where staff with
Loses labor cases.
That's right, where staff within the ombudsman's office and other commissions finds that staff has been treated unfairly.
So I did state that I think in our office we have a questionnaire to help. I did state that the principles of natural justice should guide the work of the ombudsman at each and every stage. So when a complainant comes in, there's a questionnaire that is asked of the complainant. Did you submit a complaint, or after you submitted the complaint, were you given a hearing? If you were given a hearing, did you feel it was a fair hearing? So there are a number of questions that we ask. And then when we have got the complaint from the complainant, we also have those same questions to ask of the respondent institution. Were the principles of natural justice followed? Was this person given a hearing? So when you have labor complaints, that is the standard that you're supposed to use. If you have lost the case and these people have come back to you, you have to ensure that within the institution, you say, these are our standards. Everybody must be made aware if there's a charge against them. Everybody must be given a fair hearing. Everybody must be given a chance to, if they need to have somebody to defend them, they must be given that chance. So the principle, and then again, when we're dealing with respondent institutions, it's the same standard. When you're dealing with members of staff, especially when you're dealing with members of staff, because we say that the office of the ombudsman must be the beacon.
That's right.
Must be the standard. All other institutions must measure themselves against that office.
100%. Thank you. Thank you.
Thank you. Honorable Mailam.
Thank you, Chairperson, and thank you, Ms. Sokoni. Good evening, and thank you for bearing with us for such a long period. Ms. Sokoni, my first couple of questions are just simple yes/no questions. You can answer them as simply as you want to. Are you aware that only a member of parliament may initiate proceedings for the removal of a holder of public office in terms of section 194 of the South African Constitution, read with Rule 129R of the rules of the National Assembly, through a substantive motion in the National Assembly? Are you aware of that?
No.
Okay. So a member of the public then can't, it would have to come through a member of parliament is what I'm trying to say. Okay. We heard a lot about functional autonomy yesterday. As I understand it, that means that Parliament, the judiciary, and the executive can't interfere or intervene in the work of the ombudsman or the public protector as it may be. Is that correct?
They can't interfere when an investigation is ongoing. When we're talking about functional autonomy, we are talking about the actual work. The ombudsman must be allowed to carry out that investigation independently.
Okay, I'm happy with that. And as part of that, you indicated that the public protector in South Africa is accountable to Parliament. Now, my question is, how is her independence compromised in any way if her only point of reporting and accountability is to the Parliament?
When we talk about the independence of the office being compromised, normally the threat comes from the executive. And that is the reason why you have seen the way the standards are couched, because this office investigates the executive, and the executive is very, very powerful. So when we actually talk about that, we are talking about the executive posing a threat to the office of the ombudsman.
So then, just as a follow-up to that, my question is, Parliament, by following a process of accountability, is then not a threat to the independence of the ombudsman?
Normally, it is not envisaged that Parliament is the institution that is directed at in these standards. Normally, it is the executive which poses a threat to the independence of the ombudsman.
Okay. Are you aware of any such threats in South Africa to the independence of the public protector?
From
Parliament?
From Parliament, I wouldn't say that there has been any report of threat to the independence of the ombudsman from Parliament.
Okay. You spoke earlier of how judicial review of reports is an element of quality control over those reports. If the highest courts in a country, the Constitutional Court in South Africa, makes multiple findings of incompetence or ignorance of the law against the ombudsman, would you consider that to be grounds on which the individual could or should be removed from office?
You have said if there are several judgments
Yes.
against that person. Because as I said, the court process is actually a quality controlling. It's a cleansing of the office of the ombudsman. So if the mistakes are repetitive, then I think there would be the only conclusion would be that there is a need for a process of inquiry into that office to be commenced.
Okay, thank you. Yesterday, I think it was yesterday, it might have been today, Mr. Mpofu suggested that the findings of the courts were being, and his word was, transplanted into these proceedings, and therefore that Advocate Mkhwebane was not being protected by Parliament. Do you agree that these proceedings have to consider such findings as part of our deliberations into whether or not she is fit for office?
I would think that I haven't looked at, like I said, I haven't looked at your the charge sheet, but I would think that the process that has been started is sufficiently how should I say, self-auditing. And at each and every stage, you are ensuring that the principles of natural justice are being adhered to. So, of course, it's the first time. It's the first time that it's happening. But I think that should make everybody who is concerned in this process more careful in ensuring that they're adhering to the standards, the proper standards.
Okay, my last question. The protection of the Ombudsman by Parliament, does that refer, and I'm trying to understand here, you're referring to the protection of the office of the Ombudsman rather than the protection of the individual who occupies that office, is that correct?
We're referring to protection of the office of the Ombudsman.
Okay,
yes.
And then the kind of automatic follow on to that is, should Parliament then have the power to appoint and or remove an Ombudsman from office in specific circumstances and on specific grounds?
Actually, this is the reason why there's all these standards talk about security of tenure. They talk about the conditions of service should be like this and like that. Once you appoint an ombudsman, the process should be at such a, the vetting process should be at such a high level that you shouldn't expect that you're going to be changing ombudspersons every 2 years or every 3 years. Then that goes to it questions the independence and autonomy of that office. So,
okay,
yeah.
but that doesn't answer the question. The question was, should Parliament have the power to remove a person from the office of Ombudsman on specific grounds and in specific circumstances?
Yes, the standards agree with that. All the standards.
Okay, that's it. I'm happy. Thank you very much.
Thank you.
Thank you, Honorable Milam. Honorable Dana.
Thank you, Chair. Good evening, Ms. Sokoni, and thank you for your time. My questions have all been covered by the colleagues, but I just have one follow-up question with regards to one of the questions that Honorable Milam has asked, and that's with regards to the use of court judgments during these impeachment proceedings. And yesterday, the point was brought over by Advocate Mpofu that court judgments should actually not be used during these proceedings. So if we take...
Just a pause, Honorable Dana, you can switch off for now. Advocate Mpofu.
Yeah, well, Chairperson, Ms. Dana, we will know that I don't like to be misrepresented. I never said court judgments should not be used in these proceedings. I said, at least Mr. Milam, I think, put it better. I said that this process should not be used as a conduit pipe, simply to transplant a judgment and then use it without, without more as a an impeachment basis, because I then made the example. That would then mean that the complainant through the judiciary, through this process, is the same complaint that runs through. And the point I made, I think, to your party leader, you're from the FF plus, yes. I've made this point ad nauseum to Dr. Mulder, was that if we were to do what I'm saying should not be done, would simply transplant a judgment on the basis that it's binding and then just use it here. Then why are we having an inquiry? Because we should simply take the judgment. The judgment says, no, she's bad, she's this. Then we must just chop the head. Why are we wasting time here? Because an inquiry means you are inquiring into something. And that's the point, the only point I'm making. So you can ask the question on the basis of my correct position. Thank you. Or otherwise, don't ascribe it to a Mr. Mpofu. Just ask whatever you want to ask.
Thank you, Advocate Mpofu. Back to you, Honorable Dana.
Thank you, Chair. I apologize for paraphrasing, but thank you, Advocate Mpofu, for that explanation. So going back to transplanting judgments during these inquiry proceedings, and let me just mention there's a number of judgments being used during these inquiry proceedings. What else should this committee then rely on that is more reliable and duly considered judgments, in your opinion? And just as a side note, the party leader of the FF Plus is Dr. Groenewald, not Dr. Mulder. So I just want to assist.
They all look the same to me. Yeah.
You've not been given an opportunity to speak.
Well, he was addressing me. No, sorry, Chair. She was addressing me.
She was out of order, so you can't be out of order now. Thank you, Advocate Mpofu. Thank you, Honorable Dana. Ms. Sokoni, your response. Just ignore the missiles and fires. They're not coming to you.
Thank you so much, Honorable, for that question. I think from the onset, I should say, the reason why there is a flurry of judgments coming in is because the reports of the public protectors have got binding effect. So that is the point where I think I have a point of departure from the issue. If most of the charges are based on court judgments, my submission has been, I think if you've read my paper as well, my submission has been that binding decisions are disadvantageous to the office of the Ombudsman because they bring unnecessary attention to the office. And in the end, if there are a lot of judgments against that Ombudsman, then the Ombudsman, of course, will end up being disciplined. But where the Ombudsman issues recommendations, the report is submitted to Parliament, and Parliament can quality control it at that point. They can tell the Ombudsman, you haven't done this right, you haven't done that right, you haven't done that right, and send back the reports. So it gives a chance for the Ombudsman to actually hone their skills of ombudsmanship, and they don't want their reports to be sent back by Parliament. So I think that's the only concern we had, the main concern actually, that because the reports now have a binding effect, now the process that has come to this point where there is an inquiry by Parliament.
Thank you, Sokoni. Honorable Maneli.
Thank you, Honorable Chair. Greetings to honorable members, the public protector and the legal team. Greetings to you, Ms. Sokoni. Honorable Chair, through you, I think most of the questions I would have wanted to ask have been asked, but maybe it's just to follow up, just to check if my notes are correct. Maybe just to go back to the point of self-cleansing, quality assurance in terms of what should be the attitude to judicial review. In here, there is an opportunity for the public protector to report to portfolio committee in Parliament. Would you regard that also as part of that quality assurance or self-cleansing? As you would know that this one is an inquiry as opposed to the portfolio committee ordinarily where the public protector reports. So I just wanted to check if I am of the same understanding with you, that you'd regard that process of accountability where the members have an opportunity to also make recommendations to improve the work in the public protector's office. Thank you.
Thank you so much for that question, Honorable. If there is a provision that the public protector can submit reports to a special committee, I don't know whether these are special reports. I would think that is actually a very good thing, and it should be incorporated as a permanent measure, that any report that comes from the public protector, before it is released, it should go through a committee, because then they'll be able to ensure that the appropriate standards are in place before a report is released. And you can be able to tell the public protector, well, you didn't adhere to this standard or that standard in your reports. Thank you.
Chair, maybe just to correct this point, I'm not referring specifically to an investigation report, but I'm just talking to all reports, including what happens in the public protector's office, targets that they've set for themselves. In here, you would have those reported to the committee. That's what I was referring to, as to whether you also look at that as part of that self-cleansing, because whether there would have been a court judgment, let's say in a particular quarter, surely it would not escape the committee from reflecting on how they see the performance of that office and how it can improve on its work. So I was saying it in that context, Chair, just for purposes of action.
Oh, thank you so much. I understand it now. Yes, I would consider that that is an appropriate quality assurance intervention when reports reports regarding the performance of the office are tabled before a special committee.
If I may just then take this question then further, because as I said, it's already been asked, but for purposes of correcting my notes, just to be sure that you are firmly saying that if this continues or the errors are repeated and there are findings on those all the time, you have said it is not just a matter of misconduct to the incompetence or competence of the public protector's office. So I just wanted to be sure of what you were saying exactly.
Would you kindly repeat the question?
Through you, Chair, I'm just asking. You've responded to this question, but I couldn't hear it properly. where the self-cleansing does not yield results, you still have those errors repeatedly done over a period of time, and you'll have judgments or findings even by the highest court in the land. I didn't hear you. Were you saying you will consider this as misconduct, or it is sheer incompetence on the side of an ombudsperson or public protector?
I'm sorry to trouble you. Can you repeat the question again? I'm not getting it.
Okay, Chair, I'm not sure if I'm audible then, so that I know if it is the audibility or.
Yeah, you're audible. Maybe just repeat the question and Siakova, we can hear you.
Okay, so let me take it slowly then. I'm saying, I just want to know the word you've used here, because you've already answered the question. From the self-cleansing and quality assurance side, if these errors are repeated and that there are findings even by courts that there's repetition, I didn't hear you well there. Were you saying this would be misconduct or incompetence? That's what I wanted to get for purposes of my notes.
So if the mistakes are repeated, a judgment comes out and it's not in favor of the ombudsman, and then another report is issued and the same mistakes are made, and the ombudsman does not seem to correct those mistakes. If it's repeated, it goes towards the competence of that particular individual, because why should they not be able to correct themselves?
Okay, no, thanks, Chair. Still on that question, is it therefore your evidence, because you keep on coming to the binding and non-binding or recommendation, that we already have the binding recommendations of the public protector by a court decision? Is it your submission then that instead of holding the public protector accountable, we probably need to relook at the system and taking it back to a recommendation that is not really binding, so as to eliminate the litigation that happens instead of strengthening this part of the competence of a public protector? Thank you, Chair.
We have many ombudsman offices. In fact, the majority of ombudsman offices are operating by way of issuing reports which have the effects of recommendations the world over. And these offices, some of them are working very, very, very competently. They are issuing quality reports. And as I've said before, this has been a tried and trusted system. So even if the office of the ombudsman were to go back to issuing reports which have the effects of being recommendations, I don't think you would be losing out on anything as a nation. Simply because, as I said, that is the power of the office. The fact that the office holder can issue a report which contains recommendations, and you make the office holder unreachable from the normal threats or temptations which accrue to an office holder who issues reports which have a binding effect. Thank you.
Maybe just to complete this question, Chair, may I just ask again, there may be an argument that says when they are just recommendations, as it would have been the case before that court decision, those that need to implement the recommendations may ignore them, and therefore to try and force implementation, have it binding. There will also be another argument that says, look, the reason you'll have to have it binding, it's also about that authority that makes these recommendations to do everything possible to show competence in terms of investigations and the actual recommendations that get made at the end. So in that score, it's a balance between the two that show competence, because you've been appointed as a competent person who will make proper recommendations, but at the same time ensure that the executive does not undermine the recommendations, hence they would be binding. What would you say in such an argument that probably the system is correct? It's just about holding each other accountable other than changing the system because you fear litigation that may come all the time. Thank you, Chair.
The thing is, you cannot possibly foresee this type of investigations that an ombudsman has to investigate. You can't foresee them. And to say the system of binding decisions is better, it holds the ombudsman to a higher standard of accountability, and you ensure that the institutions adhere to the reports of the ombudsman. They don't adhere, they go to courts. They don't adhere, they go to courts. Whereas where the ombudsman issues a report with the effect of recommendations, if the respondent institution does not want to implement the report of the ombudsman can go to parliament, and ideally the report is supposed to be tabled before a committee. And that's just the way it works in the majority of jurisdictions. That's the way it works. And if the respondent institutions were not implementing the reports of ombudsmen who proceed by way of recommendations, the institution of the ombudsman would have died a long time ago, but it's still thriving. It's actually growing. Thank you.
Maybe my last question, Chair, on this matter again. So I'm still on that question, but that's my last question. I just wanted to check, because we've already agreed that this committee, it's an important step in handling the matter. But I just want to check with you whether I would have heard you correctly yesterday, that you seemed to suggest that there's still time to stop this process. So if that is what you were saying, I would really want to check that in the light of all these other judgments we've spoken to, in the light of a prima facie evidence put by an independent panel, whether if we were to go that route, is it in the public interest for Parliament to do so? And if you think that's the case, why? But if I would have heard you incorrectly, that you were not necessarily suggesting that by talking to going back to a recommendation approach than binding. Please correct me, and you therefore not need to answer the other questions, Chair. Thank you.
Thank you. According to the judgment, I think Advocate Bauer referred to the Nkandla judgment. She was reading where it stated that the remedial action reports of the public protector, the courts say, I think they used the word may be binding in certain cases. And I asked then who decides whether the reports, is it the public protector who says this is binding and this is not binding? And my view is that it must be decided. South Africa still has a chance to make up their minds, because if that report, if that judgment said, the judge said the remedial action reports of the public protector may be binding in certain cases, then it means that there's still an opportunity for actually the institution to be transformed into an institution where the Ombudsman reports have the effects of a mere recommendation. With regard to this process that is ongoing now, it is still a process. The inquiries are still going on, but our job, our main job here was to bring to the fore the international standards with regard to the operation of ombudsman offices. They are, of course, of persuasive value, but if that is taken into account, it will be up to the committee to decide how they can best ensure that they adhere to the dictates of the Constitution, but at the same time that there is procedural fairness in this matter.
Thank you. Honorable Bamisa. Honorable Olomisa.
Thank you, Chairperson. Can you hear me?
Yes,
So
yes.
we can hear you, yes. Olomisa.
Thank you, thank you. Thank you, Chairperson. Can you hear me?
Yes. So we can hear you, yes.
Thank you, colleagues. Thank you, Chairperson. Can you hear me? Colleagues.
Yes. So we can hear you, yes.
Colleagues and colleagues.
Imake mkhuluwa, inoba bakhona bavula izinto apha kuwe,
I'm okay now.
bazivale.
I can hear you, Chief. Honorable colleagues and Ms. Sokoni, thank you for your input and advices. I noted your advice regarding the behavior of the executive. Here in South Africa, the executive is part of the ruling party, a rather ruling party caucus, which takes decisions to protect one of theirs. We witnessed this behavior during the former public protector Thuli Madonsela's investigation where the ruling party closed ranks in trying to water down her findings on Kandla matter. They called her names such as spy, CIA agent, etc. Recently, witnessed the same behavior in the Justice Noble Panel Committee. So, the question I have is, can Parliament close its eyes and continue to waste money on a process like this when the courts have already declared that the public protector was suspended for asking questions about pala of president of the country? Lastly, you say the spouse of the complainant should ordinarily not sit in the committee and must also declare. Question is, must that declaration be done to Parliament or to the accused person? Then finally, many remedial action have been recommended by the public protector to state institutions, but no action is being taken to implement those findings. Who must be responsible or held responsible for not implementing those findings? For record, be informed that the public protector has also won some cases in courts in this country. Would you agree with me that you cannot only focus on lost cases only when you look at her competence? We've heard also that she has been running a clean audit report administration there. So I'm looking forward to hear from you, ma'am. Thank you.
The question on remedial action, the first one, could you repeat it for me, Honorable? The first question.
The first question I said, can Parliament close its eyes and continue to waste money on a process like this? When the courts have already declared that the PP was suspended for asking questions about pala of the President of the Republic. I don't know whether it's the part you missed, but that was the first question I asked. I gave you at the beginning.
Okay. With regard to the first question, as I said before, the process has already been commenced, and the particular decision that you are referring to, I've been given to understand that it's still an ongoing court process. I think there's been an appeal in that matter. So I don't think I'm qualified to comment on that particular matter. So the process has already been begun here in Parliament. So I think you have to just see it to its conclusion. But all we have to ensure, like I said, is to ensure that there is procedural fairness and that all parties are allowed to bring the evidence forward the way we are proceeding currently. with regard to the remedial action, you have said that the public protector issues reports, but the remedial action, I don't know whether their orders or recommendations are not being taken into account by respondent institutions. So could I ask, is it the reports that the remedial action reports that are of binding effect?
Here you will see in South Africa a public protector. Once she received a complaint from the public,
yes,
she attends to that, and then she recommends certain actions to be taken. 9 out of 10 times, over 40,000 of those cases have not been challenged. And the departments and SOEs who were asked to implement most of those complaints in order to serve the poor of the poorest. You don't see any implementation on the ground. Thank you.
So, so if the remedial action reports are not being implemented by the respondent institutions, because the reports are binding, then it would mean the public protector would have to take the matter to courts to enforce, to ensure that the respondent institution implements. So this is the problem with when there are issues of binding decisions. So the last question where you have stated that the public protector has won cases in the country. She has got a clean audit report, but these positive
are not highlighted.
The positive achievements are not being recognized. I believe it's by this committee. I would state that I would hope that since this process has already started, the evidence that you are talking about should be laid before this committee so that they can consider it. And I would hope that it would help in the quest for a just resolution of this matter. Thank you.
Thank you. Thank you, Ms. Sokoni. Thank you, Honorable Olomisa. Honorable Ngola.
Thank you very much, Chairperson. Ms. Sokoni, I think it is worth mentioning that we appreciate your testimony in this inquiry. We appreciate it moreover because from where we are seated, it actually helps us beyond this inquiry. It equally helps us to strengthen our ombudsman systems in the country. I hope that equally with yourselves in the international bodies of ombudsman, you are also learning some practices in terms of this inquiry and all the related matters. The Bonanum General Chof many chance your trailer.
Order.
That was on a lighter note.
Order is sustained.
Mr. Sokoni, have you been made aware of the charges leveled against the public protector South Africa?
Yes, I was given a chance to look at them. I think when initially I was preparing my statement, but I did not really study them. Yes.
Okay, make it much quicker. One of the charges leveled against the Public Protector of South Africa is a possible misconduct. Now, what I want to check is that what do the international principles and standards say in a case where a public protector may have possible misconducted her or himself in the course of performing their duties?
As I said before, the public protector is in a classical system is accountable to the legislature, and where the public protector is, or ombudsman, let me just say ombudsman, is supposed to have misconducted himself, there should be a process by which the legislature is able to conduct an inquiry into the conduct of the particular ombudsman. Also, it could be also law enforcement agencies that receive the reports. So where law enforcement agencies receive the reports, of course, criminal action can lie against criminal investigations, and actions can lie against that particular ombudsman. Yes.
So you regard this process as that accountability process that you're talking about?
I beg your pardon?
You say your answer is that the legislature must make that ombudsman accountable if there is a possible misconduct on her or his part. So you regard this process as that accountability system, that which must be unleashed if there is an allegation of an ombudsman who may have misconducted him or herself during the course of the performance of their duties.
Yes, but I still qualify it by stating that had the reports of the public protector had the effect of being mere recommendations, the public protector would not be sitting here for these hearings. Probably through the process of to and froing of sending reports and sending reports to Parliament, there would have been a quality controlling during the process.
Okay. For time purposes, Chair, I want to enter into how the rules define misconduct. Let me just pass other. I think a lot of ground has been covered, so I don't want to be repetitive. I think that leaves me with one last question. That last question is the issue of that in terms of South African law, the public protector South Africa is established in terms of the Constitution. And it is this Constitution that unequivocally providing that it's the supreme law of the country. Now, you have got this supreme law of the country that establishes the institution of the public protector in terms of Chapter 9. You have got this supreme law that establishes the process that must be followed in the event where there is a need that the holder of a public office may be removed.
Yes.
You have got all the international standards that you have eloquently tabled here.
Yes.
Now, in a legal point of view, Which one outweighs the other?
As I said before, the international standards that we have introduced before this committee are of persuasive value. I think the OR Tambo Declaration has is yet to be tabled before the African Union, but there are standards that we are using as a guide to ensure that proper ombudsman institutions are established in various countries, and also to help the ombudsman institutions which are facing threats, maybe administrative or maybe financial, to bring these standards to the attention of their governments. So there is no way that you can equate those standards to the law of the land, obviously. So the South African Constitution is supreme, it's the supreme law of the land. And this is the reason why, of course, this process is going on here. Thank you.
No further questions, Chair.
Thank you, Honorable Ngola. Honorable Lothrit. And then we conclude with Honorable Lagude.
Thank you so much, Chairperson, and good evening, everyone. Thank you, Ms. Sokone. I will be very brief. You did mention during your evidence that you were requested, or your organization was requested for an intervention. I would just like to know, in terms of positioning your evidence today as appearing as a witness for the public protector, does this relate to the actual request for the intervention that your organization had received? And when you received that request for an intervention, did your organization consider approaching the chairperson of this committee? Because you also stated today on a number of occasions that your aim is to assist this committee by doing a presentation on best practices of ombudsmanship. So did you or your organization at any point consider approaching the chairperson of the committee to make a representation or presentation to this committee to assist us so that we can do our job properly? Or was your only option to appear as a witness for the public protector? Thank you.
Thank you so much, Honorable, for that question. Initially, we had to come here as observers, and we wrote to this August committee to request if we could observe this hearing. And following that, the organization did ask me to provide expert witness evidence on ombudsmanship, just to introduce the concept of ombudsmanship, the international concept of ombudsmanship, and also the international standards of ombudsmanship. So the submission was made to this August committee and it was accepted. in the event that the committee would have felt that there was no need for any testimony from the African Ombudsman and Mediators Association, they would have informed us. But we are happy to have been of assistance to this committee if we gave any assistance. And we thank you for having allowed us to make this representation on behalf of the African Ombudsman and Mediators Association.
Thank you, Ms. Sokoni. You done, Honorable Lottridge. I now recognize Honorable Zagude.
Thank you very much, Honorable Chairperson. Good evening, colleagues and Public Protector and a team, Ms. Sokoni. Honorable Chairperson, lots of ground have been covered by my colleagues, but I have two questions. Ms. Sokoni, under the circumstances where the Public Protector contemplates on making remedial action without consulting or giving the affected parties an opportunity to comment on the reports, do you think this is in line with the laws of natural justice and the conduct expected of a public protector?
I have already stated that the principles of natural justice are our tools. Those are the tools of the trade. And as long as you actually stick to utilizing those principles and respecting those principles, I think you will not find yourself going wrong as an ombudsman.
Thank you for that response. Don't mind us asking it over and over again.
No problem.
We want to have an understanding as you are here to assist us with this process that we have embarked upon. So how do you make sure, or how do you ensure that the reports that are produced by your office can withstand the legal scrutiny, are good enough to withstand the legal scrutiny?
I had stated earlier on that we have a term that we use in our office that you must interrogate each and every witness. You must interrogate each and every document. And when you're writing the report, you must interrogate each and every finding, and you must interrogate each and every recommendation. It should stand up to the test of the principles of natural justice. You must have each and every witness that you have in the report must have been given an opportunity to present their case, and the people who sit with the public protector to hear the case, you must ensure that the people don't have an interest in the case. And once the report is prepared, all the parties who are involved in the case must have sight of the reports. And if the report is sent back and there are any corrections that have to be made, the report must be sent back again to the parties. They must have a look at that report.
Okay. As an ombudsman with long service in your country, how do you deal with backlogs in your office? Do you rush reports or you have other mechanisms in place to deal with backlogs?
Do we? What was the question again?
How do you deal with issues of backlogs in your
Yes.
office?
Yes.
Do you rush reports without them being quality, being sent for quality assurance, or you just release those reports?
That question is really, close to my heart. I actually, maybe I may even say I may be guilty of maladministration in that area, because I actually cannot release a report unless I am absolutely happy with that report. So we do have backlogs, but we can't compromise the quality of the reports simply because there are backlogs. We just have to ensure that we get the report right. We give the report sufficient scrutiny. It's just so important.
How do you deal with backlogs in your office?
The only way that we know possible, whether we have to work weekends, we have to work overtime, just to clear the backlogs. That is the only way that we can do it. But the report will not be released until we are happy and we are ready that it is of a proper quality.
Thank you very much, Honorable Ms. Sokoni. Honorable Chairperson, we have guests in our midst. I think there is something that we need to clarify so that when they get out of this meeting, they go out with the correct information. Because this is what we've been always dealing with as this committee. We are accused of being members of the ruling party, of which we are not apologetic about it. And what we discussed in our caucuses have got nothing to do with this inquiry. And no one in this parliament, in this our parliamentary environment, we are not using in South Africa, we don't have constituency system. We have parties which contest elections and they send their members according to their party lists to parliament. So all parties, all 14 parties represented in this parliament, their members take mandates from their political parties. Whether you agree with that mandate or not, all 14 parties give mandates to their political parties. So we cannot be accused of being members of the ruling party. So when it comes to defending the executive, I want to put it clear in this meeting that we embarked on this process because of a House resolution on a motion. Honorable Milam tried to bring that to light, that as this committee, we were established through the motion of the House, adopted in the House, and that a member of parliament in this country is allowed to bring in a substantive motion against a fellow member, against a member of the executive, or anyone else. So once that is embedded in our rules, which are in line with our constitution, hence we are here today. And on the judgment of the of that EFF versus the Speaker of the National Assembly
Chairperson.
with regard to
Was Honorable Dlakode, Advocate Mpofu.
Yeah, no, I want to object to this, apart from the fact that it's late. Members at this stage of the proceedings are allowed to ask questions, not to make speeches. Yeah, so can we get a question?
Thank you, Advocate Mpofu. You have concluded your questions with Ms. Sokoni, so wrap up your just the statement you're making.
Thank you very much, Honorable Chairperson. Okay, let me conclude by saying that, Honorable Chairperson, we are a committee of Parliament empowered by the Constitution and the rules of the House to do our work. And there is nothing wrong with us embarking in this process, We have not yet concluded. We have our mandate from our political party as the ruling party. Our mandate is to embark on a fact-finding mission so that we can recommend to the House, which is the National Assembly, for a decision. We are not yet there. Hence, you are here to assist us, and other witnesses are still to come. It doesn't mean that you're appearing before this committee, then we will conclude our work. We still have a long way to go. Thank you very much.
Thank you, Honorable.
Chairperson,
Thank you, Honorable Dlakode. That was the last member in the interaction with yourself as a witness. I will now take this opportunity and ask Advocate Mpofu for any last brief reactions or pick-up questions.
Yes, thank you, Chair. Can I start with the speech? All right. I'll drop the speech. I'll save it for the last. Thank you, Chair. Okay, let's start with dealing with the speech before I ask you what I was going to ask you. You know the difference between a fair process and a witch hunt, correct? Those terms.
Familiar with the terms?
Yes.
English.
A witch hunt versus a fair process. I'm saying you're familiar with those terms?
Yes, yes.
Yes, thank you. Right. Now, if what has been described to you in the speech that was just made now, that people will just take what we know as the party line, then is there a point in having an inquiry? In other words, if people will just express the view, not of the members who have been set here, but of their political parties, putting aside, assume there's no secret ballot, can that ever produce the views or the true conscience of the members, just in general?
What I would say, I actually wanted to respond to Honorable Malaule. Thank you for those comments. I think I've also labored to stress to this honorable committee that this process is ongoing, and there is no way that we as the African Ombudsman and Mediators Association can say that there has been no procedural fairness or the public protector has been treated unfairly. It's an ongoing process. So we also have to wait until the end. So without saying that I haven't answered the question, I will just say that I'm glad that she explained that you don't have constituencies here in South Africa, and you all represent 14 different parties. And I would just hope that in your proceedings, I did state that in the lost at sea case, the ombudsman there talked about the whip system, but I'll just hope and pray that you will each look at this case with your eye as of a legislator to ensure that there is justice at the end of the day. No, thank you so much.
Yes, now I can answer my question.
I would hope that the members of this August committee, as I said, that the members of this August committee vote as legislators and not as members of any political party, but just as legislators. I'm looking at this matter fairly.
Thank you. Yeah, well, okay, thank you. In fact, yeah, let me just ask you, I'll try to ask you one generic question, because I think from the questions that were put to you, it's clear both by the evidence leader and some of the members that your evidence is completely misunderstood. You've said this probably about 10 times when you were answering these questions, that if the rules of natural justice are being followed, if there is fairness in this process, if that, then the OR Tambo principles, for example, will have been adhered to. And I don't think anyone is hearing you. So, because of course, if all those things, that all the flaws that we have pointed to were not there, then we'd have a perfect system, wouldn't we?
Yes, if all the standards, ombudsman standards were being adhered to all over the world, it would be an ideal world for all ombudsmen.
Yes, we'll all live happily ever after. Yes, and let me then start the question by referring you to 2.3 of the OR Tambo principles, for example, the one that Honorable Heron read out to you. It says the process of removal shall be, in other words, this is a prescriptive clause, on the basis of just cause, and shall be fair, transparent, and regulated by the Constitution, and preferably involve independent body. So if I want to ask you a question, a silly question, then I must say to you, well, if the process is fair, transparent, regulated by the Constitution, and preferably involves an independent body, then of course, this 3.3 will be adhered to. Your answer can only be yes, correct?
Yes.
Yeah, but that's not, there's a difference between that, whether we have a good law and whether on the ground, as I put it earlier, actually those things are happening. And I think that's where you are being missed. So let me assist by asking it like this. And I'll use the OR Tambo Declaration as a yardstick. Now, so if there is a provision in the empowering provision, let's say for this committee, if there's a provision that the public protector must have full legal representation, that's a good thing, isn't it?
Yes, yes, it is.
Thanks. But if here on the ground, she is then told, no, you cannot have legal representation. Is that in conformity with the OR Tambo Declaration?
It would not be in conformity with even the laws. If you say that the laws or the rules state that she's not entitled to legal representation, and then it would touch on the OR Tambo.
Yes. So if, let's say, on 1 or 2 or 3 days, the committee continues without her legal representatives, in spite of that very good clause, then would that be in line with the OR Tambo principles?
Yes, Chair, I just need to know, if I may ask, when the public protector was denied public legal representation as being put by the advocate now?
Yes, thank you.
Yes, because that has not happened in this committee.
Okay, just pause there. My understanding is that he refers to the challenge we put up in the Western Cape High Court on our rules, that our rules were challenged by the public protector. And the two things that they challenged us on were on the issue of legal representation, initially the way we put it in the rules, as well as the involvement of the judge. I'm hoping that's what he's referring to.
I'm referring to both, but I'll answer your question as well. It's a very simple answer.
Okay.
You are right, Chair. That's where the whole thing, I just didn't want to trace it for the witness, but just to assist the honorable member from the ACDP.
I wanted to hold back, Honorable Sukas.
Dates? Okay, no, it's very simple.
Switch off.
Yeah, the dates, it's a simple thing. 13th September, maybe right, 1st November and 2nd November. If your question is when, that's when it happened. And I think you were here actually. Or are you saying, maybe did you see me here on the 1st of November?
There's a chair in this committee, Chair, is there a question to me?
Oh, okay. No, it's fine, Chair. Let's go. All right. So anyway, I was saying, ma'am, I was not even there, but let's assume this has never happened. That's what the word "if" means here. In case we don't understand it here. Now, if there is a provision that says there must be legal representation, and then say tomorrow, and I'm making this up, the chair says, no, African Pofu, you're not allowed to come here. I'm saying we must differentiate between the good law, which we all accept. So the provision that says there must be legal representation will be good law, we all agree. And that conforms with the OR Tambo principles, correct?
That is correct.
Yes, but if what's the scenario I'm taking, the chair locks me up in my car and for 2 days, then that is not in conformity with the OR Tambo principles, correct?
Yes.
Thanks. Let me take another example. The OR Tambo principle says the process must be fair, right? Fairness, you know, the rules of natural justice. Oh, sorry, Chair.
Yes. I had extended the process because we're about to wrap up.
Yes.
But I think can we have a 5-minute just stretch break and to assist the public protector as well.
Thank you, Chair. Okay.
We'll be back in 5 minutes, colleagues. Thank you.
Recording stopped.
Let's proceed, President Mpofu, and wrap up.
Thank you, Chair.
Over to you.
Thank you, Chair. I'm aware this is what they call the graveyard shift. Everyone wants to go, but that's because of the past few hours. All right. Now, Madam Sokoni, I've made that example of the legal representation. I'll go to another one. As I say, I'll make these examples and it will cover half of really your evidence, which I say has been misunderstood. Now, again, you know that the principles of natural justice, at least the ones that we all know, are two: audi alteram partem and the rule against bias, right? So again, as we do have in South Africa, if you have a rule, and that's the one the chair was talking about, so I'll talk about it in its good form. We have a rule that after it went to the Constitutional Court and so on, said, no, let's leave that because that also still relates to legal representation. If we have a rule that says that the process must be fair, it's our rule 129 AD. Okay, again, that's a good thing, isn't it?
That's correct.
But if on the ground, as I say, you have the situation that has been mapped out to you, where the spouse of the complainant is sitting in judgment of the public protector, forget the nice rule. If that is actually what's happening here, will that be in conformity with the OR Tambo Declaration?
I think I stated earlier on, and I will repeat that it represents a conflict of interest for that particular committee member.
Yeah.
They must declare that conflict of interest.
Yes.
Yes.
But I'm asking whether.
And it would not be in conformity, yes, with the principles of natural justice, because
Thank you.
you cannot be sure that the person will will be
Fairness.
fairly treated. Yes.
Thank you. Okay. Same thing. And again, I think Ms. Bauer told you about some story about, let's say it was a poor person who was a complainant, and that poor person, you remember that example? Yeah. Now, again, if the complainant, whether it's a member of parliament or a poor person or whatever, if the complainant is barred from coming to give their version of the complaint, is that in line with the OR Tambo Declaration?
No, it is not.
Thank you. And fourthly, if the JCC in your country and the independent panel in ours, that is what is known as the sifting mechanism, whichever body declares the prima facie stage, okay? And listen to me carefully. Let's say there are two charges who are in Zambia now. Two charges, and the one is for stealing this pair of glasses, the other one is for stealing this bottle of water. And the JCC in Zambia says, yes, there's prima facie evidence for the stealing of the water, but there's no prima facie evidence for the stealing of the glasses. Will it be fair if the inquiry says, well, we're still going to inquire on the one that did not pass the prima facie test? Would that be in line with the OR Tambo principles?
Well, that would defeat the need for the initial inquiry, obviously. The reason why the initial inquiry was held was to establish the charges which should go before the committee. Yes.
Exactly. All right, thank you. So it's no use to tell me that there are good principles if when we actually come and sit here, then all hell breaks loose. All right. And then, of course, we're also told that if a process is compliant with the rules of that country, or let me put it differently. Do you agree that it is possible for a process to be compliant with the rules of a particular country? But if the rules of that particular country are themselves not compliant with the international norms, then the process is unfair. And I'll give you an example. Apartheid was compliant with the rules of the country, but it was still unfair. So the technical compliance does not mean that something is fair in the objective sense. Would you agree?
Would you repeat the question?
Would you agree that if I say, okay, let's say there's a soccer field, and I say that the rules in this soccer field is that there'll be 10 players this side, and this side there'll be 2. And then the people there, they comply with that rule. But if that rule is in itself unfair, the compliance with that rule does not mean that the process is fair. You understand what I'm saying? In other words, if the law itself or the rule itself is unfair, or the process itself is unfair, the fact that it complies with the so-called rules of a particular country does not make it compliant with the objective standards of fairness.
Yes, maybe I can qualify that. I'll give the same example I gave earlier on, that the countries which whose reports have got a binding effect are in the minority. And the international standards require that an ombudsman should issue reports which have recommendations, not a binding effect.
Yeah.
So obviously, Zambia and South Africa are not compliant with international standards, and this may result in their institutions not operating.
That's an excellent example. That's an excellent example. In other words, Zambia and South Africa might comply with their domestic rules, but that does not mean that they comply with the international standards.
Yes.
Thank you. No, I think that covers that. Yeah. All right. And isn't that the whole point of having international norms? Because I think the fallacy here is that people think that if you have international norms, it means you must have uniformity. But that's not what international norms stand for. In other words, if you have 140 member countries, each one of them might have different rules. But the whole point of having international norms is that all those 140 things must then conform with the 3 binding principles: independence, fairness, or whatever, at a higher level rather than at the domestic level. Isn't that the whole idea of having treaties and UN charters and those kinds of things?
Yes, and I think that is the reason why it was so important for us to be given an opportunity to address this committee, just to make them aware. And I'm so glad that I think 1 or 2 of the members of the committee stated that they didn't even know that the Venice principles existed. So
yes,
I hope it will prove helpful.
Thank you. Well, yes, thanks. And I echo the words of those members, and we have correctly thanked you for effectively educating all of us about these international norms. And I don't know what to say. You'll forgive us for the people who still ask you whether what is the relevance of your evidence. There's nothing you can do about that. But no, that's true. Now, then, okay, I'm done with that, trying to explain what the compliance with international standards versus the actual situation on the ground. The second broad area, because I'm just trying to not to spend a lot of time, is another major misunderstanding. If you look at the thread of the questions, is around this question about what you remember the questions that you asked about. What if certain conduct is repeated? Right. Now I want you to picture two scenarios. If there's a scenario where the public protector genuinely believes that a certain procedure is correct, okay? And because of that belief, she repetitively, it doesn't matter, it could be 1,000,000 times, yeah, implements that that procedure, okay? And then at a particular point, the court says that that procedure is wrong, let's say, okay?
Yes, yes.
And then after all those 1,000,000 times that she did, she used that procedure, genuinely believing it to be correct. Is there any point in counting those times, whether there were 3 or 4 or 20, at the time when she believed that the process was correct? Like in your case, when you thought that that old legislation was actually the latest legislation. Can you impeach a person for that?
I think the best way of my answering that question is, had those actions taken place under remedial action recommendation, then they wouldn't be a subject of an inquiry here today.
Yes.
Because the reporting by way of recommendation has got a way of cleansing itself through submitting the reports to Parliament, and also at the same time when you submit to the respondents and the plaintiffs, because it is not binding, if they are not happy with the report, you can actually ask you to say, well, here can you review, here can you review. There's a continuous process of consultation before the report is finalized.
Right. Okay. Now contrast that situation with this example. So let's say then, after all that, then the matter goes to court and so on until the highest court in the land, right? The highest court in the land says, no, the procedure is not the one that you've been following genuinely or otherwise. It is this one, okay? That's the highest court in the land. Everyone would then agree. If after that, then the public protector goes back to her favorite, irrespective of what the court has said, we would all agree that that would be misconduct, correct? When the court has now pronounced clearly, doesn't matter whether you like this or not, but this is not what you should do. In other words, I'm contrasting a situation where the conduct is repeated after the court has declared, or when it's repeated before. Those are chalk and cheese, are they not?
I would best answer it again the way I answered it. The problem here really is just that the Public Protector South Africa is issuing binding decisions And it would not have been necessary to go through this whole court process or court procedure to the appellate court or to the final appellate court.
Okay. No, that's fine. I understand that. But we're here now. I thought the question that was asked to you was that and you said, well, in that case, you'd have to have a process. Yeah. So yeah, let's leave out whether it's binding or not binding or whatever. Maybe let me make a concrete example. There is a process which was covered in 3 of the cases that feature in this case.
Yeah.
That's the 2 Godan cases and the CR17 case. You may not be familiar with those. Okay. In that process, it is said the public protector and all her predecessors believed that you give, let's call it 1 Audi opportunity in a particular set of circumstances.
Yes.
Okay. And then there are obviously many cases where she did that. And it was going on in the court system. I'm saying to you, there are 2 situations. If after the court then says, okay, we don't care what your predecessors did or whatever, but you must now have 2 Audis.
Yes.
Then the public protector has no choice but to do that, isn't it?
Yes.
And if then she said, no, I don't care. The court says 2 Audis, but I still believe that it's 1 and continued in her old ways, then that would be wrong, wouldn't it?
Yes, it would.
Yes. And that's the point I'm making. The 2 situations seem to be conflated. So before the pronouncement of the court, it doesn't matter whether she did that 10 times or 100 times or 100,000 times.
Yes, because
at that point, at that point, she believed that this is how it is done.
That is correct.
Thank you. And there are many examples of this here. In one example, by the way, she was criticized for using a particular document or the handbook. Yes, using a ministerial handbook, a version of a ministerial handbook, which was not only used by all her predecessors, but was actually endorsed in the Nkandla judgment, or rather endorsed in the sense that it was used there, and the Constitutional Court found nothing to be wrong with it. So the question really is this: can you punish someone for doing something which she found, a practice that she found in the office, number 1, but also where she genuinely believes for that reason that this is the way to do it, as opposed to when she does it after the court has clarified it?
Yeah, this is why I said that it is in the practical implementation of the various rules and regulations that regulate this procedure that the committee has to bear its mind to. So, for example, if some of the charges that are before this committee concern past practice which has been carried on from one ombudsman to the other until she came into office, and then that practice now is believed to be wrong after a particular point, I think the office can be allowed a chance to change its practices, to be able to operate in the way that is recommended by the courts.
Thank you. And I think it's in that spirit that you've been telling us about what you've called a self-cleansing process.
Yes.
In other words, there should be learnings at the particular point. Once it's been declared, like anyone who's a Democrat, once it's been declared by a court in a constitutional democracy, that's it, whether you like it or not.
Yes, as I said, I'm sorry, I seem like to be repeating myself.
No problem.
In an instance where the the Ombudsman makes recommendations, they actually learn through the reports that they are writing and with the interaction from the respondent institutions, the constant interaction from the respondent institution and the complainants, as well as with Parliament. By the time the Ombudsman reaches the seventh year, that is when they're really getting really good at what they do. And they are able to hand over the baton to another Ombudsman.
Yeah. And maybe on a lighter note, well, it's not so light because it's quite serious. Just to go back to the examples I was given about, I was giving you about legal representation. If Parliament passes a rule that says you will not have full legal representation, and then the Constitutional Court says, no, you are wrong, Parliament. And thereafter, they still deny legal representation. Isn't that the second brand now, when you repeat something when you've now been told by the highest court in the land?
Yeah, definitely.
Oh. Thank you. All right. Now, the next point is I think I made this point when I was responding to Honorable Denner, but just for the sake of completion there. If indeed the judgments of the highest court were binding in the myopic sense, in the sense that they're just binding to everything, not just to lower courts. In other words, this committee, there's nothing it can do. The Constitutional Court has said that the public protector, or anybody for that matter, is guilty of this, A, B, C, D, E. And then this Parliament, there's nothing it can do about that. Would there be any point in holding an inquiry? Because what is it that you would be inquiring into? Because the judges have already found the person guilty. That's the first part of the question. Maybe let me ask you that, yeah. Would there be any point, would the inquiry be genuine if it was proceeding on the basis that those judgments are the law of Moses?
Could you rephrase the question?
Okay. If there was an inquiry, but it was proceeding on the basis that it is based on judgments that cannot be interrogated, would that be a genuine inquiry? In other words, the judgments are just, that's what they are. If they say today is the 24th of December, 1921, then we must accept that, even if we know that that's not so. Then is there a point of having an inquiry?
If the charges are based solely on court judgments, and I did state before that I was of the view that the personal cost awards to the public protector may have been over punitive. So if the charges are based on those court judgments, I would say that the public protector has already been punished, and it would be just doubly punishing the person to go through an inquiry of this type.
All right. All right. Okay, you were asked by Ms. Bauer about whether there has been a a process of impeachment of an ombudsman that went up to this stage or beyond, which you are aware of? And I think your answer was that you are not aware of. And you may or may not be aware of this, but I'll ask you, are you aware of the court case involving the removal of the ombudsman of Romania?
It has been brought to my attention. In Eastern Europe, there have been issues of ombuds officers under threat. I think there was an issue in Poland.
Yeah.
Yes. And yes, Romania. I think there have been a couple of other countries in Eastern Europe where ombudsman officers have been under threat.
Yes, thank you. Okay, the rules won't allow me to take you through to that in detail because I can't introduce it in re-examination. So we'll deal with it maybe when the public protector testifies. Yeah. So I'll only ask you peripheral questions around it if you are aware of it. Are you aware that in that case the impeachment of they call it there in Romania, I think they stole it from some political party here in South Africa. It's called the People's Advocate. The removal, or that's probably what it will be called in the future here as well. The removal of the People's Advocate in Romania by Parliament was reversed by the court. Were you aware of that? If you are, as I say, we won't get into the detail, but and it will be introduced differently to the committee. But are you aware of that? And that happened on the 6th of July, 2021.
Yes, I'm aware. Okay. I think why I didn't mention it was because she asked me if I was involved in any process.
Well, I think in fairness to Maladministration, she asked you if you were aware of any process. But if she asked you whether you were involved, then sorry about that. I thought she's wording. She was just asking if you were aware.
Gentleman Mpofu, can you please wrap up now?
Yes, sir. Right. Now, and to the extent, if you have read that judgment or not, can you confirm if you have read it? If you haven't read it, obviously, you then don't even have to answer the question. Can you confirm that one of the reasons or some of the yardsticks that were used by the court to reverse the impeachment? In other words, we had a situation where you had a process like this, and then it was taken to Parliament, the Parliament voted to impeach. And then the person, her name was Ms. Renate Weber, then took the process to court, and she succeeded because, among other things, that process did not conform to the Venice principles and these other international instruments. Are you aware of that?
No, I'm not aware.
You are not? Okay, fine. No, we'll deal with it differently. But Chair, just for as I say, I cannot introduce that case now. I've got it, but it will be introduced in a different manner. Thank you, Chair. Chair, the delay is because I'm eliminating, not because I'm adding. All right. Now, I'm just going back to that issue of the conflict of interest. You said that, I think this question was asked by me or by someone else, or it was asked by Honorable Holomisa. And because he asked like 5 questions, I think he didn't answer that question. So I want to just get what your answer is. It was about the disclosure of the interest or declaration. Remember, when he was telling you about if there's a spouse, he said basically something to the effect, sorry, that if, or that disclosure by the spouse, should it be to Parliament in general, or should it be to the person who is accused?
I would assume that if he makes a declaration to Parliament, it would be Parliament's duty to make the person who is cited aware.
Yes.
So all parties need to be made aware that there has been a declaration of interest.
Yes. Well, I don't know if you're familiar with the international cases, but if you are, if you're not, you just say so. But even our national cases, do you know that in that context, that duty to disclose is really intended so that the accused person can sometimes waive their rights and say, it's fine. So, and therefore, if that is the correct premise, can the person have an opportunity to waive their right if they don't know that there's a problem?
No.
Okay. Okay. Yeah, look, I'm aware that you are also flying out very early, so that's why I'm wrapping up, and the chair has already given me the first Audi. No, yeah, okay. Let's. I think we dealt with this in chief, but just for the sake of completion, Chair, sorry, please bear with me. The issue of, we were making this comparison with judges and the ombudsman. And again, I think you were misunderstood. What you are saying is not that an ombudsman is a judge, correct?
Yeah, that is correct.
You are simply saying that the status and the conditions and the independence, the protections should be similar, fairly similar.
Yes.
Yes, because you are not, if you were saying that it means that the public protector is a judge, then why would you have been appointed through a different process? You should have just walked into the court. The whole point of you being appointed and the JSC and so on is because you're not a judge.
Yes,
you just have the status of a judge.
That is correct.
Right. And the point about the protections is that judges, and that's why I'm saying I made this point, can have the most scathing judgments by a higher court against their judgment. But have you ever heard of a judge being impeached for having the wrong judgment, or make it worse, being asked to pay personal costs of the parties because the judgment is so outrageous? And that, have you ever heard of that?
No.
Yeah. And lastly, you said the principles of justice must not only bind those who deal with the ombudsman, but must also deal the ombudsman himself and herself in their own dealings, correct?
Yes, yes.
Now, well, and we know that the principles, one of the principles of natural justice is audi alteram partem, correct?
Yes.
Now, can a public protector then be impeached for giving people in her environment audi alteram partem letters? In other words, giving them a chance to explain. That's why it's called audi.
Yes.
Can you actually impeach her for that?
No.
Well, welcome to South Africa. Thank you very much, Chairperson.
Thank you, Advocate Mpofu. Ms. Sokoni, we have reached the end of our interaction with you. I want to invite you first to say your concluding remarks or last reflections. Anything you want to say to the committee?
Thank you so much, Chair. I think my parting words is just to say that the work of an ombudsman is not easy, and it's a job that you learn on the job as you go along. And I think the principle that Ombudsman institution issue reports which are backed by recommendations is meant to ensure, as I said, a self-cleansing process, but also a process of the ombudsman learning on the job. So in this particular instance, where, as Advocate Bauer pointed out to me, that the Nkandla judgment stated that the recommendations, the reports of the public protector, the recommendation, they may be either recommendations or they may be binding. So I would like to urge you to look at that particular standard from the international instruments that we have presented before you, and to also consider the issue that had these reports which were issued been had the effect of recommendations, perhaps this hearing would not have taken place. So I just urge you to take into consideration. I know the standards are just persuasive, but however, you can look at that issue when you're considering the case of the public protector. Thank you so much.
Thank you, Ms. Zulu-Sokoni. On behalf of this committee, I want to thank you for availing yourself before yesterday and in the last 2 days, and offer your contributions as part of this inquiry. We hope that your contributions are going to be helpful to the committee in its deliberations and the kind of recommendations and findings we will have. So thank you very much. You are now officially excused after 2 days, very long. Thank you. Travel safe.
Thank you so much, Chair, and thank you, honorable members.
Thank you.
Once you've done with your...
Yeah, but you're
your
disturbing me.
I'm sorry.
Disturb once you've done.
And I thought maybe you're still... Okay, can I...
Yeah,
okay.
yes.
No, you can finish, Chair.
No,
I'm
acknowledging you.
Okay, thank you, Chair. Sorry, I'm sorry. I thought you were done. I apologize. No, Chair, I wanted to raise some practical difficulty that I have about tomorrow. My next witness is in the air right now, traveling and only arriving but 10:30 or I'm sure arriving at midnight by the time he'll be in his hotel. And that I had hoped that he was going to arrive earlier, but the Secretariat has explained that it's a question of flights and so on. So I'm not blaming anyone. But the reality is that I need to consult with the person. It actually works against my own interest because I need to leave early as well tomorrow. So but my request is that I think it's not going to be possible to start at the normal time. Can we start either after tea or whatever? I'll start my consultations very early just to make sure that it doesn't waste the committee's time unnecessarily. But I do need sufficient time to consult, which I thought I would have this evening. Thank you, Chair.
Does that mean that that's going to be your first interaction with the witness?
My first?
Interaction with the witness.
My 10th interaction, but it doesn't matter. Whatever it is, I need to prepare the witness.
Okay. Well, given how the day went, even if the witness was here, you here now, you would not have met the witness. And so it's a matter of 2 hours between when he arrives and when so I'm going to ask you to try your best.
I will try my best, but my best
to do what you need to do with the witness, because the witness is already going to be landing in Cape Town. That's an expenditure, so which is not what you are asking for.
No.
And you have a bit of a dilemma, because if I were to grant an extra 30 minutes, you still want to leave early tomorrow.
So that part,
I want to leave that to you to see what you can do.
No, Chair,
because it seems that it's you who must sort out something more than us as a committee, because you in the beginning and the end you have got requests.
Yes. No, Chair, don't mind the second request about leaving early, because if it comes to a push and there's a need for re-examination, then one of my learned colleagues will do it. So that part, I was just saying, I wouldn't even be making the request because it works against my own interest.
Honorable members, is it fine if we start 10:30 or 11?
Yes, Chair, we can start at 11. It's fine.
11:30.
Okay, 11. Honorable Sukas.
I think the advocate say 10:30 is fine.
Come again?
I think I heard Advocate Mpofu say that 10:30 is fine.
10:30.
No,
okay.
You didn't hear me correctly.
Did I
think
not?
there's something wrong between where I sit and the people sitting that side.
I think so.
Yes. No, I was saying 11:30 after tea, as I know. I think it means 11:30, but that's my request. But if I'm given 11, I'll do my best as the chair says.
No, that's fine. Can we then? There are two things now, because we would want to make sure that we utilize any time that we have. So we will start the inquiry at 11. Honorable members, it would be good if we are here either at 10 or 10:30, so that we deal with the matter of the other witness who would have raised the correspondence with us after we had met and took a decision, finalize that, and that witness is Advocate Madonzel. So can we utilize that time as members of the committee tomorrow? Is 30 minutes fine, or should we start at 10? 10. Thank you. We are going to start at 10, and then you will join
I'll
us
be here after tea.
at 11. No, the time is 11, unless you want us to have tea at 11.
Thank you. Thank you.
So, honorable members will meet at 10. The inquiry starts at 11. Just to be clear on that.
Thank
Thank
you
you
so
very
much.
much. I think we have found each other
Yes,
halfway.
yes. Thank
Otherwise, that's not the answer. I'm going to Funai.
No, thanks. No, just for the sake, just for.
Thank you.
Recording stopped.